We are in the Zoom era, recording in progress. His influence on you as a teacher or colleague, most importantly, as a friend. His brilliant research in the fields of labor and employment law, human rights and legal theory, and his advocacy and commitment to workers across the globe. There is not an alum event that I've ever attended without a graduate practicing in the labor and employment field, singing Karl's praises and trumpeting his influence on their career. Our students adore Karl. He has been selected faculty speaker 5 times, and his classes are always in demand. Now the accolades. Karl came to Northeastern Law in 1976 as a lecturer and then joined our faculty as an associate professor in 1977. He went on to not only achieve tenure, but also was named Matthews Distinguished Professor of Law in 1993. He has been a senior Fulbright lecturer at the European University Institute in Italy, and he has been an extraordinary professor at the University of Pretoria, in addition to many distinguished lecturing positions at universities in the United States and abroad. He has received numerous awards, including a Guggenheim Fellowship. He is the author of seminal books and articles that have challenged our understanding of complex legal theories and brought nuanced scholarship to the fields of labor and employment law, social and economic rights, critical legal theory, human rights, and more. Today, we celebrate the remarkable career and accomplishments, Karl. Thanks to our planning committee for creating a marvelous event, Professors Jeremy Paul, Lucy Williams, and Libby Adler. Thanks to our staff for their work on this event, including Miel Marquis, Professor Giassi, Deborah Feldman, Siobhan Fanning, and thanks to our sponsors, Barnard, Icklison, and Lavitt, Leonard Carter, Paul Rome Edinburgh, Siegel Reutman, and Sunduli Grace. Now on to our first panel of the day. Thank you.
Welcome, everybody. My name is Lucy Williams. I'm on the faculty here. I can use this. Now can you? Now can you hear me? Great. I'm Lucy Williams. I'm on the faculty here. I know many of you. 13 years ago, Karl and I convened the International Social and Economic Rights Project, or ISERP, a project of NUSL's program on human rights in the global economy. ISERP is an international network of human rights advocates, legal academics, and judges, primarily from the global South, that studies the emerging global jurisprudence of social and economic rights from a critical perspective. Today, 5 members of ISERP have joined us for a fabulous panel on transformative constitutionalism. Not all of them were able to be here in person, primarily because of COVID. I'm not going to give lengthy introductions. You have their full bios in front of you at your seat and online. Please look at them to fully grasp the achievements and the real live impacts of this absolutely outstanding group of people. But let me just say a few words about them that may not be in their bios. The Honorable Dennis Davis, who is on Zoom, recently retired judge of the High Court of South Africa, was a valiant fighter for democracy and against apartheid during the dark years. He's the first person who invited Karl to South Africa over 30 years ago. Amaya Alves is a law professor at the University of Concepcion and a passionate advocate of human rights, particularly for indigenous people in Chile. She is involved in a project of historic significance as an elected member of the Constitutional Convention, now writing a new constitution for the Chilean people. Although she could not leave the convention to join us, we are so grateful that she prepared a video presentation for us today. Jayshree Sapute, who is also on Zoom, is an accomplished human rights lawyer in India and the founder of NASDAQ, a legal empowerment organization that works closely with Indigenous and Dalit women to advance human rights through a community-driven approach. The Guardian newspaper has designated Jayshree as one of the world's top 100 inspiring women. Frank Michaelman, who is with us today, retired Harvard professor, is an internationally renowned constitutional lawyer who has spent a lifetime developing constitutional theory based on the radical proposition that democracy, social and economic rights, and the abolition of poverty are mutually constitutive. His 1969 article, Protecting the Poor Through the 14th Amendment, has been a beacon for progressive lawyers in this country and around the world for more than half a century. Esteban Hoyos is the Dean of AFIT University School of Law in Medellin, Colombia. He's a leading human rights lawyer, and among his many achievements was his astonishing victory in the Colombian Constitutional Court that removed school fees for primary school children. In that case, he served both as the advocate and as the named plaintiff. So you can see we brought together an astonishing group of panelists to talk about transformative constitutionalism today. And I'm first going to turn it over to you, Dennis.
Thank you, Lucy. Let me just start off by, if I can, to thank the Dean and Jeremy Paul, Lucy Williams, and Libby Adler for this extraordinarily wonderful event in honor of Karl. It is utterly a reflection of this verstunkende COVID that, having got it just before I was supposed to travel, that in great sadness, I can't be with you today. Let me, in my 8 minutes, say the following. I first met Karl more than 30 years ago at a Law and Society conference in Amsterdam. But those of us who were South African progressive lawyers knew him well beforehand, because in particular, I recall very distinctly in 1989, my colleague, who at that point was junior to me, but became one of our very, very most distinguished Constitutional Court judges, Cato Regan, had come to me very excitedly with a little box full of materials. It turned out that she'd written to Professor Klare to ask him how he taught labor law and whether that might be of assistance to us. In typical Karl fashion, he had sent us a whole range of materials. We basically plowed into this like we were children in a candy store, but that had a huge influence on the way we then taught labor law the next few years. When Karl came to South Africa, together with Frank Michaelman, who I'm delighted to be sharing the panel with as well, to educate the then appointed newly appointed South African Constitutional Court judges, Karl prepared two talks, which eventually, in 1995 and 1996, which eventually was published in the South African Journal of Human Rights in 1998, called Transformative Constitutions. It was the first time that that particular concept had really hit the academic press, as it were. And in typical Karl's style, the only contribution that I ever made to it was to nag him to actually prepare these talks for publication, because in his typical style, he told me he didn't think they were worth very much. The truth about it is that that particular article is the most influential article that has ever been published about South African constitutional law to this day. And so in the 6.5 minutes left to me, which is hardly enough time to do justice to the entire debate, let me just make a couple of introductory remarks in honor of Karl. That article which essentially has pioneered the concept of transformative constitutionalism, essentially, amongst other things, said the following, that it described the South African Constitution as a transformative constitution because it said it was a long-term project of constitutional enactment, interpretation, and enforcement committed not in isolation, of course, but in an historical context of conducive political developments to transforming a country's political and social institutions and power relationships in a democratic, participatory, and egalitarian direction. Transformative constitutionalism connotes an enterprise of inducing large-scale social change through non-violent political processes grounded in law. Now, each of these words could be the subject of an entire discussion of its own. But briefly put, what Karl did for us in that particular article, which I've just simply extracted a definition, he essentially did two things. He, born of the critical legal realism, which he and Duncan Kennedy, who was also extremely influential in South African legal education, and I might add this to this day, and I'm sorry that I won't be able to say hello to him personally today, what they had brought as an insight and what Karl brought to bear in this enterprise to which I'm making reference was the idea that if law, as it had in South Africa, had shaped the social, the racist, sexist, authoritarian structure of South African society, and that everything in South Africa at that particular point in time had been meticulously shaped by the perverse legal system which we had for over 300 years of colonial and apartheid rule, the question which was posed was, could you flip it and could you argue that a different form of law, a progressive egalitarian law, could to some extent contribute to the reshaping of society in an egalitarian democratic way which would produce social justice for 60 million South Africans? And that was a really big challenge. And in a way, that particular set of insights concretized the enterprise with which we were engaged in South Africa at the time. But Karl had although he'd only been in South Africa for about 3 or 4 times before that, 95, 96, he also seemed to have an exquisitely nuanced view of our legal history, understanding fully that the independent trade union movement from the late 1970s had used law in a way to ensure that through political struggle buttressed by law, the trade union movement could claw from this repressive regime a series of rights to strike, organize collective bargaining, as it were, so that even though apartheid continued, industrial citizenship for the vast majority of workers was ultimately available by the late 80s. So the notion that law could perform, coupled with significant political activity, could perform a role in large-scale social engineering towards an egalitarian society, to use the words of the Constitution, based on dignity, equality, and freedom for all. That was what Karl was posing to us as a challenge. He also made, I think, 2 points, one of which I've already made, which is the need for a kind of progressive politics, which, absent of which, law on its own was never going to do the job, as it were. And secondly, he raised the very important issue of a myopic, formalistic legal culture which dominated South African society, and which, in his view, unless it could be brought into congruence with the egalitarian objectives of the Constitution, would itself create a major problem. And in fact, he's been right about both, because to a large extent, the African National Congress government of since 1994 has desperately let the country down. Inequality has increased. Rent seeking, now for a perhaps slightly larger but nonetheless elite group, continues apace as does state capture at the expense of 60 million people, many of whom shamefully, and I say this with a great deal of sadness, continue to live on the margins. And so therefore, the idea that the politics of South Africa would ultimately come to as it were, be central to this transformative constitutional enterprise has not been the case. And it's therefore, and it's also true, that the legal culture in South Africa, some glorious exceptions notwithstanding, which include some very profound judgments, particularly by the earlier Constitutional Court, the legal culture remains a conservative one. It is fascinating to me that when interviews are taken for the highest judicial office in South Africa, transformative constitutionalism is always trotted out, but as a war cry, rather than as a substantive plan for the long-term reconstruction of South African society. And so we have reached the point now where there are significant criticisms of transformative constitutionalism, and particularly from those who, to some extent, have gone back and looked at the work of people like Frans Fanon and Stephen Biko, the legendary South African activist, and suggested that the South African Constitution, even with its transformative gloss, is no more than a liberal instrument which to a large degree reproduces the status quo rather than engineers or at least contributes to the large-scale transformation of South African society. Time does not allow me to say much about this, save for 2 points. I remain convinced that the vast majority of South Africans don't share that critique. Secondly, it is not the challenge that Karl posed to us in relation to transformative constitutionalism where the fault lies. The fault lies with a shocking politics of a, in many ways, neoliberal kind, and in fact, even worse than that, a kind that to a large degree never embraced the real spirit, purport, and objects of transformative constitutionalism. And as a result of which, I can well understand why people are angry with the constitutional project which was launched in 1994. But the truth be told, that particular project, through the way in which Karl sought to interpret the text, has never been an obstacle to large-scale social and economic change in South Africa. To the contrary, it is the government, it is politics that has failed us in this particular regard. And to the extent that there have been gains, and there have been gains in areas of medical care and education and so on and so forth, many of these have been procured by very, very fine litigation strategies employed by non-governmental organizations who truly have embraced the challenges that Karl posed for us in 1996. And therefore, because my time is up, let me say one final thing. It is in South Africa today, we are having a debate about this. And perhaps the important point is that the debate is still framed around this idea of the merits or demerits of transformative constitution. How extraordinary it is for me, a South African academic, to think that an article penned by an academic at Northeastern University in Boston in 1995 and 1996, to this day, remains the defining framework for us debating these questions. That is an incredible tribute to Karl, which is why it seems to me alone he's deserving of the event that we have today. And to end, therefore, it seems to me it's not transformative constitutionalism that has let down 60 million South Africans. It is not transformative constitutionalism which continues as which has contributed to the continuation of the degrading lives which are the daily reality of most of my countrymen and countrywomen. To the contrary, it is the politics of this country, the governance of the country, which has let down the objects of transformative constitutionalism the way Karl envisaged it when he wrote this more than 25 years ago. Karl, it is a great tribute to you that you made that contribution. It's an enormous contribution to South African legal culture. It is the most single important contribution of an academic kind that has been made, and that is the least of the tributes that I can pay to you.
Thank you so much, Dennis. And now we will have the video from Amaya from Chile.
Hello, everyone. My name is Amaya Alves. I'm a law professor at the Universidad de Concepción in Chile, and currently I'm working on the Constitutional Assembly, on the Constituent Assembly in Chile, drafting a new constitution. I was elected in 2021, and we will be developing our work up until July 2022. That's why I couldn't be in person with Karl, Lucy, and all the marvelous and fantastic ISER people and researchers. And I wish I really could be there with you, but I hope soon enough we will be able to spend time together. More than 20 years ago, Karl coined the expression transformative constitutionalism to capture the spirit of the new post-apartheid South African constitution. We still remember and use Karl's term. Actually, I posted in a newspaper in Chile, and I call it transformative constitutionalism as a question mark for Chile. Today, although in a different period and continent, the constitutional moment in Chile might be described using Karl's terminology. Let me emphasize three aspects of Karl's argument that they foregrounded decades ago when writing about transformative constitutionalism, and that have special relevance today when thinking about the current constitutional process in Chile. First, constitutional transformative constitutions are classic, the social democratic constitutions. Second, at the same time, these constitutions go beyond the classical social democratic model, including new values regarding indigenous peoples, the environment, culture, or gender. Finally, much of Karl Klare article on transformative constitutionalism was a warning about the tensions between the values enshrined in the new constitution and the traditional formalist legal culture that could forestall the constitutional potential. Let me start with the first point. The constitution had emerged in Global South at the end of the Cold War, where post-liberal constitutions departed from the 19th century model of minimal constitutions limited to the recognition of formal equality under the law and negative rights, that is, civil and political rights. Not only South Africa, but also Colombia, Kenya, and more recently Ecuador, Bolivia, or Nepal enacted constitutions resembling the European continental welfare state tradition. This social democratic constitution placed formal equality and social justice as the center. We may think about this as transformative constitutions, as they have sought to bring about social justice, respecting the rights and guarantees imposed by the rule of law. In this sense, from South Africa on, but recognizing the Mexican or the Brazilian constitution as previous and very important milestones, the recognition of justiciable social economic rights is at the center of the constitutional tradition of the Global South. Chile comes late, but under the current constitutional moment will enter with force to this trend. The Chilean constitutional tradition was violently interrupted in 1973 when a coup d'etat that put an end not only to the democratically elected government of Salvador Allende, but also to the constitution that had ruled the country since 1925. In 1980, the dictatorship passed a constitution that was both authoritarian and neoliberal. While Chile was part of the democratization wave that followed the end of the Cold War world, unlike South Africa and Colombia, our transition to democracy did not entail constitutional change. Although many times amended, we still live under the constitution passed by the dictatorship, which has not just symbolic relevance. Ours is a neoliberal constitution that does not recognize justiciable social rights as positive rights. Even those recognized, like education or health, are refashioned as rights to choose in a private system for the rich and an underfunded system for the poor. One of the central demands of the social uprising that gave way to the constitutional momentum was the recognition of social and economic rights. At the moment, we see our country updating the list of constitutional rights, which will probably subject to justiciability. However, most constitutions enacted in the Global South during the last 3 decades have not simply replicated the social democratic constitutional model. They have, moreover, responded to the particular challenges derived from the colonial past, as well to new values that define the demands for justice of the newer generations. On the one hand, this constitution responds to the historical demands of indigenous peoples. In this, Chile will be the latest example of constitutional making that faces the injustice of the past. In the Constitutional Convention, special seats for representatives of indigenous peoples were created. The elected constituents have played a crucial role. The first president of the convention was a prominent intellectual member of the Mapuche people, the largest indigenous group in Chile. The constitutional text so far has recognized the multicultural and multinational nature of our political community, as well as the territorial autonomy of indigenous people, including prior and informed consent as a constitutional right. On the other hand, the Chilean constitutional process is also an example of the transformative constitutionalism that could include new values and new rights. This started with the election of the constituents and the functioning of the convention that has adopted a gender parity as a strict rule. Issues of gender and reproductive rights has been debated, including a norm that could enable legislation on abortion, as well as LGBTQ rights. Work and deliberation has not been easy. Rules has to pass with a 3/3 quorum. That means 103 conventionals out of 154, which requires hard negotiation and consensus building. Here, one of the challenges we have faced may also be understood and examined in light of Karl's exploration of transformative constitutionalism. One of the many insights of this article is his discussion of the tension between a formalist understanding of the law and the transformative goals of the new constitution. We are facing similar challenges. When we propose new mechanisms to share power, what Roberto Gargarella calls the democratization of the constitution engine room, we opponents argue from received understanding of law as one and unitary. As we want to open up norm-making to subnational political unities like regions and local government, and as we want that normative processes to be subjected to civil participation, we see calls to preserve the unity of the law as expression of the will of central political bodies. Call to preserve legislative unity that invoke the conceptual integrity of the law are offered as technical opinions that reflects legal scientific necessities. We see them as values defenses of the vested interests of the dominant groups that has thus far prevented constitutional and political transformation. We have learned from Karl to call the debate for what it is, as controversy over two political approaches, conservative and transformative, that we should not cover with a legal cloud of misplaced objectivity. We are in the middle of the battle. We can't see we will prevail, Karl. We are really fighting towards a constitution that could transform political debate and political distribution of power. I really hope that next time we see each other, I can tell you that we have prevailed. But up until now, I wish you all the best, and I really hope you will keep all your positive vibes with us. We really need the support of all the academics and all the political positive energy that you could send us to Chile. So goodbye. I really hope to see you soon, guys.
Now we'll go to Delhi, India, and Jayshree.
Hello, everyone. Good morning. There's almost good night, so good evening from Delhi. Karl, I'm so sorry. I tried my level best, couldn't be there. Would have loved to do this in person. Lucy and all other organizers, I really thank you for putting this event together. I saw that how much of effort it went into making this happen, especially during the times of pandemic. I also feel it's a matter of honor to be on panel today and to be given an opportunity to speak about Karl and Karl's work. I would jump right into it. I just want to say one thing is also over last 10 years of me knowing Karl, he has really acted as a mentor and a guide through the journey of Nazdeek and through journey of me being a lawyer, and that too coming up as a labor lawyer. So Karl's work has been really guiding principle for us, and also in-person guidance for pre-pandemic universe. It was great to kind of like, bounce of ideas with Karl and to get his inputs and see where we could really incorporate the concepts of constitutionalism, transformative constitutionalism into the practice, and how it can play out in this different facets of our work. Just to give you a little background of what's been happening in this part of the world, from the labor law context, is the Indian labor law regime is in process of unprecedented overhaul. In 2019, the Code of Wages was enacted, followed in 2020 by the Code of Social Security, the Industrial Relation Codes, and the Occupational Health and Working Conditions Code came later. These four codes together set off to repeal and replace 29 existing labor laws. And mind you, all this was done during pandemic with no consultation with people and no consultation with the workers themselves, and very, very limited consultation with unions themselves. Even national union and state level unions was just not aware of all the changes which were happening. While these four codes have been passed by the Parliament of India, they're yet not in force. Because there are several states in India who have already gone ahead and formed rules under these codes, and other states are still kind of like, trying to grapple with whether they still want to continue engaging with the old laws or they want to adopt the new codes. For decades, unions and organizations like us had gone on field to workers to simplify these laws, especially laws which are directly applicable and impacts the lives of workers. For example, pension, gratuity, laws relating to maternal benefit, laws relating to wages, unionization, and specifically laws relating to plantations where it comes to the tea plantations of Assam. We all are aware of Assam black tea. In Assam, the tea industry is the largest private sector employer with 60% or over 60% of its workforce is women, and the population is largely illiterate, malnourished. There's a high rate of maternal mortality, infant mortality, and these plantations were started in colonial era. Just a little bit of background. But these changes of law make big impacts in their lives while they were not aware of the older laws, and the unions and organizations like us had put together a lot of effort, time in simplifying the laws and communicating so that workers can then agitate those laws either through administrative channels, through labor commissioners, or through the courts themselves if the administrative channels do not work out. But this shift had been not communicated to workers at all. Overnight, the rules within these laws were framed and published by the state government. Again, it's mandated by law that whenever any legislation is being published, it has to be published both in English and a regional language. When it comes to Assam, the rules were only published in English, and non-availability of these laws or rules in any other regional language acts as a major barrier. While conducting advocacy with the government had clearly mentioned that, it might be very difficult to translate these laws in the regional language, but unless there's a regional translation in these regional language, it becomes very difficult to interpret really what the lawmakers intended from one language to another without compromising the essence or ethos of it. So what Nazdik has been predominantly now engaging has been in really bringing out comparison between old laws and new laws, how new laws would impact the rights of workers. For example, unionization. Unionization will change significantly under new laws, because there is now something called negotiating union. So only one union, which is a majority membership in any sector, would be entitled to negotiate with the employers. While now, if there are 10 unions, no matter how much their memberships are, they have some say in the matter of wages, in the matter of bonus, in matters of leave, and what other benefits workers get. But that is soon going to change. How you go out and strike, and how you have to give 2 weeks prior notice to the employer before going on the strike. Now, is making strike itself illegal, or how that would translate in real world, we are awaiting to see. During COVID times, our courts were mostly Supreme Court was closed for the times. It is just there were online hearings happening, and then there were some hybrid hearings happening. The court fully reopened just on 4th of April. Various high courts were also limited functioning. So the burden, the cases, which the pendency, which India is already notorious for, has gone significantly high. Very, very critical, important human rights cases. My own cases have not seen light of the day for last 2.5 years, and I don't expect them to be coming up anytime soon. In these times, the administrative grievance mechanisms has been very helpful in ensuring at least the impacted communities has direct say, and get some sort of redressal, while the courts have has become even more exclusionary. That's why we just see how the shift in just not relying only on the high courts, the Supreme Courts, when we talk about human rights, but really kind of also looking at what administrative grievance mechanism there are, and seeing them as the as an entry point towards the justice system. We also have seen a major shift in how the constitutional rights have been interpreted by courts in last few years, particularly right to housing. There are many decisions which have come out of the Supreme Court in past few months, in last year as well, on interpreting the right to housing. There was a massive demolition which happened in Delhi, in Khoregaon. There's a judgment on Gujarat railway case, where the court have clearly said that there is a epidemic of poor coming to the cities, and how the cities transfers because of poor and poverty. I lost track of time. So is there a way of knowing how much I have?
You have a couple more minutes, Jayshree.
Okay. So I just wanted to bring in, like, our history, where there has been cases like PUCL versus Union of India, which upheld, which talked about right to food and really brought in right to food in purview of Article 21 of the Constitution of India, which is right to life. Then the decision of Lakshmi Mandal, which really kind of like talked about how surviving childbirth and pregnancy is a fundamental right, and several other decisions which on housing rights, Sudama Singh versus Union of India, which brought sort of meaningful engagement and we from this South African jurisprudence. But now we are seeing the way these decisions are being interpreted further, or in the decisions of the court in newer cases, and how the interpretation of right to life and fundamental life and its application is very concerning. I would really want to take this opportunity to also acknowledge Karl's contribution and how we still look up to his work, and his work is still a guiding principle. And we, through the field work and engaging with people, are really trying to see how these concepts could translate in a transformation from a bottom-up approach, and how if these concepts are communicated and broken down to beneficiaries themselves, how the approach to human rights discourse could transform. So Karl, really honored to be here on this panel. Miss being there in person, but I'm there in spirit, and really happy to be part of this celebration. Thank you.
Thank you so much, Jayashree, and we'll be getting back to you in a few minutes. So now Esteban and Frank, if you can come to the front. And Frank, we'll turn it over to you. And make sure you hold the microphone close to your, yeah, you do it. Hold it close to your mouth, because otherwise people won't hear you.
Okay, I'll do the best I can with this. It's really a joy for me to be here this morning doing this. But look around at our panel. You have to remember who is up there in front of you and who's sitting here in front of you. Now look at the panel. Look who's on it. Where we come from. We are stand-ins for a wide world of engagements with constitutional democracy, and it's as such that we pay honor to Karl for his hugely influential idea, Transformative Constitutionalism, or TC, as I'm going to refer to it in short. But ask yourselves, is this TC idea actually one of interest to every country in the world? How about to us here in the United States? Lucy, our chair, my friend, has thought that that would be a good question for me to try to address, and I will try. And I'm going to start by suggesting that the Clarion idea of TC is actually a threefold construction. It's an upshot from three intersecting lines of thought. And you should think about the United States as I now put these lines before you one by one. So here's the first. Say you've got a society that's embarked on a project of radical transformation, radical upheaval from a condition, say, of racialist oligarchic domination to one of universal liberation and inclusion. And the thought is that you could place major reliance for that project's pursuit on a device of legalism, a law called the Constitution, installed as a part of the country's body of positive legislation. That's the first idea. And then the second and complementary idea is that of a newfangled ideal type for legal constitutions, post-liberal, in Karl's phrase, to stand alongside such old line types as classical liberal, socialist, social democratic, and the like. And then the third component of the TC construction, we have the repudiation of formalistic approaches to applications of constitutional law. This for Karl is absolutely crucial, the linchpin for the whole. I mean, here is Karl Klare coming out of CLS. The idea that you could effectively pursue a project of emancipatory social upheaval through a device of positive legality must initially have come to Karl as something of a challenge. And if, as did happen, Karl would come to see a case for that in the particular situation of South Africa in the 1980s and 90s, that could only possibly be the stipulation for a shift in the country's prevailing legal culture from a formalist to what I'll call a pragmatist mindset. And behold then the upshot of all of this, the union of these three intersecting lines of thought, the emergence of Karl Klare as a major late contributor to the broad historical constitutional democratic tradition. Okay, but now what could be the relevance of all of that to constitution-focused debates in the here and now United States? I'll take it piece by piece, and I'll start in the middle with the post-liberal constitutional ideal type that Karl has put on the table. In Karl's classification, the post-liberal type stands in many ways opposite to the classical liberal type, and I have took us through some of this. It stands opposite to the classical liberal type that Karl tends to associate with us. The post-liberal rejects the classical type's restrictions on direct popular politics, its fancy of a private sphere beyond the reach of law, its blindness to structural inequality, its anti-redistributive fetish of property rights, its refusal of state-protected duties and socioeconomic rights. Now, here's Frank. Actually, not a single one of those issues is missing from long-standing, ongoing, highly energetic American constitutional debates. The difference from Karl is that we here who contest these issues from the left don't always or mainly do so in categories of liberal versus post-liberal, maybe with some implication of not liberal. Some of us, rather see this as a fight over the best understanding of this country's undoubted liberal heritage and the implication of that for policies bearing on a host of issues in regard to non-discrimination, inclusion, privacy, political economy, and others. So one might say that Karl's post-liberal does indeed figure in the US as an active fighting stance only under a banner in which the syllable post is replaced by the syllable true. This is a topic of an ongoing conversation between Karl and me. But now come back to the first idea in the TC construction. That is the idea of looking to a positive law, a legal constitution, as your leading instrument of societal transformation. Does any such idea as that now have, or has it ever had a purchase here? Well, maybe once upon a time in the 18th century it did, but that surely is not how most Americans view our Constitution today. Rather, to the contrary, our overwhelming tendency is to treat the Constitution as an original social contract made long ago, but somehow become binding across generations. Thus, not as forward-looking, visionary, but rather as rearward-looking, restorative. I'm going to give you an example from the left, not the right. For those of you who might know it, the recent wonderful book of Jamie Fishel and Willie Forbath called The Anti-Oligarchy Constitution. Jamie and Willie, in pursuit of leftist redistributive aims, employ the method of history. They urge readers toward an understanding of our Constitution as having always been, from the very start, not classical liberal in Karl's sense of the term, but to the contrary, egalitarian and counter-oligarchical post-liberal in Karl's classification. They see that original Constitution's restoration to a place of high influence in our politics as a key to getting where we ought to be. We'll place that beside Karl's conception of the liberationist Constitution as transformative, meaning as permanently forward-looking, permanently visionary, always a project waiting to be fulfilled, never done, never possibly done. Americans today, I would say, could badly use a large infusion of that breath of the spirit of the laws, post, not past. Now, the relevance to us of the third piece, the critique of formalist constitutional interpretation, follows on from what I've just been saying. Yes, we Americans, we're all legal realists now. We're all awash in legal realism's aftermath. And yes, our judicial pragmatists are alive and they are vocal. But you know, we have our formalist tending jurists too. And they are not at the moment exactly a repressed faction in our judiciary. At the moment, the formalist tendency here would appear to gather mainly on the right, and mainly to be marching hand in glove with a yearning, a restorative yearning toward American original constitutional foundations, as seen from the right. Now, Karl, in his writings on TC, is careful not to say that formalists must inevitably come to right-leaning conservative. The specific history in South Africa tells him otherwise. But Karl does also quite cogently suggest that conservative is how the formalist profession of dedication to a law fenced off from considerations of politics usually will work out to legitimate, as he says, the status quo. That critique and the reasons behind it were fashioned for the case of South Africa in transition, but they surely do not have relevance for Americans today. So there, you see, maybe stretching a point a little bit here and there is my answer to your question. Yes, we should pay attention, and thank you.
Thank you so much, Frank. You exceeded my expectations by a mile. So last but not least, Esteban, thank you so much.
Thank you. Okay, so good morning. I'm very excited to be here this morning celebrating Karl Klare's life and academic career. As I have said in other places, Karl is for me a role model as a person, as an academic, and as a human rights advocate. I've been honored by his friendship and his generosity for more than a decade as a member of the ISER network, a group of lawyers, academics, advocates, and judges committed to the defense of the rule of law and the enforcement of social and economic rights around the world. Thank you, Karl, for your friendship, your lessons, your sense of humor, and for many nights and conversation with a glass of wine, I would say more than one glass, in at least 7 cities and 3 continents around the globe, including my hometown, Medellin, in 2017. And thank you, Lucy, for leading together with Karl our network during these years. We are thrilled and honored with your friendship, your leadership, and your work. And thank you for making possible these panels with my fellow friends, Frank, Dennis, Jayshree, Amaya. And thank you especially for making possible to open up this event with people like me who speak English with an accent. No Frank, of course. Which actually shows Karl's truly influence around the world. In the 7 minutes I have left, I have the challenge to talk about transformative constitutionalism in Colombia in the last 30 years. Last year, the Colombian Constitution of 1991 turned 30 years old. And this year, our constitutional court, our famous, world famous constitutional court is also becoming 30 years old. Of course, I cannot do that balance in 7 minutes. However, I can focus on a concrete matter from which we have learned so much from Karl, the adjudication of social and economic rights. For this, I follow a recent publication by another good friend of Karl, Lucy, and myself, an ICER member, Professor Natalia Angel Cabo, who this week, just on Monday, was sworn in as a new justice of the Colombian Constitutional Court. Natalia's arrival to the court is a guarantee that the work of the Constitutional Court on economic and social rights will continue for the foreseeable future. In general, the balance of the court's work on economic and social rights is very positive. However, this doesn't mean that it doesn't have some important challenges ahead. As positive aspects, we can highlight the early commitment of the Colombian Constitutional Court back in the 1990s with the possibility that economic and social rights could be protected through the tutela petition. Acción de tutela is a judicial mechanism that the 1991 Colombian Constitution provided for the protection of fundamental rights. This was only possible with an extensive interpretation of the Estado Social de Derecho, or our social state of law clause contained in our Constitution, but also with the development of the doctrine of conexidad, that allowed the court to protect non-fundamental social rights when the plaintiffs proved that the violation of a social right also implied the violation of a fundamental right. This allowed, for example, the early protection of the right to health because of its connection with the right to life. The right to health initially had not been included as a fundamental right in the 1991 Constitution. During these initial years of the jurisprudence of the Colombian Constitutional Court, it was also essential to recognize, to acknowledge the right to a minimum subsistence level, o derecho al mínimo vital. This is not a minimum core of our right, but the jurisprudential recognition of an autonomous fundamental right to have minimum subsistence conditions that can be protected through the tutela petition. Also, in this period, the court introduced the notion of the unconstitutional state of affairs, the estado de cosas inconstitucional. This is a novel notion that allowed the court to declare the massive and generalized violation of several constitutional rights, affecting a significant number of people, giving prolonged omission of the authorities in the fulfillment of their obligations to guarantee their rights. The notion allowed the court to give orders and issue remedies addressed to the institutions responsible for ensuring the protection of rights. The court has declared the unconstitutional state of affairs, for example, regarding the situation of the penitentiary and prison system, the pension system, and with regard to the situation of the rights of the internally displaced population in Colombia. As Natalia rightly points out, the court's rich jurisprudence evolves day by day and is built by responding to criticism and comments on the jurisprudence of the previous period. A more major court in the early 2000s is the one that issued two of the most well-known rulings of the Colombian Constitutional Court worldwide, the ruling on forced displacement, the IDP case, and the ruling on the right to health. These are two structural decisions, to a structural judgment that adopt complex remedies and orders to many state institutions in charge of protecting economic and social rights. I have no time this morning to discuss in detail these decisions, but these rulings were also novel because of the manner in which they were adopted, public hearings and active participation of social actors involved in the case, plus the complex follow-up mechanisms that the court has used to enforce them. The case of the right to health is particularly important because the court recognizes health now as a fundamental autonomous right, clearly abandoning the doctrine of conexidad for its protection. Again, as Natalia rightly points out, these rulings are very important, but they do not constitute a single model of social rights adjudication adopted by the Colombian Constitutional Court. The court issues hundreds of rulings every year, and structural rulings or structural decisions such as these are the exception. However, they were at the time a sign of an innovative court that builds on the court's jurisprudence of the 1990s. The cases of this era includes, of course, the 2010 decision, a case that is very close to my heart, in which the court removed school fees for primary education in public schools back in 2010. The court's recent years have been challenging for economic and social rights jurisprudence. The court remains committed to these rights, but there have been attempts to introduce greater procedural requirements for economic and social rights claims. Similarly, there is greater concern about the fiscal impact of decisions, and there have been limits to the adoption of structural judgments that the court is responsible for following up on. There have been also some attacks on the judicial independence of the country by the executive branch, particularly when it has disagreed with court's decisions. This happened, for instance, very recently with the abortion decision, with the abortion case in the country. Unlike the transformative court of the 1990s, the court in recent years seems to be more concerned with the stability of our democracy and our political system. Precisely in a period where there have been protests and social outbursts that began in 2018 and continue in 2020, coinciding with the economic crisis derived from the pandemic. Unlike Chile, the popular demands in Colombia are not for a new constitution. The demand is for the fulfillment of constitutional promises contained in the 1991 constitutions. That is why one of the great challenges for the court, as Natalia rightly points out, is to issue rulings that can actually be complied with. Another challenge, undoubtedly, is the excess of tutela actions to seek protection of economic and social rights. The court must find a balance between individual litigation and structural decisions to address more precisely the protection of economic and social rights without affecting the petitioner's right to equality. Transformation of political and social institutions and power relations in a democratic, participatory, and egalitarian direction, as proposed by Karl, is still an incomplete task in Colombia. However, if any institution has contributed to it in the country by introducing progressive social changes through law and generating non-violent processes, it is our constitutional court. That is why it must be surrounded and protected. Thank you, Karl, for your work and for your inspiration to do it every day.
In our ISERP tradition, we frequently have panels that present ideas, but the panelists are not just experts. The they present ideas, but then the audience or the other ISERP participants discuss, and we learn from one another. So although we welcome questions for all of the panelists, because obviously they have amazing experiences that you probably want to ask a lot of questions about. We also just welcome your thoughts and reflections on what they have said and put forward, because that's what we do in ISERP. We consider all of you experts as well, and we consider that you probably have a lot of thoughts that you would like to share with one another as we learn from the amazing panel that you've just heard. So I open the floor now to people who want to reflect on what you've heard. And I cannot believe this amazing audience does not want to say some things.
Lucy.
Ah.
One of the things that struck me is, we're thinking about this.
Introduce yourself.
So I'm Ingrid Nav. I'm a labor lawyer, a student of Karl's, past student of Karl's. And I work at SEIU Local 32BJ. I do, which is a big, for those that don't know, a service union that represents janitors, security guards up and down the East Coast. And one of the things that struck me in the comments is that to think about how you would use transformative constitutionalism seems to require that you're in the position to effectuate transformative constitutionalism. And when you're in a position where the people in power, or the people that wrestle more power from other, the most power, if it's differential, aren't truly interested in egalitarianism, then how do you use those tools to, how do you use those tools when that's not actually the interest or the motivation?
Oh, Dennis and Jayshree, can you hear what Ingrid was saying?
Yes, I did.
Sort of,
Hey,
yeah.
Dennis, are you with us?
Yes, yes.
Okay, did you hear what Ingrid was saying?
I sort of heard, not entirely, but unclear. But
Okay,
unclear.
Ingrid was saying how when you're in a position, when the people who are in power are not so willing to do what you want them to do in terms of transformative constitutionalism, how do you use it to effectuate what you want to do? Is that pretty much what you were saying, Ingrid? Yes.
Oh, do you want us to answer that, Lizzie?
Dennis, do you want to take that?
Well, I suppose I'm happy to make a point, Lucy, if that's
Or
what you
two
want.
other people want to chime in a bit first?
But you may want other people. Yeah, why don't you? Just call on us
Okay.
when you want us to. Yeah.
What do you want to, Jeremy?
I just thought Dennis wanted to say something.
Oh, Dennis, you want to say something?
No, I was waiting. I thought you said we should take some more questions, but comments. But if you want,
I can add this point if you like.
Sorry?
Oh,
Jayshree?
yeah, I can add to this point. There are several instances specifically at present we are struggling with where, these labor codes were passed during the pandemic, and also in the rule-making process, people do not have any say. So what we see, first step as simplifying law and maybe making people aware of these laws so that they can decide for themselves what part of law is acceptable and what they see as compromising of their rights. and then making an avenue so that the conversation for them to participate in that lawmaking process and be able to give their comments, and to advocate for those comments to be accepted. If that doesn't work, then I think the next step is to kind of take on streets and engage in movement building and ensuring that that you agitate through being on the streets.
Lucy, if I can make a comment if Josie's finished.
Go ahead, Dennis.
Oh, thank you. Well, I suppose the answer is that I do live in a country where this is happening almost all the time these days, which is effectively that the promises of transformative constitutionalism in the manner in which it's been discussed by this entire panel is honored very much more in the breach than in the compliance by the government. But there are two or three aspects to that. Number one, it does depend to a large degree on the resilience of civil society, non-governmental organizations, of which there are a range in South Africa and very, very good ones too. And the fact that they can actually drag government to court and that they can do so in a fashion which combines both politics and legal strategy actually becomes really important, and that it's part of the process of contestation. It's part of the process of seeking to take the government on, if I could put it that way, or the status quo on. So there's never been a guarantee. I never thought for one moment that in 1994, when we got 96, when we got our final constitution, that we just press a button and suddenly we'd be living in utopia. This is a long and going to be a very, very difficult struggle. But the more that one can harness political groups who feel that that constitution does in fact embrace many of their aspirations, that actually does fuel political commitments of the kind that seem to me to be very important in trying to reconfigure the balance of political forces in the country, which is ultimately the crucial point. I should also say in this regard that finally, after a very long time, the kind of work that, and Frank alluded to it, the kind of work that Fishel and Forbath have done in their new book is not a million miles removed from what we're trying to do in South Africa, which is try to look at the Constitution in a manner which suggests that there are a series of economic policies which are absolutely vital if you're actually going to get anywhere near close to vindicating the promises of the Constitution. And that means people are starting to think through, how can we develop economic policies congruent with putting the Constitution in its best possible transformative light? And how do we actually then, as it were, manage to inspire the unions, other NGOs, etc., to join in this particular enterprise and use, as it were, those normative frameworks of the Constitution to develop a much more coherent economic policy than is happening now. So those are the kinds of political initiatives under the banner of transformative constitutionalism that should not be entirely discounted.
Ingrid, I think your question has sparked a lot of discussion among the panelists.
Well, Dennis, I think we really need to think about that first question. What's the case if you have a division of views about what the Constitution stands for, what the Constitution points to? And some of us may see the Constitution as anti-oligarchical, but others may see it in some ways oppositely, and those others may, for the moment at least, be more influential or have more control over the levers of power than the first group. How does the Constitution help you then? That's what I take the question to be. Well, no one, least of all, Karl, Dennis, no one would suggest that once you've got the Constitution laid down, the work is done. Everything else just follows. Obviously, politics is going to be a big part. It's going to play a big part in determining what the future outcomes are going to be. But a lesson that Carl and Dennis together actually collaborate a lot of this, are trying to get across is that part of that politics consists of legal work. It consists of work done by lawyers in fashioning arguments, in bringing cases, in designing pleadings, in producing evidence. And part of that work is done by judges engaged in constitutional interpretation and application. And I think a major part of what Carl and Dennis are trying to get across is that when a judge does that work, and when a judge does that work, as inevitably the judge will do from a standpoint, from a set of intuitions, a set of instincts about right and good politics that could only itself be called political. When a judge does that, the judge is not necessarily engaged in a betrayal of the rule of law. The judge is engaged in what the rule of law at a constitutional level, at least, necessarily has to consist of, which is a contest of visions that have political components in them, because the Constitution necessarily is written at a level of abstraction that is going to be open to debate and interpretation. So the transformative Constitution is an assignment. It's not a completion, it's an assignment to us to go to work in ways that have a distinctly legal coloration and aren't law-free.
All right.
My name is Sam Bookman. I'm a SJD candidate at Harvard Law School, and I have an interest in comparative constitutional law and transformative constitutionalism. And I was really interested in Professor Michaelman's provocation, I guess, about whether transformative constitutionalism is post-liberal or a different form of liberalism. Because it's a critique that is labeled elsewhere. It's a concept that relies in large part on rights, albeit different rights, but rights as we think of them as liberal institutions. And secondly, a theory of legal culture, legal interpretation that is possibly not so far off from some left liberal theories of interpretation, thinking of Ronald Dworkin and the like. So I guess my question for the panelists is whether you agree with the question of whether transformative constitutionalism is truly a post-liberal or not, and what features of the concept they see as being particularly post-liberal or different from a left liberal paradigm. And secondly, I guess, is whether any of this really matters. What are the stakes of it being described as a liberal versus a post-liberal concept?
So the question is TC post-liberal, and does it matter?
I think that's directed, at least in part, to me. TC is post-liberal. The question is whether, or the extent to which we want to say that makes it not liberal. I don't think Carl ever meant not liberal. He chose post in order to avoid that. But what it's not is classical liberal. That I certainly would accept. I have my own ideas about what liberal is. In that respect, you can classify me as a follower of John Rawls. I have actually a book-length treatment of this coming out sometime later this year. But what I would say is, what is liberal? Liberal is a universalist. Liberalism is a universalist idea. It takes us as persons. It sees us not as atomized, but it does see us as among other attributes, individuals. It sees us as having lives to live as people. It sees us as the mantra, the expression is free and equal, but equally as free and equal. And that has implications for social structure. It has implications for what John Rawls calls the basic structure of society, meaning all the structural characteristics of a society that parcel out prospects for prosperous and dignified lives among the population. So political economy is not alien to liberalism as I see it. It's deeply ensconced at the heart of liberalism as I see it. That's one of the ways in which I would be set up in a debate with some more classically minded liberal, like an academic friend and associate of mine, Richard Epstein, author of a book called The Classical Liberal Constitution. Epstein and I used to debate these questions around the country, and we didn't debate them in terms of liberal versus something else. We debated them in terms of what are you talking about when you say liberal? So that's the stance that, to me, I mean, backward looking, to the extent I want to be restorative looking, to the extent I want to look to a tradition, and to a tradition that I think my country's history aligns it. That's the way my impulses, my upbringing, whatever, tell me to do.
Yeah, Emily?
I'm Emily Spieler. I'm a colleague of Lucy and Carl's, and introduce myself more in a minute when we go to the other panel. But I actually wanted to make a couple of points. One is that our Health Law and Policy program has a grant from the Robert Wood Johnson Foundation to educate judges about the social determinants of health. And I think that relates.
Speak louder, Emily.
Our Health Law and Policy program has a program that is educating judges with funding from the Robert Wood Johnson Foundation on the social determinants of health, so that they will consider these issues in making health-related decisions in court. And I think it's a direct kind of example of how judges can play a role and how we can play a role in making sure that judges are aware of the kind of role that they can play in promoting social and economic rights. That was the first thing I just wanted to tell people about. And the second is that what I've been thinking about here as I've been listening is some of the work that's being done at the state level under state constitutions around the country. Some of the state constitutions have remarkable provisions that are absent from our federal constitution, and often they lack some of the deeply troubling aspects of the federal constitution. And activists around the country who are interested in social and economic rights have latched onto a number of the provisions of state constitutions, including vague ones like what does equality mean, in order to promote the rights of disadvantaged, marginalized people. And I think we should pay attention to that as an example of how to think about transformative constitutionalism within the United States when sometimes it feels hard to be optimistic about pressuring on the interpretation of the federal constitution, certainly in this moment.
The right to health. As I mentioned in my talk, the Colombian constitutional clause on the right to health is not very clear, but it's real, like a true political commitment of courts with the interpretation of the right as a fundamental right. It's totally possible to protect it, and this is something that the Constitutional Court in Colombia did back in the early 1990s with the use of the doctrine of the connexity, and even later when recognized the right to health as a fundamental right. And this goes back to the first question, because then what happened is that the National Congress adopted the idea of a fundament that health is a fundamental right in a statutory law, which is interesting because and this shows Frank's earlier point about how the jurisprudence of the Colombian Constitutional Court also contributes to the political discussion and to the political process when Congress decides to enact a law following the court's jurisprudence, and how activists and human rights advocate appropriate the rulings of the Colombian Constitutional Court to continue in that process. So I was just going to mention that on the right to health.
Lucy, can I go back to this issue of liberal and post-liberal?
Absolutely, Dennis.
Well, because it really irritates me, this particular thing, because I think it's completely unhelpful. You know, it's not the label, but having said that,
what you really think.
let me at least quote what Karl said in '98, because it's relevant. The South African Constitution, in sharp contrast to the classical liberal documents, is social, redistributive, caring, positive, at least partly horizontal, participatory, multicultural, and self-conscious about its historical setting and the transformative role and mission. Now, we can again unpack all of that, but the real point I'm making is that, leave aside the labels, the real question about that constitution is precisely the idea is those particular aims that Karl set out seem to me to be correct. Now, if you go to the question of the right to health and try to educate judges for that matter, it seems to me that in the South African context, very, very few judges embraced the holistic vision that I've just read out. It is true, you can point to various judgments that are very good, but whether in fact you really have got, whether our legal culture, or for that matter most, in a sense, can embrace something which is social, redistributive, caring, positive, and horizontal, and participatory, all at the same time, requires significant political work to try to figure out what that really means when you adjudicate upon cases. And after 23 years on the bench, I can truly say that I find very few constitutional court judgments which help me along the way in that particular regard. But if you're going to ask yourself, what is transformative constitutions about? It seems to me that it is promoting, broadly speaking, those particular description that Karl put up. And that is a million miles away from a liberal conception of a constitution. And there lies the pity. Why am I irritated by this? Because it's precisely this dichotomy which has caused such trouble in South Africa, by virtue of the fact that by being able to be labeled in some broad liberal framework of that kind, which is antithetical to the point of participatory, redistributive, horizontal, etc., we have now got ourselves into the point that the very transformative constitutional enterprise, which I still think is our best hope, is under significant attack by those who now want to reject the entire enterprise.
Dennis, I know that you spoke in Karl's American Legal Thought class yesterday, and I think one of the other points you were making was that because of the formalism with which your legal education is so rife, many of your lawyers are not making the transformative arguments in front of the judges that your constitution would allow. Is that correct?
Completely correct. Completely correct. And that has been the case since 1996. And I would think that it's to the great tribute of the first Constitutional Court that they were able to push the boundaries beyond the presentations that most of the lawyers gave to them.
I mean, we have a number of students in the audience here and alums. Can you speak a little bit more about how you think those arguments might be able to be made when you were the judge and you wanted them to be made?
Well, the interesting thing, you see, is that it is not for want of academic writing, or not much, but there is academic writing, which which ultimately, if the advocates actually embraced them, we would be far further along the line than we are. I'll give you a few examples, apart from Karl's own writing. There are the writings of the late Andre van der Walt, who was an extraordinary property lawyer and who sought to think through property law in the way in which it would be egalitarian, participative, and redistributive. And what he was trying to do was to reconfigure the concepts of property law, almost in the great tradition of Karl Renner, by suggesting that the contents change even if the concepts remain the same, in order, as it were, to develop a property law which would have given a whole range of people in our land rights that they hitherto don't have. I think it's true if I look at the work of my, I'm always proud of my ex-students, of Professor Liebenberg, who's written astonishingly fine stuff on socioeconomic rights. And I would wonder that if some of that, including, might I add, your own article on the Hertzfor and the Mazibuko case, which I did rather pathetically give to my son, who's now clerking in the Constitutional Court, in the hope that he might persuade judges to read it, on the basis that that's the kind of stuff that I would hope that advocates would have taken up and argued in a nuanced fashion. But the reality is that to a large degree, you don't get that. And that has been a particular problematic. And as the court has got weaker and as the politics have become more toxic, in fact, the problems have only exacerbated. So I really am all in favor of the kind of legal education that some of you guys give your students at Northeastern. Say, if only that would happen at UCT and at the other universities in South Africa, and more people would read Van der Walt, Liebenberg et al., we may get somewhere.
I want to address this last round. I'm not sure if it's appropriate to address to Karl, so I'm not going to address Karl. To the people who are, all of us who are disciples of Karl, isn't the story that Dennis is telling, don't we have to now come back to the wisdom of the younger Karl, the judicial de-radicalization of the Wagner? Isn't this the story now being told in the mode of South Africa and constitutionalism? Isn't this kind of sad story of and maybe lawyerly de-radicalization of the South African Constitution? I'm sure there's wisdom here in the story that's being told, and the conditions of the way in which a legal document that is the product of people's struggles then gets alienated from its aims by the forms of the legal of the legal institution. And isn't that what didn't Karl already predict this years ago?
What he couldn't predict was the failure of the politics.
Failure of the politics. But I have to say, and Jayshree, I want to turn this back to you. You have done some amazing transformative lawyering in India. And can you speak to that a little bit? Because I just taught in my social welfare law class a case that you argued in the court on its own motion around maternal health benefits. So can you just speak a little bit about some of the amazing litigation that you've done in India?
Sure. The litigation which I had earlier practiced was mostly a top-down approach where you identify an issue, go to the community, conduct your own survey and file cases. What I found problematic with that was even if you did the best lawyering and put all your efforts to get an amazing decision, it did not translate into reality for people, because the knowledge to translate that legal victory into an action and real impact in life was not there, and that transfer did not be there. As a result of which, I started working on more of bottom-up approach wherein engaging deeply with the communities. I want to work with engaging on simplifying legal provisions, making the process more participatory, making the process more empowering, and where the communities themselves would have say into what in the strategies of legal actions. So from the place of identifying issues they want to take up, once the issues are identified, what discourse they want to take, whether they want to go to the administrative mechanisms first, explore what that means, and only after due consultation, if there is no outcome with the advocacy and administrative mechanism, to take the matter to the court, be it High Court or Supreme Court. Now, what happens in those cases is that we, during the process of consultation and administrative mechanism, gather a lot of evidence, which usually people do not kind of tend to get because they're not given those documentation, especially in terms of healthcare. If a pregnant woman approaches a hospital, she's not given a referral sheet, she's not given medication, like, you know, the prescription slip. She's not given her test results. So many times I found barrier of not having documentation to strengthen the case. But once we kind of like decided to engage more strategically with cases, the evidence collection became easier, and also kind of to show how the administrations have failed to take action. In those cases, we have been able to show to court that we have exhausted all non-legal remedies. And as a last resort, we have come to the court, and there was a clear documentation to show where there was a failure on the part of the government, on administrative mechanism, to respond effectively to the grievances of the petitioner or complainant. Through such steps, we have definitely gotten a lot of legal victory from ensuring that informal settlement in Delhi has a community toilet which is operational, clean, has water in it. There are several women who were denied their maternity benefits, have been able to file the complaints and post a non-redressal, have approached court and has been able to get those cash legal entitlements issued through court orders, and so on and so forth. But in cases of housing, I have seen that the trajectory has not been that easy. There are cases which I had argued about 10 years ago, 12 years ago, had landmark decisions. They've been cited in legal journals, are talked about by students. But when I see the translation or implementation of those decisions on the ground, which has still not happened, even if, like, you know, the most celebrated decisions. In one of the cases, which the community was demolished in 2010, went to the court, got their right to housing was upheld. The government was directed to give them rehabilitation. We had to go file a contempt case. In contempt case, the government made the payment for rehabilitation. The private party made payment for rehabilitation. The matter was disposed of. We had to file the case again, where all the households which were demolished did not figure out in the eligibility list. We got everybody in the eligibility list. Final order of the court said give rehabilitation in 6 months. 2-3 years passed while communities are awaiting rehabilitation in a very small space, about 75 families in one massive hall. They're sharing that space, were waiting for rehabilitation, had paid their share for rehabilitation. The government schemes changed on rehabilitation. The government policy changed on rehabilitation of slum dwellers. So now we have filed another case challenging that policy, where they are now rendered as ineligible for rehabilitation even after paying to the government their share for rehabilitation, found eligible, and doing 10 years of litigation. 7 days ago, their electricity was shut down. We tried our level best through administrative mechanism to get the electricity back up, restored. It's a month of Ramadan where people fast. It's a month of Navratri, again, a Hindu calendar year where people fast. And it's really, really hot in Delhi. It's impossible to stay without a fan. In this situation, they stayed without water, without electricity for 7 days, and we finally had to move an application to the court saying that please ask government to restore the electricity. And at about 7 p.m. today, that electricity was restored after 7 days for community who's been waiting for rehabilitation for 10 years and for no fault of theirs have been continuously denied. So I am becoming skeptical of litigation and an output which comes out of it, because I'm seeing more and more how the systematic denial of rights has been happening. And I'm also been seeing how these strong decisions which we have managed to get over last 50 years are being now further diluted for one or the other reason. So being a human rights lawyer who has been practicing for about 15 years and has had good run over, getting landmark decisions on fundamental human rights issues, I am critically re-looking at taking cases to the courts, because now when my clients who are leprosy cured people, who are people who are waiting for compensations or waiting for rehabilitations, call me up, when is my case going to be taken up? Victims of trafficking, I have no answer. When will I get a hearing before the court? I have no answer. Will I get a favorable decision? Even if I have a strong case, today, the way our courts are functioning, the way system is, I will not be with certainty be able to say, yes, you will get a positive decision or you will get some relief. So if being a lawyer, if I'm not able to give those answers, I am really, really questioning the ways in which we agitate for our rights.
Thanks, Jayshree, so much. And thanks to this entire panel. We'll take a few minutes break and be back for the second panel at 11:30.
My name is Emily Spieler, and it's my job to welcome you to the second panel, which focuses on the second area of Karl's transformative work. For those of you who don't know me, I came to Northeastern almost exactly 20 years ago as dean, and some of you actually know me from, some of the people here know me from when I was in the Women's Law Collective in Boston in the 70s. But leaving that aside, I've been Karl's colleague and fellow traveler in labor and employment law since I came here, teaching and maintaining a curriculum for law students and supporting the work of worker centers and unions in their quest to promote workers' rights in Boston and around the world. This panel is a panel that focuses on Karl's work, that focused on about labor law, starting with the seminal article on the de-radicalization of the Wagner Act. And there will be 4 remarkable scholars, only one of whom had to stay home because of COVID. But first, we will hear via video from Judge Silvana, who has known Karl for more than 30 years. She was the first woman elected by Parliament as a judge at the Italian Constitutional Court in 2014, after serving as a professor of labor law and European social law at the University of Florence and at the European University Institute. She's now an emeritus professor at the University of Florence. After we see her interview, her video, we will be hearing from 4 speakers, not in the order that you have in your flyer. First, from Michael Fishel, who's the professor of law at the University of Connecticut, began his legal career as an attorney with the NLRB, and after Reagan won the presidency, he escaped to academia at the University of Miami until he moved to UConn in 2006. He includes in his career highlights active participation in a faculty group supporting the ultimately successful effort of SEIU to organize the custodial and landscaping workers at the University of Miami. The second speaker will be Sanjukta Paul, who's an assistant professor of law at Wayne State. Prior to transitioning to the academy, she practiced law for several years, representing workers, labor unions, and civil rights plaintiffs, has written widely on issues of antitrust and labor, and broadly speaking, studies how law organizes economic coordination, currently focusing on labor and antitrust. We will then hear from Veena Dubal, professor of law at UC Hastings. Her research focuses on the intersection of law, technology, and precarious work. And within this broad frame, she does empirical research and uses critical theory to understand the impact of digital technologies and emerging legal frameworks on the lives of workers, the co-constitutive influences of law and work on identity, and the role of law and lawyers in solidarity movements. Joining us via Zoom will be Diamond Ashyagbor, who is professor of law at the University of Kent. Diamond is an interdisciplinary legal scholar who studies labor law, equality, trade and development, and economic sociology of law. She's a graduate of Oxford and European University Institute in Florence. Her most recent edited book was Reimagining Labor Law for Development, Informal Work in the Global North and South. I've suggested to the panelists who are here that they not come up until after we hear from Justice Sciarra, and then we will come up here and speak from the table, and Diamond will speak at the end. And hopefully there will be plenty of time for conversation afterwards. Thank you.
Karl and dear friends, thank you for including me in this celebration. I feel part of this special gathering, which is a tribute to scholarship and to friendship. I have been thinking of the many occasions we have had to share thoughts and discuss projects, and I have been going back with memories. And then doing this, I found in a folder in my apartment in Florence a paper Karl delivered in Rome in 1994, so we're going back a few years, at the Centro per la Riforma dello Stato. The title is Legal Practice and the Democratization of Society. You tried in that paper and many other occasions to explain to Italian lawyers the doctrine, the practice, and the theory of critical legal studies in the US. And Italian lawyers listening to you were people engaged in some form of democratic reforms. They were trying to enhance changes in Italian legal system. And I remember our long discussions on what riformismo means in Italian. I read those pages, Karl, and the enthusiasm and the honesty of your work is there. You write, among many other things in that paper, if you put any three critics in a room for political discussion, they would advance at least 4 or 5 different points of view. This is the solid ground on which you have built your work, dear Karl. Pluralism and constant challenges to combine coherence and open-mindedness. Let me recall your work in South Africa. You have inspired so many lawyers and so many friends and people there. They have been benefiting from your work and from your many advices. And let me mention the seminar we organized together at the European University Institute, again many years ago, with Boustroth. I have a vivid memory of you in that seminar, and what a joy to enter the classroom with you, and then the discussion and the pleasure to discuss with you afterwards. Another vivid memory I have in my mind is of you and Hallie arriving in Florence, and of the time we spent together in those happy days. and a vivid memory of visiting your father in New York. A real privilege. Thank you for allowing me to do that. And also thank you for the strength you transmit to students. I know how much students love you. And thank you for keeping all your friends together today in such difficult times, for not losing hope and energy that you are so good in transmitting to other people. I often look at the picture of you and Holly, and I feel close to you and confident we shall always be friends and discuss passionately as we have done in the past. And why not include some gossip in our conversations? I wish I were there. Good luck to everybody and a big hug to you all. Thank you.
That's the first time I have taken off a mask in a room with this many people in about 2 years and a month. Don't anybody breathe. No, you can breathe. It's okay. But it is a little unnerving. It's wonderful to be here. It's just amazing to be here, and I can't express enough gratitude to the organizers, to the dean, and especially to Karl for this amazing occasion. Thrilled to be included. I want to use my time to tell 2 stories. The first set in 1976 at Harvard Law School. Second set in the 1990s and early aughts all over the world. And then I'll close with an epilogue that's focused on the current fraught yet remarkable moment in labor history. So the first story was the fall of 1976. And I can say firsthand, a thrilling time to be a lefty student at Harvard Law School. At the time, I would say, we came for the liberals, but stayed for something else altogether. Because there were these professors whose classes were just different. And the first sign of difference was that they assembled their own course materials, which meant no resale value whatsoever. Thanks a lot. And they often included readings from extra legal sources, and in any event, readings that creatively and energetically challenged what turned out to be the settled understandings that organized our more mainstream texts, which were all either brown or red. For another thing, inside and outside of class, they treated their students decently, generously even, and that was a welcome surprise to a generation of law students who had just seen Paper Chase before heading to law school. We arrived expecting crabby imperiousness and ritual humiliation, and we weren't disappointed. Not at all. If you want to know the details, one of our classmates wrote a book about it. It's sort of Son of Paper Chase, or 1L. But mostly the difference was a studied distance from the legal materials, a focus on critique rather than apologetics, or just doing my job, ma'am, doctrine. We had Duncan Kennedy for contracts, where the rhetoric of legal justification was taken seriously but not literally. And the secrets of the realists, deeply repressed or snidely dismissed in our other classes, were revealed to our constant amazement and delight. Morty Horowitz for legal history, offering a powerful counterpunch to the steady liberal progress narrative served up in our other courses. Derek Bell for race, racism, and American law. She taught out of his just published casebook that sported a shot of the famous Black Power salute in the 1968 Olympics in Mexico City, and at least implicitly said that he was going to be as critical of the notion of civil as he was of the notion of rights. And then Unger for jurisprudence, where the smallest unit of analysis was advanced Western capitalist democracies. And where at any moment we were half expecting a divine reply to the question he provocatively posed at the end of knowledge and politics. Critical legal studies wasn't even a thing yet, let alone had it been thingified. But a relentlessly critical and decidedly unapologetic study of law was infiltrating the citadel. And both the school of thought and the social movement were rapidly coalescing, even as we students researched our third-year papers and prepped for another set of exams. And then came the buzz about a paper that had been presented by a recent graduate at a faculty workshop. Mostly we students didn't hear a lot about faculty workshops, didn't even know they existed. This one broke the seal. Paper in question had energized the soon-to-be crits and driven other faculty into a flurry of memo writing. Professor Bell was so impressed with the paper that he set aside his course plan to enthuse about it at length and to persuade those of us fortunate enough to be in his class to be sure to read it. And the research and teaching assistants who were working with the usual suspects, we got the details and spread the word further. And the paper was the Judicial De-Radicalization of the Wagner Act and the Origins of Modern Legal Consciousness. A recent graduate was Karl Klare. And for those of us who study and teach the subject labor law, it's not been the same since. In a nutshell, he pulled back the curtain on the normal science of labor law, revealing patterns of ideological conflict and contestation behind the judicial declarations of doctrinal constraint and fidelity to congressional purpose. Judicial de-radicalization, like other first-gen CLS work, posed a deep and daunting challenge to the perceived tradition of largely technical studies sprinkled with well-meaning policy talk, inspiring those of us who entered the academy in its wake to search every nook and cranny of our subject for the hidden and not so hidden politics of law. But among a significant group of students at the time, the paper inspired a deep interest in labor law, produced a series of workshops and informal study sessions. Kathy Stone was a year ahead of me, and she was a principal organizer. Ed James, who had worked for the mine workers, was a participant as well. The highlight workshop was one where the author of the paper came and turned out to be a wonderful and inspiring presence. Whatever else those gatherings produced, they inoculated all of us against the risk of taking labor law from Archibald Cox. In my own case, the paper and the conversations it produced, and most of all, the deep humanity and intellectual generosity of the author inspired me to a career in labor law, enabling me to spend a half-decade as an appellate lawyer for the NLRB and also with the California Agricultural Labor Relations Board, working to secure justice for employees fired for union organizing. Second story, fast forward to the mid-1990s and the story of a critical legal movement that flourished in the decades following the supposed death of critical legal studies, like the crash of the mothership. The name of this movement was INTEL, the International Network of Transformative Employment and Labor Law. But in terms of ideas, energy, and many of the participants, it was CLS reloaded. And over the course of a decade, beginning in the mid-90s, we held a series of extraordinary conferences in Canterbury, Coral Gables, Cape Town, Toronto, Catania, and Kyoto. We published a pair of groundbreaking collections, including Labor Law in an Era of Globalization, Transformative Practice and Possibilities. Karl made us promise never to say the first part without the transformative practices and possibilities part. The other collection, Labor Law, Work and Family. And we spawned a host of cross-pollinating collaborations, mini conferences, group email threads, academic visits, friendships, and conversations. There were 4 remarkable features of this critical network. Hold on one second. Thank you so much. Marco Rubio was a student at the University of Miami, and I learned how to drink water. So 4 remarkable features of this critical network. The first remarkable feature was, it was the first truly sustained international labor dialogue with active participants from Europe, the Middle East, the Americas, Africa, Asia. What we had in common, in addition to deep commitments to critical legal work, to workplace justice, and to sorting out just what was happening to our field, was that every one of us was a friend of Karl, who had carefully cultivated scholarly engagements and friendships throughout the world. Turned out, as I saw from the first panel, he was seeing other people. This is really not the way I would hope to find out, but we will always have Paris. The second remarkable feature of this conference was we didn't have any money. Actually, it turned out to be a metaphor for my life. It was Lukman, no funding, and it was all homemade. And what we would do one at a time is talk our deans into, we're gonna have some friends over, and then convincing them to pay the $30,000 bill, and the conference was over. So it can be done. The third remarkable feature was a feminist revolt at the first meeting that eliminated for the rest of the project the usual tendency toward white male dominance. It was an extraordinary moment that could have exploded the whole project, but instead what happened is some people went away and others learned to behave better. And so the kind of decorum that Lucy was describing on the first panel was also very much decorum. The fourth remarkable feature is its provenance as self-critique. Karl had already inspired one transformation of labor law scholarship with judicial de-radicalization, together with other first-gen critical labor scholars like Kathy Stone and Alan Hyde. That work dramatically shifted the preoccupations, not just of left, but also of mainstream labor law scholarship for a decade and then some. But as innovative and invigorating as the new work was, the revelations of one generation inevitably take for granted understandings and assumptions ripe for interrogation by the next. And it turned out that even the best labor scholarship of the 80s and the 90s was operating largely within frames that were problematic from the get-go, and that were in any event already under assault by economic, cultural, and political developments, soon collectively to be known as globalization. So what was remarkable is that Karl energetically organized a challenge to the very work he had begun and inspired, as Intel undertook a relentless exploration of some of the most fundamental concepts in the labor field, interrogating the concepts of work, of worker, of workplace, of employment, challenging the distinctions between paid and unpaid work, between employment and unemployment, between employment and self-employment, and between work and other essential life activities. And undertaking this rethinking nearly a decade before others noticed, and nearly 2 decades before the insights that much of the work yielded became conventional wisdom among progressive legal thinkers. So that brings me to the epilogue. Turns out that the most dramatic influence of all on labor law happened in the classroom. For decades, progressive labor lawyers and scholars have been critiquing the National Labor Relations Board, the agency charged with enforcing the country's labor laws, and lamenting its snail-paced procedures, legalistic interpretations, and toothless remedies. While we were doing all that lamenting, two remarkable labor lawyers and a generation of their peers were hard at work devising creative strategies based on deep understandings of law on the books as well as the law in action. And as a result, their work has begun to exceed by far the hopes of the lamenters. Fortunately for the development of labor law, Presidents Obama and Biden saw fit to appoint each of them as general counsel to the National Labor Relations Board. Richard Griffin was Obama's second general counsel, and Jennifer Abruzzi is as of now President Biden's general counsel. There's a challenge to that in federal court. We'll save that for another day. Richard was Karl's student, and Jennifer was a student of someone who became a labor lawyer and scholar in large measure because of Karl's example. And there's no greater honor for a life in teaching than to watch our students accomplish things we couldn't even have imagined for the field we love. Their work offers a greater possibility in the moment than at any other point in my lifetime of delivering on the core promise of the Wagner Act, which asked not what the law could do for workers, but what workers could do for and with each other, with the law poised to challenge obstructions to those efforts, particularly obstructions posed by recalcitrant employers wielding power that is still very much the product of the common law of master and servant, and with the law poised to play a critical role in generating community and official support for those efforts. As recent events at a sprawling warehouse on Staten Island attest, talk about of all the gin joints at all the towns. The potential energy of solidaristic collective action should not be misunderestimated. And the importance of the work of our students and a new generation of labor lawyers and academics in enabling and in reinforcing the release of all that energy shouldn't be underestimated either.
We want it used because there's so many people watching on Zoom.
No problem. Hi, everyone. My name is Sanjukta Paul, and I'm really, really honored to be here. And I really appreciaed hearing some of the real-time developments Una and I were discussing, that we were not there for that, but we too, I think, feel and can feel the reverberations of how something that it's very evident was not common sense at the time has become common sense, has become sort of the water we swim in as scholars today. And so it's just an incredible honor to participate in this conversation, even if I can't speak to some of the same things that Professor Fishel did. So I think I'm going to pick up on a couple of things in the paper and then relate them a little bit to some of the research I've been doing. And then maybe we can talk in the Q&A a little bit, or maybe I'll tee up a little bit, these questions of methods that Karl has also participated, in currently in these debates that are happening in the LPE world. So perhaps we can talk about that as well. So just, rereading the paper for the judicial de-radicalization paper for today, I think that there's, maybe this, again, seems very obvious now, but as he says in the paper, taking the relatively autonomous dimension of legal consciousness, legal institutions, and legal practices, kind of charting this middle path between reducing it all to external social and political realities, and then obviously also avoiding the formalism and the conceptualism. So I think, you know, this is what I try to aspire to do, and I think many of us aspire to do, and this really is, you know, an inspiration in attempting to do that. So, and I guess two elements of that too that I'll draw out, you know, that the law is not simply reducible to external social and political forces. It's obviously constitutive of them in part, and that, you know, these subversions of some of the big aims of the Wagner Act, we might also say the Sherman Act, we've seen it in other instances as well, isn't a plot or conspiracy, he says in the paper. And he then, you know, in then following this through, the paper generates a new history. It's not just important in labor law, it's important for historians, that charts a middle course between, you know, this naive progressive historiography that he describes and this, I mean, tell me if I'm getting this right, and this more reductive corporate liberalism thesis. So that's how I read it. And so I then wanted to maybe talk a little bit about how I try to apply this method in labor and antitrust. So, and I think what I want to say is that we could identify, using the same method, a kind of structural genetic defect in the New Deal settlement, including the Wagner Act, even prior to the stage that Karl talks about in the paper, and fully taking on the big potential and democratic and egalitarian aspirations of the act, not negating that at all. But even prior to the judge-made interpretations. And I want to describe this genetic defect not in terms of capital, not in terms of property rights, not in terms of the employer, which I think is actually the use of which in labor law, I think actually tends to reify this thing that I think is a genetic defect. And that is something that I call the firm exemption, that there is this, I started calling it the firm exemption, focusing on antitrust law, where we talk all the time about the labor exemption, right? But there's also a big firm exemption in antitrust law, but really it's a trans-substantive legal common sense that I think we can argue that starting in the progressive era, I'll say a little bit more about that, but then in the New Deal settlement in particular, that we have a kind of hierarchy of economic coordination. Law organizes economic coordination. It allocates coordination rights, right, from the ground up. And it was not the case in the anti-monopoly period, for example, in the populist period, if you want to call it that, of the late 19th century, that we had yet enshrined the business firm as the primary engine of economic coordination and production. That just wasn't the case yet. You know, there were all kinds of other associations. Economic production was more complex. We know this
history. And okay, so to say the middle part of the story a little bit, I think that the transition, and many people have, of course, noted this in other ways, but it's usually noted in terms of people embraced, that big is efficient in the progressive era. And I think that's, with the exception of maybe Brandeis and a couple of others, I think that's basically right. But I think the even more fundamental point is that the progressives, big P progressives, embraced the business firm as the gold standard in the hierarchy of economic coordination. And I don't think that was the case before. And I think that they did that very much not as part of a plot or conspiracy, very much a part of this, this narrative of unfolding progress. And it wasn't just though sort of like the liberal elite middle class progressives who did this. There were socialists who did this. Eugene Debs in some of his writings did this. And I think that there was really a notion at the time in those decades before the New Deal that that people were convinced by the idea that there are efficiencies that are embodied in the business firm, these economies of scale that we can almost sort of
deductively assume that they exist, and then the progressive and socialist side of that is that we can harness those for the public or for workers. And I think that I mean, we can go more into the argument, but I think the point and the commonality that I think I see is that this was, I think, genuine belief, right? I think it was maybe not right, but I think it was genuine belief. I don't think it was sort of selling out to capital or selling out to property or selling out to the employer. And I think that's evidenced by the fact that it couldn't be reduced to sort of how, to the level of radicalism exactly. So I think that we then see this pass into the New Deal settlement itself. It's in antitrust law and in other areas, but also I think it's in labor law in various ways. And I'll just maybe just briefly describe how I see it. We, today in some of the labor policy debates that we're having, we talk about, and obviously this was also discussed in Karl's paper and earlier, the fork in the road between enterprise bargaining and sectoral bargaining, right? But there's, I think, and that is really important as a practical matter, because having a common wage, as the labor institutionalist Sidney and Beatrice Webb called it back in the 1890s, the device of the common rule, having that reach sector-wide, really market-wide, whatever the reach of the market is essential to make collective bargaining efficacious, right? So, and we achieved that in de facto ways in the mid-century period through multi-employer bargaining, obviously, even if we didn't have formal sectoral bargaining. But conceptually, there's a prior question, or there's a way of just slightly at a diagonal reframing the question, where enterprise bargaining, it's not just enterprise bargaining versus sectoral bargaining, but enterprise bargaining versus non-enterprise bargaining. And so obviously this could include all kinds of other formations that cut across firm boundaries. And just briefly, this is an audience that one doesn't have to convince, but I often say this to antitrust audiences, but it's worth just doing this thought experiment between how labor unions are formed and how business firms are formed. And this is something that already exists at the beginning of when the Wagner Act is created, right? And that is that there is a public process of constitution that is just not the case for business firms. It's already incorporation as of right at that point. It's conceived as basically, as in the New Deal settlement itself, it's sort of seen as de facto, for practical purposes, of a creature of property and contract. And, we have some minimal securities regulation, but the process of constitution is you file a paper with the state secretary of state. It's, students learn that. Meanwhile, in labor law, we spend weeks of the semester, talking about how the Constitution occurs, and moreover, that the organization process is fundamentally derivative of the firm structure, which exists in both practical and conceptual terms in a prior way. And I don't think that this is something we can just reduce to sort of property or capital versus labor. I think it is something that sort of is this legal consciousness that permeated across areas of law and that I think solidified in the New Deal settlement. But I think it happens even before some of the bad law, and obviously before Taft-Hartley and all of that. And then it has lots of consequences, so that even in the height of, in Republic Aviation, we have, which we'd like to recapture fully, right? Even there, we have Section 7 rights defined fundamentally the way that the court says property rights, but it doesn't actually make any sense from a corporate law perspective to assert property rights over the physical plant. And right, I mean, shareholders have no control over that. They have absolutely no control rights over that. If the enterprise owns the physical plant, yes, and has control rights, but workers are part of that enterprise. So labor law itself is autonomously creating its own notion of default intra-firm coordination. It's trying to outsource it to things like property and corporate law, but actually it's creating its own sense does that make sense? And then saying, but we're going to modify that and give workers some rights. But the thing I just want to point out, there's versions of this happening in antitrust. There's other, in corporate law in various ways. But labor law is really contributing to this itself, right? And in a way, in a stronger and even less coherent way than is happening in corporate law and antitrust law. And so that just we'll stop there, but that was sort of an example of an application that I think is continuing the methods that we see in the seminal paper, and that I think is also hopefully capturing the spirit of this. It's not all a conspiracy. It's not all reducible to sort of these clear class formations outside the law. The law is, nor is it not interacting with those things, right? I mean, clearly people who are empowered already by the law are able to influence the direction of the law in the future. And, but this legal common sense really exerts so much influence in the decade. We can reframe, I think, some of the bad decisions as extensions and distortions of this basic genetic defect. So I think I'm going to stop there because I feel like I'm a little over, and then maybe we can talk about the other stuff. But I actually, let me say one more thing, which is how I came to meet Karl super briefly. And I think, haven't known him for the years that many of you have, but in the few years that I have known Karl, I've been impressed by blessed by the same generosity of spirit that you all have described over decades. And I was telling my brother on the way over here, on the way to the airport yesterday, that about 3 years ago, I got an email in my inbox and it said Karl Klare, and I had this moment of mental confusion because I was like, wait, is the subject line Karl Klare? No, it's from Karl Klare. That can't be right. And my brain couldn't quite digest it. And he had, read a comment or something that I've written and had had all these amazing, and then had, I think, gone and read another draft paper and had all these amazing, generous comments for me. And it was just really made such an impression on me. And I think it is really, really, and then of course we become, he's been a wonderful, wonderful mentor to me since in my junior years. And, but I think it's just so of a piece with everything else I hear from everyone and from his former students. So I just wanted to add that anecdote. Thank you so much for having me here.
So I too am so deeply honored to be here, not just on this panel of luminaries and not just and to celebrate Karl and to honor him, but there's something I can't quite, haven't articulated for myself yet, but I'll try. When I walked into the room earlier, I was struck by the energy. I have been to many talks in the last month, 12 to be exact, and none have been as well attended as this one, and none have felt as beautiful. And there's something in here about that that I think really speaks to Karl, but also transcends Karl, about the academy, about love, about solidarity that Karl often brings out in spaces that I want to honor and comment on. This is a really special, we've created a really special space today. So in preparing my comments, I had the opportunity to think back at my first encounters with Karl Klare's work almost a decade ago. I was a graduate student at UC Berkeley, a former public interest attorney, and I was studying a century of taxi worker organizing using both legal history, labor archives, and ethnography. And though I was specifically interested in the impact of progressive mobilizations of law in either sort of facilitating or inhibiting labor organizing over time, the classic law and society question, I myself knew very little about labor unions or the labor movement. This was in large part because of the time of my birth. If I can reveal that, I was born in the early 1980s, not exactly the height of the labor movement. also to Indian middle-class parents who didn't sort of expose me into the larger discussions of social justice in the US, but also because I had long been interested in the immigrant-dominated service economy, a place with minimal labor union presence. And over the course of my graduate fieldwork, I had accumulated a whole trough of data from historical archives and years of ethnographic field notes. But as I struggled to write my dissertation, as one does, I realized how little I knew about labor law history. How could I begin to make sense of my research, my frankly sociological research, without the larger historical backdrop? And so I stopped typing and started reading, much to the dismay of my committee. So Karl's famous article, which you've now heard about, the judicial de-radicalization of the Wagner Act, written some 3 decades before I encountered it and some 3 years before I was born, became the single most influential piece of legal history and labor law scholarship that I read during that time. Reading it again, as I did for today's panel, I'm struck by how prescient Karl was, writing in 1977-78 about the roots of the decline of labor unionism and of independent rank and file agitation more broadly. For me, as with so many other labor scholars today, Karl's central insights and understandings of judicial interpretations of the NLRA have become almost second nature, as Sanjukta alluded to. And truly, there is nothing more that any of us could wish for our own scholarship, that we, like Karl, make our arguments so clearly, so convincingly, and so compellingly that over time they seem instinctive instead of learned. Karl made the central point in this article, as many of you know, contrary to the traditional materialists of the time, that the Wagner Act was not in and of itself a state tool to de-radicalize the labor movement and to promote business interests at the expense of worker liberation. It was not the written law that led to this outcome. And indeed, he makes the claim that the NLRA, when passed, was a radical win, a capitulation by the state to labor amidst massive agitation. But he asks, for all of its liberatory potential, how is it that the act did so little to enhance the role of the working class in decision-making regarding the use of society's means of production and the organization of the work process? And in examining the first few decades of the Supreme Court's decisions on the Wagner Act, Karl found, as you all know, that it was the court and not the Congress that turned to contractualism to make sense of the relationship between labor and capital, rejecting any inference that the law would or should inquire into the substantive justice of labor management relations or the fairness of the wage bargain. And it was therefore the court and not the act itself that legitimized the inequalities of bargaining power and the unequal social distribution of property ownership. And it was the court and not the Congress, at least until the passage, of course, of Taft-Hartley, that drew the boundaries of what types of labor activities were considered legitimate, therefore not only shaping and limiting the actual transformative direct actions of labor unions, but also shaping their own political analysis and self-conceptualization in relationship to the broader polity. And for me, this was and continues to be a critical understanding for making sense of the present and the future of the labor movement. Many union leaders came to understand their unions not as vibrant and evolving structures that were growing a radical class-based movement, but rather in striking contrast to the views of their rank and file members as responsible political institutions that often reproduced rather than eliminated the alienation that characterized the work process. This also, in my mind, helped to explain parts of the labor movement history that I found stunningly at odds with my own politics of liberation as a post-colonial subject, including the role of US union leaders in participating in the US imperial project during the Cold War under the guise of international labor solidarity. And for me, these central insights about how the courts had essentially defanged this radical law helped to put my research in broader perspective. For example, it helped me to understand how the chauffeurs union in California, which represented taxi workers, was slowly seen as in bed with yellow cab in the decades following the National Labor Relations Act, owing, of course, to a number of cultural and political factors, but also in response to the possibilities and parameters of unionism set out by the Supreme Court. It helped me to understand, at least partly, why it was that so many taxi workers felt enormous discontent and alienation from their union. So much so that by the late 1970s, when given the choice, they chose an independent contractor contract and to opt out of the one bargained for by the union, leading to the entire deunionization of the industry and to the rise of precarious and unstable working conditions that have only grown in contemporary times. And Karl's arguments have continued to be a touchstone for me as I think through any number of issues in my current research on workers whose relationship to the NLRA is ambiguous at best. Today, as many of you may know, I continue to study the collective organizing of ununionized workers whose status as employees who have the protected right to organize under the NLRA is contested by capital. These workers, namely Uber and Lyft drivers, but also food delivery workers like Instacart shoppers and DoorDash drivers, have, like Karl, maintained faith in the possibilities of radical law and radical lawyering to support their organizing. Indeed, Karl has observed in other influential writing that contestation over legal rules and practices, like judicial contestation over the Wagner Act, actually opens up transformative practices if the contestation addresses not only liberal legal rights, but also structures of equitable distribution. While there are strong arguments made by friends and allies who I deeply admire that law is simply a tool of class oppression, that it fundamentally unequally distributes power, and that it should be disregarded when thinking about justice and transformation, what Karl has taught me both in his labor law scholarship, but also in his critical legal studies scholarship, is that rules and legal categories penetrate every level of our society. And the question is not, does law matter or should we use it? Which were frankly the questions I was asking at the beginning of my dissertation writing. But in the context of class struggle, how does law matter and how do we use it? Even if by using it, we mean existing and agitating outside of it and in opposition to it. Workers in my research, despite being victims of judicial retrenchment of the last many decades, of being deprived of the basic rights embedded in the NLRA, constricted by court interpretation, understand the law dialectically in the context of the worlds and work in which they labor and the ones that they are striving to build. They, like Karl, believe that institutions and practices produced by the law must be reconstructed through contestation. And in the course of this contestation, which I've seen most clearly through one-on-one conversations amongst workers, liberatory politics become possible. And in these troubled times, this is where I put my hope for transformation. Before I end, I want to make a few personal observations about Karl. It is rare in the legal academy to find both brilliance and humble kindness in one person, and I think you all will agree. Karl is not just a radical labor law elder, he also continues to be a forceful thinker, embracing projects of the contemporary generation of new legal thinkers, helping us, pushing us, and supporting us through inclusive kindness, completely undeserved modesty, and deeply felt support and love for us and our strivings for better worlds. It is not until this very day that I have been in Karl's physical presence. And yet he has been in my mind and my heart for a decade. And there is something deeply, deeply beautiful about that. We're going to turn to Diamond.
She's on the screen up there, but I don't know. You just need to go to view. Speak. That's what she needs to. Diamond, can you unmute?
I am unmuted, hopefully.
Okay, well, we're good then. You can go ahead.
Thank you. I hope you can hear me.
Yes.
We can now.
Great. I'd like to start by saying thank you so much to Dean James Hackney, Professors Libby Adler, Jeremy Paul, Lucy Williams, and also Emily Spieler for organising today and organising this panel. And obviously, mostly thank you so much to Karl. I am so sorry, what we say over here is I'm absolutely gutted that COVID has struck, and that means I was all set to fly this week and I haven't been able to. So I'm really, really sorry not to be there in person. So we've been asked to talk on this panel on unions and workers' solidarity forever about the predictive power of Karl's insights. And I think those insights also speak to and cast light on worker organization in other industrialized economies, not just the US, other industrialized economies of the global north. So in my intervention, I'll explore collective organization among non-standard, precarious and racialized workers in the United Kingdom. But first, and I'm going to share my screen. I hope everyone can see that. Slideshow, labor of love, yeah. Good, okay. First, I'd like to say something about the context in which I first met Karl 26 years ago, and my own engagement with his labour law scholarship, which has influenced my research and my observations, both specifically today, but also my broader research on the role of labour law and today the power of collective organisation. So this image is of a Deliveroo driver, and I realised I should perhaps have had an image of a DoorDash rider or an Uber Eats rider, but you get the idea. My PhD thesis was undertaken at the European University Institute in Florence, and you have just seen a short presentation from Professor Silvana. So my PhD was on labour law, economic theory, and the European employment strategy. My supervisors were Karl and Silvana, and as you know, she's now a judge of the Constitutional Court of Italy. Karl came on board because at the time he was visiting the European University Institute as a Fulbright scholar during my first year in 1998. So this is the context in which we were having these intense discussions about labour law, and it's the ideal context to study and research and think about labour law, deliberate on. So the thesis was a critique of economic analysis of labour market regulation in the context of the European Union's labour law and employment policy. Karl and Silvana significantly helped me clarify what it was I really wanted to say. I thought I wanted to talk about globalization, I thought I wanted to talk about everything, and just that focus and helped me to pinpoint what it was I was really interested in was enormously valuable. There was a comparative element. I was interested in interrogating myths embedded in the discourse around labour market flexibility among labour economists, policymakers, legislators, and concerned about high unemployment in Europe. They looked with envy at the achievements of the comparatively unregulated US labour market. So it was obviously enormously helpful for me to have these conversations with Karl about to help me critique those assumptions about how institutions and legislative interventions, which figure so prominently in European economies, were somehow critiqued as impeding the ability of the labour market to clear, and that market equilibrium in Europe could be restored by deregulation following the US model. So I actually first met Karl a couple of years earlier at the second of the meetings of Intel, the International Network on Transformative Employment and Labour Law, which Michael has talked about, but which obviously Karl was co-founder and co-secretary. Intel 2 was at the University of Kent Law School, where I now work, and that was in 1996, and it was one of my very first scholarly presentations. I've put here a poster from subsequent Intel conferences, Intel 6, which was the University of Catania in Sicily in 2002. You can see here a list of the participants. I'm sure, and I know quite a few of you are physically present now at Northeastern. I'm so sorry that I can't be there. And then this is Intel 8, the final Intel in Cuernavaca, Mexico, on globalization. Does globalization make labor law obsolete, with particular focus on a new opening to the left in Latin America and the role of labor movements in that. So what I would say is I think I'm able to trace much of my evolution as a labor law scholar through conversation with Karl in person and through his written work. So this is us having a heated conversation, but no doubt about how autonomous labour law really can be, on the street of Upper West Side when I was visiting Colombian Law School in 2007. So these comparative conversations, I've come to see the commonalities in the extent to which labour law can be said to be either autonomous from or perhaps yet another instantiation of the economic context of a market economy, which is increasingly subject to market fundamentalism. And it's that balance, you know, how cynical are we going to be? What I find, what is perhaps equally, if not more important, that I've learned from Karl, which I hope I bring to my own practice as a colleague, a mentor, a PhD supervisor, is the way in which Karl has modelled what it means to be a normatively committed, yet intellectually open and non-hierarchical academic. So here, the final picture is of Karl with my parents. He just recently retired from over 30 years working as psychiatric nurses in the National Health Service in the UK. They've been very active in the Healthcare Workers Union and naturally found lots to talk about with Karl. Just this final point about Karl's modelling what it means to be a good academic, best practice as a scholar. So this is another image from the very hardworking Intel 8 in Cuernavaca, Mexico. Here with the long hair and the pink dress is Ruth Dukes. Later on, I organised a colloquium where Karl was a very important participant on Ruth's award-winning monograph, The Labour Constitution, the Enduring Idea of Labour Law. And here is Karl's contribution to that symposium in the journal Jurisprudence. He was, as ever, intellectually generous and very supportive, whilst also providing really constructive criticism of one's work. Okay, what I want to turn now to is continuing these comparative conversations, and I want to focus on decollectivization. So I'm thinking about the insights that I had a look again at Karl's Wagner Act article. So what I'd like to do with the remainder of my comments is to continue this comparative conversation, to trace the resonances between the US and the UK. So the decline of collective bargaining model that prevailed mid-century, the decimation of union membership and collective bargaining coverage, but its possible resurgence. So just recently, just now, Vina Dubal talked about the research she's undertaking, and Michael referred indirectly to the successes of the Amazon Labor Union. And so I'm also interested in the possible resurgence of collective organization through new, radically imaginative forms of union organizing and mobilization from amongst those workers who've been historically excluded from the standard narrative of trade unionism. So a narrative which is familiar to those of us who study industrial relations and labour law in the UK context is one of decollectivization, precipitous declines in trade union density and collective bargaining coverage from what you can see here on this graph, the dizzy heights of the 1970s. So what happened in 1979, I wonder. First of the long era of conservative governments led by Margaret Thatcher. So Karl interrogates some of the rationales motivating the Wagner Act, albeit prior to it being defanged, a concern to achieve industrial peace, minimizing economically inefficient industrial action, promotion of collective bargaining in part as a means to mediate industrial conflict, in part so as to support collective regulation of terms and conditions of employment, to address the egregious inequality of bargaining power between capital and individual workers, in part to promote industrial democracy. This is a familiar story in the UK context as well, though rather than being achieved through a comprehensive statutory enactment like the Wagner Act, designed to formalise trade unions and establish a stable understanding of what in the 70s and 80s we called corporatism, instead the UK model has been marked more by an ambivalence about the role of statute in regulating labour. So in the immediate post-war era, collective social partners were to some extent left to their own devices. So it's a sort of laissez-faire system, we call it collective laissez-faire, where responsibility for standard setting and determination of terms and conditions of employment lay with the collective parties rather than with government. But to that, subsequently there was an era of regulatory intervention, which was marked though by simultaneous decollectivization and individualization. So simultaneous commitment to the reduction of the power of trade unions in the workplace and within industrial relations in general, at the same time an enactment of individual employment rights, in particular equality rights, and some of those were in part in response to the need to meet the requirements of European Union membership. This commitment to decollectivization has had a marked impact. The UK has a doggedly determined array of anti-union legislation, in particular during the long due Conservative governments from 1979 under Margaret Thatcher, reversing statutory support for collective bargaining, empowering employers to resist trade union demands, incrementally restricting the lawfulness of industrial action. These legislative interventions operate in parallel with wider labour market changes, some of which were equally facilitated by government deregulation. So the composition of employment has shifted away from more highly unionised sectors to traditionally non-union sectors and workers. Labour markets have become increasingly internationalised as trade has liberalised, immigration has increased, and capital markets have taken on a more global structure. So, as you can see, interesting comparison, this table from the UK is 1892 to 2020. The table I've got here from the US is 1890 to 2016. Sorry, very similar stories that have been told by these graphs. But what has been observable in recent years has been, in the UK, I think, as well as the US, a counter movement, an emergence or re-emergence of vocal trade unionism by workers in these very sectors, which have been restructured by capital, in large part the restructuring taking place so as to avoid the strictures of employment protection legislation and collective organisation. So this is the way we tell the story, that there's been a close affinity between the protections offered by the standard employment relationship, the coverage offered by collective bargaining, the safety net created by the post-war welfare state, which provided, for instance, income replacement during periods of unemployment, social security and old age. So my assessment of this story is that the social solidarity, which was to some extent engendered by and deemed necessary for the project of post-war reconstruction after the Second World War, arguably built on a wartime sense of national unity. So we now have a story, and this will be familiar to those of you in the US, which is that solidarity is weakened by an undue focus on identity politics, an undue focus on gender and race. So there is an argument, though, that the post-war solidarity, which was facilitated the building of the systems of collective bargaining and welfare state, entailed a conception of nationhood, which possibly carries an imperialist or racist rationality into the labour market. Race and racism were historically a structuring force within the working class in the UK, but in a slightly contradictory way. So on the one hand, one could say the working class has not wholly embraced a national identification with Britishness to the exclusion of non-native workers. And indeed, there was a multi-ethnic formation of the working class from its inception in the UK, comprising Irish Catholic, Jewish, Asian and African diaspora workers. So for example, Satnam Virdi uncovers a long tradition of cooperation and solidarity that often transcended racial and ethnic boundaries. But at the same time, though, in the context of the welfare state settlement, in the context of union organisation at its peak, there was hostility on the part of trade unions and on the part of the white working class to racialise others and migrants. So we do need to interrogate how inclusive of racialised workers and colonial subjects were the labour market institutions which comprise the foundation of the industrial citizenship of collective agreements, social security. Simon Deacon and Frank Wilkinson, for example, outline the very partial and uneven, fragile and incomplete quality of regulation through collective bargaining. And as with access to benefits of the welfare state, collective bargaining coverage was partial even during its peak, and that unevenness has historically been gendered and racialized. So universality required belonging or participation in the labour market, ideally in the primary labour market. Racialised and migrant workers in the UK, particularly those contracting for work under what we now call atypical or non-standard terms, were traditionally excluded from the industrial citizenship or social citizenship of the post-war welfare state. Similarly, in terms of gender, Sandra Fredman and Judy Ferd remind us that the countervailing workers' power, the counterbalancing of the inequality of the individual employment relationship through collective action, is an option which has until recently been far less available to women workers than men, with women located in work which has been challenging for trade unions to organise or not fully recognised as work, given its close proximity with social reproduction. So collective bargaining, individualized employment rights, universal welfare state provision has been partial. That exclusion has been further exacerbated by growing informalization and flexibilization of labour. We have a number of interrelated factors: privatization of the public sector, deindustrialization, the rise of the services economy, decline of trade union power, employer preferences for flexibility, the inventiveness of platform capital have meant a shift towards work which departs sharply from the standard employment relationship. And that shift towards non-standard and more flexible contracting for work has in large part been facilitated by state deregulations. The state has not been absent. So we've seen employers and holders of capital increasingly organising production through distancing strategies, encouragement of labour flexibility in the private sector, distancing strategies such as subcontracting, franchising, concessions, outsourcing, where the employer contracts out the work rather than using its own workforce. This shift is manifested across all industrial sectors, but is particularly prevalent in the service sector, retail workers, catering, hospitality workers, home care workers, delivery drivers, security officers, most of whom are working non-standard arrangements, many precarious, many exploitative. Now, this retreat from the standard employment relationship has had differential impacts, but possibly disproportionately affected racialized groups. As Aaron Kandani contends, the privatizing of public life that neoliberalism engenders has racially disparate consequences due to the past history of racially differentiating discriminatory treatment. What I want to focus on just the final couple of minutes is new forms of worker organization. In two recent papers, Manos Diaz-Abi in one paper and Alessia Bertolini and Ruth Dixon in another talk about the varieties of strategies adopted by unions which classify themselves as traditional and alternative or indie on behalf of precisely these non-standard workers, in particular in platform-mediated work. Organising, worker mobilisation, collective bargaining, strategic litigation, and involvement in policy or lawmaking. Manoj has written about the surprisingly prominent use of litigation strategies by indie unions, surprisingly because indie unions tend to have a more radical orientation, but there is this interesting dual strategy, which I see a lot of resonances with the work that Karl and Vina mentioned just now, combining worker activism, worker mobilisation, political theatre, community-based organising around language and migration status. So it's interesting that this new wave of union activism in the UK has been driven by unions representing and led by workers who were excluded from unions at the heights of trade union density in the 70s. So I'm just going to give this example here of the Independent Workers' Union of Great Britain, IWGB, which describes itself as a grassroots member-led union fighting for justice for workers. So the University of London and its constituent colleges and institutes such as SOAS, University College London, the Institute of Advanced Legal Studies, makes extensive use of contracting with sourcing companies to provide services rather than directly employing, for instance, security officers, maintenance workers, cleaners, porters. And this highly racialized workforce with high proportions of migrant workers. So the IWGB was founded in 2012 by Latin American cleaners organized for better working conditions. I seem to be following the union around. So when I worked at SOAS, this is where they were beginning their campaigns, Justice for Cleaners, employed at SOAS. I then moved to the Institute of Advanced Legal Studies, where they were also advertised. This is part of the University of London. This is Senate House, which is the University of Advanced Legal Studies. IWGU members focus on the Tres Cosas 3 Things campaign to gain closer parity with in-house staff on sick pay, pensions, holiday entitlements, 14 months of demonstrations, student sit-ins, strikes, copious use of social media, 1,400 emails sent to members of the public. University Vice-Chancellor effectively capitulated and they won on the 3 Cosas issue. After a 10-year campaign, they won on this issue of being brought in-house, the cleaners and also the porters. The campaign consisted of strike action, public protests, including in 2019, the biggest strike of outsourced workers in UK higher education history. The campaign continues. My conclusion is that some of these imaginative tactics and strategies which the IWGB has utilised may sound familiar. And here again, I found resonance in the work of Karl. For example, his paper Towards New Strategies for Low-Wage Workers, identifying weaknesses of traditional union organising efforts among low-wage workers, and need to revitalise links between labour and other social movements, in particular poor people's alliances. and to think also about less formal, less hierarchical, more rooted in communities forms of organising, which have been possible, for instance, even in large unions such as the Service Employers International Union, which I've heard Karl talking about in the context of Justice for Janitors campaign. So I'll end on this point.
So for the time we have left, I'm happy to open up the floor to anyone. I'd like to ask Vina, though, if she'd like to talk a little, just very briefly, about the work that you've been doing.
I don't so much want to talk about the work that I've been doing as I want to say something that I think is, keeps using the term transformational, which of course Karl uses, but I think is really sort of hopeful and situates him intellectually, specifically in this moment with, what Diamond and Michael have referenced as sort of this historic David and Goliath sort of moment in which the small union ALU in Staten Island has voted to unionize an Amazon warehouse. So one of the things that Karl has thought about a lot and has articulated is that sort of the transformations that need to occur through and with law and structural change are not simply redistributive, but actually also shifts in ways of thinking through community, if that is paraphrased correctly. Shifts in ways that we connect with one another, shifts in ways that we feel solidarity towards one another, and it cannot just be about wages and hours. It has to be about different types of interconnectedness. And just as an aside, my late brother wrote about the role of football clubs in Brazil as sort of replacing, in the context of neoliberalization, replacing the role of unions and of the state in forming these sorts of transformative solidarities. And it made me think about how sort of Chris Smalls has been heralded in this context of the Amazon labor union as sort of a hero, but actually the union itself emerges out of an experiment that very much reflects a lot of Karl's thinking. During the pandemic, a number of workers across the country, somewhere between 20 and 30, formed what they called the Congress on Essential Workers. This included Chris Smalls, but it also included radical Black women like Adrienne Williams, who is an Amazon organizer in the Bay Area. It included Instacart drivers and Uber workers, but included a lot of people who were forced to work while the rest of us were sort of inside, shuttered from the virus, and who were working doing essential jobs. And what was sort of amazing, to reference what both Sanjukta and Diamond articulated, is that they did not connect to each other solely through working conditions or wages, that they connected to each other through new forms of identity, some of which were class-based, but also some of which were political and cultural. And they built relationships that essentially allowed the emergence of the Amazon labor union and its sort of subversive support for the ALU all over the country over the last many months. And so I want to underscore, as we talk, it's inevitable here that we're talking about redistribution and in the context of labor law, but there's something else that Karl has really beautifully always, and more recently in the work that I've read, never neglected. And it's also something that he embodies, which is that what we strive towards is much more than redistribution, but actually relations and relationships. And that is essentially what solidarity and transformation looks like.
Ingrid.
So again, Carl's former student. I think that's really beautifully put. And I just wanted to follow up because I had a thought also from the woman in the middle. I can't read your. And you talked about, I think that's very true. And I will tell this story about my Labor 1 class when I was in Carl's class, is that without telling us about any law review article, he definitely communicated that he did think that the Wagner Act was a radical act at the time, and that its promise was more than just redistribution. At least that's what I remember taking away from the way he framed the class. But I will say that I always was confused by that, because to me, the Wagner Act does also have a genetic defect from the beginning. And I think what all of your comments were very interesting in thinking about it. And it became something that I continued to think about after I was practicing and interacting with workers in committees and understanding how they understood their own rights in the workplace. But to me, the genetic defect is that the Wagner Act says, we give you wages and working conditions. The rest is up to us.
Yes. And he says that too. In the article. Yeah.
Anyone else? Comments? I just want to say that the way I first came to know Karl's work was actually through graduates of this law school who were working in labor law around the country. And quite a few of the people in this room are included in that now. But in the early days, the person I came to know first was Judy Scott, who I think was with my practitioner hat on, was the most remarkable labor lawyer I ever knew, and was at the forefront of every reform movement of a major union during her entire working life, including at the forefront of thinking through the strategy for the Fight for 15. And I believe that her conceptualization of these issues in the same way that I think Ingrid took it forward and all of the other labor lawyers in the room took it forward was deeply rooted, Karl, in the way you think about both about the law and about labor and about community. And so as I've come to know you, I've come to understand that better. But the reach of your teaching in labor law, and you'll hear from Dick Griffin, I think up on the monitor later today, has been extraordinary and deep, I think, throughout the labor movement. And one of the things that Karl and I talk about is the fact that Northeastern in particular has been a place to educate the future labor law leaders in this country on the progressive wing, and that it is really essential that it continue. I do remember that once when I was dean, that there were conversations among other deans about how labor law didn't need to be taught anymore, and that it has really declined in importance. Even work law has declined in importance outside the teaching of employment discrimination in the academy. And I think that the important role that Northeastern plays in this can't be forgotten, and that it's really rooted in the work that you've been doing all along.
I have a somewhat rare experience among labor lawyers. I'm the child of a factory worker. And I had the good fortune of having the opportunity to get a college education. People in my high school observed that I was better than most and capable and thought I should go forward. I've been working since I was 11 for local merchants. But I did go to college, and then trying to decide between academia and law school. Law school was 3 years and a known debt. And the people I knew at Michigan who were graduate students who got their doctorate were going off to East Podunk. You know, the idea that they were going to be part of a continuing community of active, engaged minds began to be less confident. This is in the late 70s. In any case, I came here for law school. The idea that the faculty here had chosen to take a different tack on how to teach their students. And it was fundamentally, in my mind, grounded in respect. I was somewhat older than most of my fellow students, but the idea that all knowledge wasn't at the front, but as I had experienced as a college student, I was interested in what my fellow students thought because we were all experiencing things for the first time, coming with different levels of experience or totally different kinds of experiences. And in law school, that seemed vital because I'd become a labor activist at Michigan. I came to see some quandaries around that, challenges of organizing drives in the public sector, not just in the private. And my first tort, I was fortunately assigned to Karl Klare's tort class. And it wasn't a baking class, it was for real. It was about conflict between people and their aspirations and power structures. One of the first things he did was take the case book and point out to us how cases were reported. And he made the point, why isn't the person's full name there? The corporate entity's full name is there. Well, maybe, I mean, he revealed to us how the law cloaks the reality of what it's deciding simply in that device. Now, was it done by West Publishing? Maybe, I don't know. But he made the point, think about what you're reading, think about what you're seeing. And I guess the point in the context of relations, as a young person, my father's factory became unionized, probably when I was in elementary school. And it changed things dramatically because workers gained control over the amount of overtime that could be put upon them. And workers who are forced to work massive overtime have less and less opportunity to participate in their communities and even with their families. But the union that came in, that was accepted, had social events for the families. Twice a year, we had big union-based, it was a Christmas, obviously that it was not inclusive, and a summer party, picnic in a public park. Some of that eroded relatively quickly with suburbanization. This kind of core population where people lived relatively close to where they worked in the city. People didn't want to make the trip, whatever. Or sometimes we talk in the labor movement about the problem of success. People began to, all they could get was money, and they too began to pursue money primarily, as opposed to objective. In my experience, the thing employers fight is lack of control. The idea that they have to give any kind of control over the people who do the work. We see that institutionally, the scholarship showed it as how in steelworking, they stripped David Brody's monograph, stripped that power away from the workers, or tried to strip it away. But these struggles reemerge right now.
There's no question about
It's
that.
glorious that it's happening.
They are reemerging and the courts still tip their hat a lot to managerial control.
Oh, absolutely.
You just didn't address what Sure. Just a quick point, or I wanted to quickly address, what's that? Ingrid, sorry. And I guess I just want to make a quick pitch since this is a room full of some practicing labor lawyers, labor academics, and so maybe more to the recent graduates and the labor lawyers, which is that we have to take back business law because there's what's that? Yeah. I mean, because as Karl's work shows, as as your comment demonstrates, the courts did not have to take that direction with respect to wages and working conditions, even based on the text of the act. And they didn't have to do it based on property rights or some of these things are more, when you look at, the debates that are happening in business law, on the one hand, those are ossified as well, but there's nothing in corporate law that says that workers who are, according to Ronald Coase's theory of the firm, are inside the firm. So so there's no conception of property that clearly should say that they don't participate in firm-wide decisions. This also gets exported into the labor exemption case law. And so anyway, that's a little beyond the scope, but so just my little pitch is, and right now in corporate law, there's obviously this big debate about is it all about maximizing shareholder wealth? We have really pretty mainstream figures like the former Chief Justice of the Delaware Supreme Court saying, no, it's not, right? So I think we need to connect these conversations and should not assume that everything outside of labor law, we should question all of that as well, and then bring that questioning into labor law as well.
People on streaming. Yes. What? Tell the people on streaming that they will not be able to hear Duncan at lunch.
Oh, okay, I didn't know
Back
that.
at 2:15.
Okay, so we're about to break for lunch, and lunch is in the Commons, which is the basement room in this building. For those of you who are on streaming, we will be breaking, and we will be back at 2:15.
All right. I'm about to put Dan Danielson, who is on speakerphone, close to the mic. He's had a viral infection. I don't want to overshare, Dan. But so he could not be here today, but he is about to introduce our speaker, our luncheon speaker. Okay, Dan, take it away.
Thank you so much, Lucy, and good afternoon, everyone. I am totally heartbroken that I'm not there as well. It wasn't COVID that was my viral infection, but I can tell you, having spent the last couple weeks getting over it, you wouldn't have wanted me to bring it to the party. I also have to chuckle at the sort of amusing aspect of this introduction, in terms of the fact that it's cobbled together. I've been dutifully watching the streaming of every minute so far and have enjoyed every minute, but I can't see you, who I'm talking to, and I won't be able to see Duncan, who I'm going to introduce. But there's something about all this that strikes me as kind of both funny and also poignant, in the sense of all of the long tradition of events and organizing that has been described so far in the morning, and we'll hear so much more about as the afternoon goes on, both by Karl and by Duncan, from critical legal studies through Intel and ISERP and beyond. And that's that none of those events were about polish or hierarchy or perfect technology, and certainly not perfectly Xeroxed materials, but about people and ideas and progressive social transformation. I came to meet Karl and Duncan in the same year. It was the spring of 1987. I was a first-year law student, and Duncan was on the faculty of my law school. And Karl was one of the co-organizers and a speaker at what was then my first critical legal studies event, which was a conference held at Northeastern in a classroom, I think, that no longer exists. But what was stunning to me in that engagement that year with these two extraordinary men was that they were offering something, and I think Vina was putting her finger on it in her comments in the last panel about Karl. They were offering something that was more than progressive ideas, or more than mentorship. They were modeling a way of being, and what felt to me at that point, for the first time in my life, is a way of life that I felt like I might want to pursue. And I could say some things that sort of epitomized what I saw in these two men, and many others who were involved in the collective enterprises that they were making happen. Those things included an incredible passion for ideas, progressive political solidarity, a community that enabled one to be both among friends, among political comrades, and among professional colleagues all at once. A shared commitment to collaborative activism and collaborative scholarship. Honest and generous critique, sometimes brutal, but always ultimately needed and given with the highest form of love and respect. And all of these things supported on a foundation of an enduring, deep friendship. And I think, you know, no relationship that I can think of except maybe Lucy's and Carl's comes close to reflecting and manifesting all of these values that really became the path upon which I modeled my own career and my thinking. And it was clear from today how many others have similarly done so, following in Carl's path. That Karl and Duncan just epitomize these things. They're collaborators, they're comrades, they're sometimes competitors, they're colleagues, they're trusted interlocutors, they're 30-year plus patrons of the S&S Deli, which is a small deli in Inman Square that they've both walked to for weekly meals for over 30 years, and to a lifetime of friendship. I couldn't be more honored to introduce and honor both Karl in this celebration and Duncan, the Carter Professor of General Jurisprudence Emeritus, who are my intellectual role models, my academic heroes, and my dear, dear friends. One small additional irony is that I won't be able to hear Duncan's speech, but I understand it's going to be recorded.
That's
So
right.
I'm very much looking forward to it. Without further ado, I give you Duncan Kennedy. Thank you so much for letting me participate.
Thank you, Dan.
Can you hear me? Do I, let's see, is this in a, oh, yeah. Can you hear me now? Better? Closer? Like this? Closer. So this is an amazing event, as everyone has said, and it still continues amazing as it goes into the afternoon. I think I have something to offer, which is tales of Karl as a baby, virtually. So, and also I want to characterize him in a way that's somewhat inconsistent with the very powerful group portrait that all of you have given of him. So Karl went to Harvard Law School. He enrolled in 1962, and he was in my contracts class a little before Michael was also later, but in a sort of similar oppositional relationship from the beginning with Harvard Law School. But I didn't know that. So in the contracts class, it was my second year teaching contracts. And as many of you who are law teachers know, the second year you're still barely grappling with that topic. And I was barely grappling with trying to produce my own critical approach to the teaching of contracts. So I had my own materials as accurately represented by one people describing the tactics. We had our own materials. The basic problem was a 150-person classroom. So a wonderful but complicated problem was how can you address and perform for 150 people day after day after day. And the 150 people, you had to somehow find a way to relate to them because there's so many people, it couldn't be one-on-one. And one of my ideas was that I should periodically consult the class. This was a very 1960s thing. I was totally in counter groups, was all that kind of stuff. But the idea was to poll the class, let people comment. But this was such a terrifyingly hierarchically, brutally hierarchical environment that you couldn't conceivably ask people to do that publicly. That would be just unthinkable. So the tactic that I developed was write something. So write something on a page, give me a page in which you say what you think the course is about and how it's going. You don't have to sign your name. It can be a sentence, it can be more if you want. So I actually, of class of 150, maybe this is a moment of still getting going, probably 40 students out of 150 would dare do this, and most of them were one sentence saying, "Keep it up or go back to Russia where you belong," which was actually was a comment that I received in the 70s periodically. Go back to Russia where you belong. So one of these, and this is obviously going to be Karl, so his anonymous page, is my mic still? So his anonymous page was a full page, so it was 2 paragraphs. Meticulously handwritten paragraphs, perfectly organized. And he basically said, the course is about the conflict between 2 general attitudes towards private law and contract law in particular. The 2 attitudes, the 2 contrasting, are a classical liberal one and a more progressive or conceivably radical one in which human solidarity can infuse itself in the design of contract law. So this was actually an amazing moment. So I thought, what's going on here? So what is going on here? Who is this person? Now I didn't identify the person as Karl because he didn't talk in class practically at all. This is a world of gunners.
Yeah.
And a basic problem, a pedagogical problem, was repressing the gunners, which I was pretty brutal at repressing the gunners. And Karl is exactly the bad effect of that. Was Karl was incredibly modest, careful, and earnestly collaborative, understood that the repression of the gunners meant that he shouldn't do what he would never do anyway. So he didn't talk practically at all. And then at some point he came up to the front of the class and said, he gave a little introduction, and I don't remember how his identity was revealed. But at the moment in which he revealed his identity, that began our relationship. That was in probably November or December in 1972, which is still totally alive. So Karl is a lifelong friend, someone with whom I've had deep, deep collaborative joy over all of these 50 years. So, but here's some things about him that might not have come out. So what came out was really Karl. But the things that are missing, here's some things that are missing. Radicalism, Marxism. Radicalism and Marxism. And incredible stubborn resistance to the situation of, quote, late capitalism. He introduced me to the phrase late capitalism, by the way, which just made me laugh as a person with a very different kind of background. So these are factors which are negative energy. So it's not right to understand them as part of his loving collaborative self. This is part of Karl's negativity. So the start idea is the situation in 1972 and the situation today is terrible. The situation is sufficiently terrible so that it's reasonable to be enraged, committed, and completely feeling that something has to be done and to be unbelievably frustrated at the extreme limits of what can be done. And that went all the way from interpersonal relations in the law school classroom, all the way to the question of how you ought to behave in relationship to teachers, all the way up to what you thought about violence in resistance to the regime, which is the moment of the Black Panthers. It's the moment of the slaughter of the Black Panthers in Chicago. It's the moment of the war is raging at its height. So we got to know each other in a context where the basic experience of rage against the system is beginning to orient our work. Now I'm going to jump. Let me see. How long have I talked for? I've got a few minutes. Okay, so let me go on. What emerges from this, 2 things that come out of this are the Marx study group. The Marx study group.
The mic got, you were censored when you said. Yeah.
Marx. So this is in my relationship with Karl, this is again a very basic thing, which goes something like this. Karl was quite serious in his.
When you move.
Oh, maybe back here.
There's something about this thing.
This spot.
There you are.
So Karl. Oh, it's because of the camera. So Karl was quite serious in his neo-Marxism. And by quite serious, it turned out that he was a deeply learned student of Marxism and the co-editor of a book about neo-Marxism, and a book of essays. So he was a collection of chapters. And I was completely and totally a non to anti-Marxist. So I was very deeply trained in I was majored in economics. I had no interest in liberal political philosophy, but I totally believed in the solidity of the basic modes of liberal analysis. So in this experience, the way it worked was, I think we gave each other something that's really amazing. I gave him an incredibly brutal, really brutal critique of his Marxism, of the ways in which it was still tied as neo-Marxism to a lot of basic premises of the classic Marxist paradigm. So I think it could be said that I beat a lot of it out of him. But he turned me into a Marxist. So the end result of this was a common enterprise in which I was in the end, in fact, as I am today, deeply interested in, and I feel myself to be part of the tradition of Marxist, both economic and social and ideological analysis. And he became, by losing his relatively dogmatic Marxism, he became capable of inventing, promoting, and dealing with transformative constitutionalism. He had to make this very complex transition, keeping all the emotional, affective dimension of his being that was revealed in the morning, but with a new analytic, which was the analytic of the possibility of reformist from within, completely hostile to the Marxist tradition he came from. So it's an anti-revolutionary version of the Marxist impulse of total radical critique. So it was an enormous gift. So I got something out of being a hard-nosed, nasty person with Karl, which was I got my own Marxism, and he got a totally new version of himself as a social activist. So that's all I have to say. It's been wonderful. It's so great to be here. I hope it continues on the same line. Thanks for listening to me.
And so here's how we're going to do this. We have a very brief video from Dick Griffin. It's like 2 minutes long. So we're going to do that first. And then then our panelists will come down. We got 2 here and 1 on Zoom, and I'll introduce them and introduce the panel after the video. But so first we're just going to hear from Dick Griffin, who is Northeastern class of 1981 and a longtime union lawyer in DC of counsel at Radoff and Kaiser, and former general counsel of the National Labor Relations Board. So Jacob is gonna put that up in just a minute. And then Ted and Mackenzie, you come down right after that.
I'm a proud Northeastern Law School graduate, class of 1981. I've spent my entire legal career, now more than 40 years, practicing labor law, and was privileged to serve as the general counsel of the National Labor Relations Board during the second Obama administration. Like so many other Northeastern graduates practicing labor law, I owe my career to Karl Klare's inspirational teaching and writing. In my case, that is literal. At the interview that resulted in my first job, the interview looked at my resume, saw that I attended Northeastern Law School, and his first question was, what did you think of Karl Klare's article in the Minnesota Law Review on judicial de-radicalization of the Wagner Act? That question demonstrates the deep impact of Karl's scholarship. It was as a teacher, however, that he truly made his mark. In my era, Karl taught first-year contracts and social theory, and subsequently Labor Law 1, Labor Law 2, and collective bargaining. In each area, he was a deeply learned, unbelievably considerate teacher. In labor law, he conveyed his passion for the National Labor Relations Act and its interpretation, teaching us not just the law, but how it connected to the hopes and aspirations of America's workers. The passion he conveyed has inspired several generations of Northeastern students to enter the field. No single other person in the United States is responsible for inspiring more labor lawyers than Karl. The countless workers and their families whose lives have been bettered through his students' representation are Karl's true legacy. Thanks, Karl, for everything you've done for my colleagues and me. We couldn't have asked for a better teacher, guide, mentor, or friend.
I forgot, I'm so used to wearing a mask these days, I had forgotten I had it on, but now I have it off. So I never really had the chance to be Karl's student, but I have had the privilege of being his colleague for the last 13 years. And as many of you know, he's a very generous colleague as well as a very generous teacher. And so I feel very lucky to have had that experience. But we are joined by, we'll have 3 people with us today who have had much deeper experiences as his students, and I'll be introducing them in a minute. I do want to say, although I was never a student, I did early on in my time at Northeastern, I did join this reading group. There was this sort of informal little reading group where we were going to read some works by Karl Marx and think about their relationship to legal theory. And, you know, it was just sort of a reading group, but really one person in the reading group had thought a lot more about those issues than the rest of us. So lo and behold, you know, Karl's like making little packets of reading assignments for us, and he's like giving us discussion questions, and, you know, so although I wasn't really your student ever, I feel like I got a little taste of the care and love that you bring to that endeavor. And I do think, I love the title of this event, because I do think love is a big part of it. And I want to give a big thank you to the folks who put this event together. And, you know, Vina Dubal said on the last panel that there's like, you know, this really special sort of feeling in the room. And it's really true. I mean, for me, this is sort of unprecedented in these pandemic times to be in a room this way. We all, I think, at this point have developed a very high threshold for, you know, what event we would go to in person, right? Particularly when it's being live streamed and you could just sit there, you know, in your living room and watch it. And it takes a very special person to get us all out. And so you've given us a gift. You've given us so many gifts, but one of the gifts you've given us, the most recent, is to bring us all together for this kind of event, which is very rare these days. So the folks on this panel span really almost all of Karl's teaching career thus far, from his very first years on the faculty at Northeastern up through the pandemic. And so let me just briefly introduce them. I'm not going to, the full bios you've got, I'm not going to give you the full bios, but I'll give you the quick bios and then turn it over to them. So we have Ted Lieberman, who is Northeastern class of 1978, was a labor lawyer for many years, and more recently has been a documentary photographer. We also have Sukti Dital, who's, can you, here, can we get to, yes, can you, yes, wonderful. Hello, hi Sukti. So Sukti is Northeastern class of 2006, and she is currently the executive director of the Bernstein Institute for Human Rights at NYU Law School. And then we have Mackenzie Spear, who is Northeastern class of 2020, and currently an Equal Justice Works Fellow at the Legal Aid Society in Chicago, working on housing issues. And the way we're going to do this is I have a couple of rounds of questions I'm going to ask. And we're going to kind of go back and forth among them. So they're going to, even though we're going to kind of be going back and forth to the video, everyone's going to stay up here the whole time. And we're going to leave plenty of time for discussion because I have a feeling there are many people here today who also have experiences as Karl students that they might want to share. So the first question, and we're going to go in chronological order of graduation here. So starting with you, Ted. First impressions of Karl Klare and how, what effect did Karl have on your time in law school?
Yes, thank you, Rachel. By way of introduction, I came to Northeastern to be a labor lawyer. The mine workers have a song, "Which side are you on?" I was very clear which side I was going to be on. I had come up through the New Left, was very active during college and after, and decided the best way I could do something with my life was work with the institution of labor unions. And so after my first year, I show up for the class in Labor Law 1. No one told us who was going to be teaching it. And we walk in and there's Karl at the front. And he looked eminently presentable and, you know, was very nice and pleasant. And, you know, so the first impression was positive. And I think he, to me, looked a little lost at that point. And I invited him to come out for a cup of coffee. And we found that we had progressive backgrounds in common. As the course started to go on, I found that Karl was teaching a little differently than most of his colleagues here at Northeastern. I think he was the only one that gave us Xeroxed 4 pages of chapter 1, volume 1 of Das Kapital, so that we would understand the relationship between use value, exchange value, and surplus value. I didn't see that in Cox and Bach. But Karl was not, he did not push any philosophy or theory. He said from the beginning of the class, he was happy to have discussion and argument and opposing views. But he had a good way of raising questions. Let me give you one example. He's teaching duty of fair representation, an important concept in American labor law. So we're reading Ford Motor Company versus Huffman, 345 US 345. Right? And it's a fairly straightforward case. A group of employees who Ford Motor Company, who are in the bargaining unit, are suing the union and management because there's a clause in the contract that said that if you were a veteran of the US Armed Forces or the Merchant Marine during World War II, you would be entitled to company seniority for that time, even if it was before you had become an employee of the company. And they defined the war as commencing after June 21, 1941. And so the question was, did the union breach its duty by giving seniority to people who in fact had come to become employees of the company after serving in the armed forces when there were others who had been with the company longer. And the court said, Yes, this was fine. They used the words, there's a wide range of reasonableness that's afforded to the union and the company to take care of situations when there are really competing claims and purposes that are being served by certain provisions of the contract. But that made sense. Everyone's fine with that. We understand that. And then Karl asked the question, by the way, anyone know what's the significance of after June 21, 1941? And class is sort of looking around. Well, Pearl Harbor? No, that was December 7th. Henry Ford's birthday, Walter Reuther's birthday. Yeah. And finally it comes out. June 22nd, 1941 was the day that the German army invaded the Soviet Union, notwithstanding the peace pact that they had between the countries. And it was the day that most of the communist parties and leftist parties around the world shifted their line from that the war between France and the UK and Germany was a war between imperialist powers to this was the Great War to defend socialism and the rights and freedom of the Western world. Why was that in the contract of the Ford Motor Company? Because the Communist Party of the US and other leftist parties were very strong in the United Auto Workers at that time, as well as other unions. And they somehow picked that date to start with the seniority as opposed to any other date. Not mentioned anywhere in the Supreme Court case, as you might imagine. And it was not a big deal in the course, but I remember it, and it was, I think, a way of one of many ways of Karl reminding us that there's more to these court cases than meets the eye and that are talked about in the cases. Oliver Wendell Holmes once wrote that the lifeblood of the law is not logic but experience. And to me, in this course, Karl was really saying, and we were learning that experience is not simply the dry facts of the case, but it was also about politics and power and strategy and tactics and cunning. And this would be a theme during, I think, the entire time. And it was a lesson that served me well in my subsequent career.
Thank you, Ted. Let's go to you, Sukti. Tell us about your time as Karl's student here at Northeastern.
Great. Can you all hear me okay?
Yep.
I have my head is probably this gigantic thing on that screen. I am so sad to not be there in person. It was truly, as you said, Rachel, one of those moments where you felt like this was something worth coming out for, and then my partner tested positive. And so here we are, but very, very grateful for technology in this way to be here with all of you. So especially on this panel, because Karl, I can see the back of you, but your spirit and your humility and kindness is always with me. And so to be able to just have the privilege of reflecting on the ways in which you have shaped me and countless other students is a total privilege. So thank you to Lucy and all the other organizers for this gift. In terms of the question of when we first met Karl and how did he shape law school, Karl was we were all waiting to take Karl's classes. He was a bit of a legend. He was like a rock star at the law school. We knew he was this world-renowned critical legal theorist, and of course his legacy in labor law. And he was known to just be like a cool human. And so everyone kind of was clamoring to get into his courses and to absorb a little bit of him. And I mean, he was one of the professors that drew me to want to go to law school, and particularly Northeastern. What was just mentioned by Ted, I was nodding my head, because when I think about my experiences at Northeastern, and I think even more poignantly about my time with Karl, was this constant questioning of background rules, that things are not just what you see within the case summaries and within the briefs, but there is a whole political power play happening in the background. And while I thought I understood that even when selecting Northeastern, it wasn't until I became his student and started really excavating some of the decisions that we were reading together that even came more to life. And now, my gosh, 15 years later or 16 years later, I see it even more clearly. So I was fortunate enough my third year, so it was the spring of 2006, to be in 2 classes with Karl. So it was like a buy one, get one free, waited 3 years and got critical legal theory and employment law together. Both of which have shaped my, not only my law school, but really my trajectory in the course of my work, both in human rights and also in labor law and labor rights. But what I remember very, very intimately is the feeling of critical legal theory. It was a seminar, so it was only, and I think it was maybe like 12 or 14 of us in a small room. And I just remember the feeling of that. I'll never forget the feeling of that room. It was safe. There was curiosity. There was humility. We didn't kind of come with egos or titles. And I think I really learned from Karl how you model that practice. And when you model a certain way of being, that naturally gets absorbed in the energy in the room. And that's how it felt when we walked into that room, I think twice a week for an hour and a half. It was a really grounding community. And Karl was able to create a space for us to not only reflect on some of the decisions we were reading and some of the law review articles, but also to think critically about what might be possible, to not be so locked into this notion that law was fixed and that these systems were fixed. And so in that, we read excerpts from Nelson Mandela's Long Walk to Freedom and a number of South African Constitutional Court decisions. And through that process, there was a probing by Karl as a professor, but it was done gently. And it was done, again, with this sense of humility and kindness and an appreciation that even though we didn't have decades of legal expertise and we were not, labor rock stars, we mattered. And our role was a really powerful one that we would eventually play in this project that is the legal ecosystem. And I think Karl always saw that, even though we didn't necessarily see it for ourselves. And one of the things I remember a lot about that class that sits with me is while we were learning about Mandela in particular, this notion of what it means to be inside and outside of systems. What does it look like to practice law, to practice in a system that is built for to silence, to oppress, to marginalize, to serve as a weapon of marginalization, and yet still Mandela engages in that and also supports outside movements. And so think really, really creatively about how we could take this tool that we were gaining and be able to build and work together to build a more just future that I think all of us were really sharing at that time. So with that, I remember it was the first time I'd actually been introduced to the concept of Ubuntu and this notion of interdependence. And that has stayed with me. I never understood how powerful it was and how I was really motivated as my animating principle, this notion that I am because you are. And it was in Carl's course that I really started to think about that. And at graduation that year, I remember speaking about the power of Ubuntu and the privilege and responsibility that we as attorneys carry in interpreting words. And what does it mean to be one who acts, who works through the work of translation and presentation. And there was other concepts that I really didn't understand. I didn't understand horizontal application. I'm sorry, Karl. I didn't fully understand how animist property was until, years later. But those seeds were planted, those seeds of kind of understanding the power of background rules, who gets to be in a room to speak, who doesn't, what does it mean to engage in a system that you know is fundamentally unjust, if your desire is to create a more just system and redistribute the privilege and power that you may have for the greater good. And these are concepts that have stayed with me and continue to stay with me many, many years later. And I would just end by saying on this point that, really marked by the critical legal theory course, a couple of years later, I took a solo trip to South Africa to really retrace or pretend to retrace some of Mandela's major footsteps. And it was that book in my hand, that was a very big book to travel with, but to take Long Walk to Freedom throughout South Africa and just learn by doing. And so I want to thank you, Karl. I didn't realize it then, but that was really the beginning of a lifelong career in human rights and particularly grassroots justice, and also a lifelong friendship. So thank you, and excited to be here.
I think let's try to hold applause, I think, till the end, just because we're going to try to go back and forth and sort of have this be a conversation. And but we will have a chance to applaud all of you at the end.
Well, thank you for having me. I'm honored to be here, Karl, and everyone else who invited me. I think, the first time I saw Karl was when he walked into a room in the downstairs to talk to us about the Northeastern Charter and how we were going to be involved in the school. And when we were talking about our first meetings with Karl, I thought about how he always encouraged us to be kind of participants in the law school in learning and not consumers of this education. So the first time he walked into Doxer, set down this charter and really asked us to step up and be part of the governance of this school. So I think in the same way folks have talked about in theory, how he asks us to build more participatory systems. He was also doing that every day here. As soon as we walked in the door the first day, said, you're an important part of this. You're a participant in your education here. So of course, then he also always volunteers to give a lecture for the National Lawyers Guild every year. And I went to that and he asked questions that no other professors in my first year were asking me. I think we did a simple torts case about a car crash. And something I remember both about that lecture and his labor law class is watching him walk a group of people to a binary conclusion and then just blowing it up for everyone. So it would, we'd walk together on this logical conclusion that the judge got to. And then he'd ask a question like Ted said, well, what is the state? Or what role does insurance play in this system where we have a car crash? And what would that mean for the disability rights community if this was insurance was the solution to this supposed binary conflict between the person who caused an accident because of a medical emergency and the person who was the victim of that accident. So even though I had no intention of going into labor, I signed up for Labor One. I got to watch that again and again, Karl walking us to a conclusion and then offering us midway through the class something that would, cause a kerfuffle and everyone would have to deal with it. And I enjoyed those classes so much because it was rigorous. One of the hardest exams I've ever taken was Labor One. And Karl would do all the scaffolding we needed to get the law And then he would invite us to actually think about what was happening in context. And for me, that gave me the opportunity to do all the learning that I wanted to do at law school. And instead of talking after class about the criminal legal system and what's actually happening with my peers, I got to bring that conversation into class. What does labor law mean in the context of work, in the context of working people in this country? And it went from being a debrief with my friends after class to something that was given space in the classroom. So in that way, I felt like Karl took us seriously as learners. He took movement seriously as part of what we were engaging with when we were talking about the law and lawyering. And even though I don't do labor law and I'm not an academic, I use that every day in my practice now, which we'll have an opportunity to talk about later. The real gift that Karl gave me, though, was American legal thought. We started that class right before the pandemic, and it was a small seminar class where Karl has meticulously cut out sections of law, but also of theory. And we talked about, England in the 1700s, and we talked about what's happening today. And he managed to create this puzzle that fit together into actually thinking about what we were going to be participating in when we left the law school. And in March of 2020, that project suddenly shut down, and we went online. And if anyone, most people here have probably had interactions with Karl and know how important an individual conversation with Karl is, having time to walk in the hallway with him, or, we lost all of that all of a sudden. So we had the opportunity then to start meeting with Karl weekly, a group of us, and just to see how he was doing. He'd check in on us, and we've talked every week since the shutdown in March. Again, he takes us seriously as a group of newer attorneys who came to Northeastern with work experience, with different identities, and wanted to hold those throughout. And I think Karl's classroom allowed us to do that, allowed me to do that. And he respected the work that I'd done before I got to Northeastern in a way that sometimes felt erased. And then he took us seriously as a group of young people who wanted to do not necessarily academic work or labor law, but wanted to practice and have rigor to our practice, but be day-to-day lawyers, most of us in legal services. So I think, Karl, you created a space where you allowed us to do the learning that we wanted to take out into the world, and you didn't see that as less important than the work that was happening in the academy. And I'm very grateful for that.
I'm not going to police your clapping, I decided. But wait, before we go on to the next question, I just have to ask you a follow-up question, Ted. Am I right that when you encountered Karl in the classroom, that was his first week teaching?
That was his first day teaching law school, although if I remember correctly, and I may not, Karl was doing some teaching before he even went to law school. Yes. Karl clearly showed a practiced, I don't want to say patter, but an easy way speaking to a large group of people. But this was his trial by fire in law. And we liked it, and he obviously liked it as well, because very shortly after that class, I had the privilege of being a co-op. I was a co-op clerk at Siegel Reutemann, where he was still an associate. Thank you. And we talked a lot then, and I was interested in being an associate in a law firm like that. And he, by contrast, was interested in being a legal professor at a law school like this. I'd like to say we traded places, but we didn't. But I felt like my experience with Karl had prepared me well for a career in a labor law firm.
Right, there you have it, Karl's first day of law teaching. And so Mackenzie, you alluded to this a little bit of sort of what I know it's a shorter period of time post law school for you than for some others. So actually, maybe we'll start with you. We'll go maybe in reverse order this time around. And so, how has Karl shaped your time since law school, either in the sense of sort of an ongoing relationship, or you know, sort of what you learned and how does it affect what you've done since? That's a question for everybody.
So I am an eviction defense attorney in Chicago, and I mostly work with people who are living in subsidized housing. So if you are evicted, you also lose a federal subsidy. So a government benefit that helps you pay for your housing. And you can explain, I can say I do eviction defense, but I think a way that Karl might talk about it is I'm on the front lines of when it's moral to remove someone from their home. So we talked about that a lot in American legal thought. The idea that law is in some ways a marker of what is moral or right. And so when I think about my clients and how the law thinks about when it's moral for someone to be removed from their own home, that's why I go to work every day. This idea also helps me conceptualize how to talk to my clients about power and the courts. So if I can understand that maybe my client doesn't agree with the law's idea of when it's moral to remove them from their own home, and I disagree with how the law thinks about that, I can meet them where they're at a lot quicker, right? I can say to them, this isn't fair, but this is how the judge is going to think about it. And that's why we need to make a plan based on how this is going to go. That tool for me crosses identity. Most of my clients are Black women. I'm a white woman who's highly educated. And I can cross that boundary really quickly by saying, I don't think this is fair. And our court system isn't necessarily fair, while still acknowledging the power that law and the courts have. So I think in a roundabout way, American legal thought has given me tools to kind of be rigorous about the idea that the court system and laws are moral judgments, but they're not necessarily ones that we share, and they can be contested. Another thing that comes up in my work a lot is just the kind of binary thinking that happens in my own office. So I find some of what folks were talking about earlier with the transformational constitutionalism, the idea that this is all kind of contested and it's a discourse and we need to be using language and ideas all the time through the law to make change. I feel like in my legal services office, there's often a discussion of this is the way the law is and this is the way the law isn't. So a lot of the work that I do to bring that idea out into the world is through my case acceptance meetings, saying, I think there's actually room to move this. I think there's a reasonable interpretation that this protection could be applied to this situation. So I'll give a quick example, which is there's a law passed in Cook County. It's called the Just Housing Amendment. And it says that you can't discriminate against someone in a housing decision because of their criminal history, so arrests and convictions. And the regulatory body that's in charge of enforcing that has mostly thought of it as you can't deny someone's rental application because of an arrest or a conviction. They've issued a lot of guidance about that. It's really thought of as like a front end entry to housing opportunities. I've been using that in eviction court to say you can't evict someone because they've been arrested. So a lot of times in subsidized housing, all these background things are happening where the Chicago Police Department reports arrests at subsidized address to the property owner. So if you're in subsidized housing, you're more likely to have a notice of termination for an arrest that comes up. So why are they allowed to make a decision based on an arrest record to remove you from your home? And so reasonably you can interpret, you can't make a housing decision based on an arrest or a conviction to also mean you can't evict someone for that. There's a lot of folks in Chicago, even in my world, who are on the tenant side who say, well, this was all about entry into housing. This was about application. That's why this was created. But if you use it in court, you talk to the right judge about it, you get a good ruling, and you build that out. So there's nothing that says we can't be doing that. And so I think that's part of what Karl is talking about, is that we have all these small experiments where we're pushing to make the world more just with tools that maybe folks didn't think were supposed to be that broad or that revolutionary or forward thinking, but can really be powerful. I also want to say about the Just Housing Amendment that this was an organizing effort by formerly incarcerated people to build this into Cook County law. So it came from the movement. And I feel like one of the things that I learned from Karl's classes is because we're lawyers, we have to think about and be responsible for the arguments we're making. And I feel like one of the things I can be proud of is moving with the people who passed the Just Housing Amendment to try and expand their vision of what's fair in Cook County. So taking what they built, which is a powerful tool, and trying to be a part of enforcing that. The other thing I think I want to note about how my work is influenced by Karl's kind of teaching is how I process my role as a new attorney. I've only been practicing for a year and a half, and I work in what I will fondly and not fondly say is like the Wild West of courts in Cook County. I work in eviction court. It's a summary proceeding, cases fly quickly. And I think I could internalize a lot of the losses and a lot of the, my clients are already up against it. They're up against bias. They're up against the structures that have been created to make it easier to evict someone than it is to file a claim for conditions issues. So when I go to court, knowing that gives me the context that I need to keep showing up even through the small and the big losses. And to think about separating my reflections about what I need to learn and grow in from getting a no from a judge. And so I think it's been a powerful tool for me to be able to feel resilient, but also feel like there's a lot that I need to keep learning and I want to build those skills. But it doesn't necessarily mean that I'm going to win every time or the right argument is the winning argument. And that will carry me a lot longer way than feeling like if I don't win, I should sit down and not try that argument again.
Thank you, Mackenzie. Sukti, why don't we go to you? So what effect has Karl had on you in the time since you graduated?
I feel like I could go for like 10 hours, so this one's going to be hard. I also just want to state that I have a 3-year-old sleeping upstairs and I'm praying to anything that's auspicious that she won't wake up, but if she does, you might see me zoom off and zoom back in, but hopefully not. What I think about is the month of April, and the month of April, which is what we're in now, has proven, as I was thinking about this question, to be a pretty auspicious month for my histories with Karl and Lucy. It was in 2010 April that Karl and Lucy were at an alumni event in New York City, and I had just come back for a few months having worked. I was working in India. You heard this morning from Jayashree Satpute in the first panel. She's a very dear friend and someone I've worked with for a number of years. And we were both working at a local human rights organization at the time, and we were doing a ton of social and economic rights litigation on issues of housing and health. And when I was back in the States for a little bit, I ran to this event because, again, Lucy and Karl are still the rock stars. And so I thought, oh, I can see them in person. This will be so wonderful. Little did I know that since the time I had graduated in 2006 to 2010, that ISERP, the International Social and Economic Rights Project, had been established by Lucy and Karl, and they didn't know that I was engaging in social and economic rights litigation in India. There was some time for which we were not in touch. And so I remember being at this bar on the Upper West Side, and it was one of those, again, auspicious moments of sliding doors where it was like, we were at the right place at the right time. And I learned that in 2 weeks' time, they were going to be having the second convening for ISERP in Bogota. And my colleague from that Indian Human Rights Organization was going to be attending. And it was just this beautiful synergy. And in the classic way that Lucy and Karl managed to make things happen, in 2 weeks, I was on a flight to Bogota to serve as a rapporteur for this convening. And that was, again, another marker. It was an opportunity to be encased in and part of a larger global community of advocates and academics and judges who were thinking very, very critically about what it meant to advance social and economic rights, and to do so in a way that tried to disrupt the silos that are often calcify when we get into the legal space, where the academics speak to the academics and the practitioners speak to the practitioners, and the judges, I don't know who you speak to, but the judges are with, their own community. And so you find yourself not being able to have that cross-learning. And ISERP really, really strives to disrupt that way of being and doing. And it's been more than a decade now of being a part of this really special community that is stewarded by Karl and Lucy. And it was through this work that, after a few years of continuing to work at that local human rights organization, that Jayshree and I and another women human rights defender started to really feel this sense that our approach, this glorified kind of public interest litigation, this opportunity that India had, this very expressive constitution, we were litigating cases around abortion and maternal death and eviction, and we were getting these victories in the courts. And yet, as Jayshree mentioned, we would go back into those communities and we would see so little changed in the material lives of people. And it was this real sense of, what are we doing wrong? What are we not doing? Who is not part of this conversation? Who are we failing to listen to? And how can we better leverage our privilege and power as attorneys to create a different way of doing? And it was a lot of conversations with Karl and with Lucy and with the ISERP folks to really think about, could we imagine and dream of an organization that might, in a small way, be able to address some of those gaps? And our first presentation as a group, kind of launching the idea of Nazdik, was with Lucy and Karl sitting in the front, just like I see the back of their heads, but if I was sitting up there today, it would be the same thing. I'd be looking at them. And we created this, what we thought was a very snazzy presentation. And I would be mortified to go back and look at that presentation now. But, we introduced this idea, and it was that sense of, we appreciate you, we see you, you are learning with us. We will share the knowledge that we have to kind of guide and advise you in this process. But it was 100,000% do it. Like, we're with you. And that sense of accompaniment is such a gift. And had it not been for Karl, and had it not been for Lucy and others to kind of stand with us, I really think that we wouldn't have felt the kind of confidence to be able to go forward in the ways that we did with the organization. And again, I think it was April or March of 2016, Lucy and Karl came to India with other ISERP members, and we hosted a convening in Delhi. And it was it was so special to be able to take this community into one of the communities that we are working in. They're local artisans. It's called Katputli, which is these wooden. They work with wooden puppets, and they are indigenous to Rajasthan, but have been living in this informal settlement in a very expensive part of Delhi for a long time, and they are constantly under the threat of eviction. And it was in conversation with the ISERP group and with our communities, and being able to see how this organization that we had built, that was really centered on, again, disrupting silos between who gets to speak, who gets to engage, what does it mean to be a community engaged in your own justice struggle. And all of that felt like it was coming together in that way that we were thinking about in critical legal theory, about inside and outside activism and background rules and dreaming of different ways of trying to do this work. And so I will never forget that collision. And it has really stayed with me for many, many years. And since then, I have moved back to the States and am now working at NYU at a center whose focus is really around democratization of law and this idea that we should be thinking again very critically as attorneys and those in the legal profession about how do we step aside? What does allyship mean? What does it mean to redistribute legal power and create an opportunity for those impacted to engage? And so all of these moments have kind of built on each other. And so I am so deeply indebted to Karl for his accompaniment and vision and support. And Karl, you are such a supporter of Nasdaq. So quietly, every year, every few months, you bring us into these conversations and conferences, and I cannot express enough how much that means to all of us. And I will just end with one personal story. That in 2015, again, it was April, my partner and I at the time, my fiance at the time, were we were planning a wedding from India in the States. And it was, my partner's an atheist and I'm more spiritual. So we were going to have we weren't going to have a religious ceremony, and we wanted to have one that was really rooted in the senses. And so earth and fire and water and air. And we thought of who would we want to officiate? And we thought, and it didn't take very long. And I turned to Vivek and I said, well, what about Karl? And he was like, Karl, your professor? And I was like, yeah, and my friend, the one that we go to ISERP, and he's just this legend. And he was part of Transformative Constitutionalism. And my partner is also a human rights advocate, and it was a no-brainer. And so in April, I think 20th, I sent you an email, Karl, and I was like, will you officiate our wedding? And you generously said yes. And I'm sure you didn't sign up for all of that. Little did you know in 2006 you'd be officiating a wedding, but here we are. And you did it beautifully. And you were there witnessing at one of the most important moments of my life. So thank you. And here it's April again. So I do think there's something about April and Karl. And so thank you again, Karl, for just being such a wonderful friend through all of these twists and turns.
I just want to say Suchi sent a wonderful picture from her wedding, and actually Mackenzie sent a screenshot of the Zoom group, and we didn't quite get our act together to put them on the screen, but I think we should, I just want to encourage people to go dig out your pictures, Karl, from various stages of life. I think we should do something with them. I don't know what we're going to do, but you're all on notice here. Go to your archives and try to find them. We'll send out an email about it or something. So Ted.
Thank you. I have to say, I feel somewhat envious of my two colleagues on this panel who got to experience Karl's teaching and friendship at different times and in courses and in issues beyond just labor law. where Karl had been able to think more about these issues in a general way and in the context of torts and contracts and constitutional law, and not just limited to labor. So I feel like, you know, they got to experience all 9 of Beethoven's symphonies, and I heard one of the early overtures, and it was a good overture, and I appreciate it. I feel like I should really go back and listen to all the. I mean, and I also think I need to mention that as influential as and important as Karl's teaching and friendship has been to me, that there were other professors at Northeastern who were also extremely helpful and important to me. And I'm thinking particularly of Dan Gavelber, who was here earlier, Steve Subrin, and Judy Brown, who hopefully is watching the live stream or will watch the video later. But the 4 of them can be thought of the 4 horsemen and women of the apocalypse, and help make me who I am. That's unfair to put it on them, but in terms of, you know, sort of this meta, how Karl influenced my life, I think I would have given different answers at different times, and I think Karl would always say that you have to understand a phenomenon or an idea or an institution, and in the particular time and context that you're dealing with. We're all at a time when we see a horrifying war in the Ukraine. We see a global pandemic that has killed tens of millions of people, including 1 million Americans, hundreds of thousands of which could have been prevented if we had had competent leadership in our country. And we are dealing with, possibly for the first time in many, many years, the rise of effective assaults on democracy and basic human freedom in our country, as well as other Western countries. And it made me think that, you know, the last refuge of a lawyer is to quote somebody else and then cite it as precedent. And so what I thought about in terms of Karl was the poem by W.H. Auden entitled September 1, 1939. That date, by the way, you might remember, is the actual date of the start of World War II, not June 22nd, 1941. But the poem is about the despair of the start of the war and all the woes of the Western world. But at the very end of the poem, Auden writes the following: defenseless under the night, our world in stupor lies, yet dotted everywhere, ironic points of light flash out wherever the just exchange their messages. May I, composed like them of eros and of dust, beleaguered by the same negation and despair, show an affirming flame. When I think of Karl, it's not just that he was a good teacher or a great teacher or a good scholar or a great scholar, but in all of his endeavors, in his support for students, in his support for social justice, and in his generosity of spirit, then and since, he has shown himself to be one of the just of our era. And as despairing as we may now be, his example encouraged us all to show our affirming flames. Thank you, Karl.
So I'm going to give you three a chance. If there's anything that you sort of thought of when someone else was talking, or that you want to ask each other or anything before we open it up to the audience. Does anybody have anything they want to add or say or ask? Open it up. Okay. Let's open it up. What do you all have to say? I'm sure there's a bunch of other former students of Karl's in the audience here. You don't, if you can talk loudly, you don't strictly need this. The mics will pick you up on Zoom. Anyway. Yes.
Hello, Ryan Quinn. I'm class of 2019. I'm an associate at Siegel right now. We're so proud of our link with Karl there. I wanted to say, I could say dozens of stories about Karl, but I will try not to. I just want to mention two things. One is that in his labor law textbook, something I'd never seen before in a textbook in 20 years of school, which is there would be a story about something that workers did, and then a sentence that says, please take a moment and think about the courage that it took to do this. And I think that first, everybody did. Everybody did, in fact, take a moment and think about that, even though they had hundreds of pages to read for other classes. And I think that that is such, to me, it's the perfect example of how Karl teaches and how he connects what you're learning with what the actual stakes are. And I did always love that when I'd come across that sentence in a book that he had written for Labor Law 1 or 2. The other thing I wanted to say is Ted mentioned Ford Motor Company versus Huffman. And I recall another lesson that Karl imparted in 2018 that also is sort of the classic Karl teaching style. I think we were discussing the duty of fair representation, and probably every labor lawyer who's ever dealt with a DFR case has quoted the language Ted quoted and has said something, there's a line about the complete satisfaction of all is not to be expected. That's in every brief that's ever been written since 1953 on the issue. But after we went through that, Karl then wanted to get to the stakes of what was being discussed. And so there's Mr. Huffman, who I guess had not been in the service and did not have his seniority, but those aren't really the stakes. And through a very effective use of a series of questions, he got us to the point of realizing the stakes of this case are that none of the women who are working in the plants have any seniority. And that's what the case is about. It's not mentioned at all. But of course, there were, the unions win and good, and every lawyer is going to cite that language, but I can't cite that language without thinking, am I doing the right thing? Even though, unions my clients, and obviously they're right, they're never wrong. But, is this the right thing? And that's, I don't know, that was the gift of taking Labor Law 2 with Karl. Thank you, Karl.
Thank you. Others? Don't be shy.
Maybe I'll jump in just as we're waiting. I think it was someone talked about the student charter, and it just gave me just wonderful flashbacks to when we were a student and thinking about, I think, Karl, one of the things that I really I appreciated from you is how much care and intentionality you have put towards how Northeastern Law School has structured itself, the ways in which we think about participation and representation in the way in which the law school functions, and that sense of pride that you have shared with all of us about your time at Northeastern, and the way in which that scaffolding and infrastructure so deeply connects to the spirit and the being of an institution. And it always felt a safe place to go to your office when it felt like some of the aspects of the law school were changing, and some of the spirit of its attempts to be egalitarian and its attempts for participation were naturally being challenged. And to feel as if it was not only like a place of present space, but you would give us that historical context about how we came to be. And I think that I just really, really valued that so much as a student, and think very critically about it now when developing kind of collective documents and collective agreements, because that practice of co-creation, that process, irrespective of if it gets enforced and irrespective of what may come, that process of collaborative creation is just so powerful. And so I just want to, I chuckled when I heard the student charter because I know how passionate you are about it, but I also understand why you are so passionate about it. So I just wanted to just add a comment about that.
I say he shows up at faculty meetings waving the the charter as well. Like, I think he carries it around in his pocket all the time. Pat.
I just wanted to say that I suddenly started counting up the years I have known Karl, or known of Karl, because I think I knew Karl before he, before we became colleagues, well before we became colleagues, because I was in Karl's law school class. I mean, we were actually in the same section. And at that time, for any of you who've seen the movie, The Paper Chase, it was filmed while we were in law school. So it was like big amphitheaters with hundreds of people and a professor who stood at the top of the class and yelled at you, or actually in those days, women were 8% of the entire class. And I think ours was the last class that had powder puff days, where they would actually throw powder puff questions at the women. They would call on you once a month, and it was just, there were very few people I remember from my law school years. The reason I remember Karl is that he was so respectful, but he pushed back. He created a space for his beliefs, and for those of us who had beliefs that throwing powder puffs at us was not the appropriate thing, or throwing chalk at us was not the appropriate way to handle students. So even as a student, Karl was an activist, and as a student, he was also a teacher. And so I count myself among his students to this day.
So I'm Dick Griffin, class 81, and I've known Karl for a long time. And we've had a series of conversations over the last 40 years where we've identified stress points at the law school, where we recognize that when I arrived, and for many, many, many years after, I hope it is still the case today, we were the #1 public interest law school. True. But there was tension as to what direction the school was going to go. And would we be just another pretty good law school, or would we inspire and celebrate the kind of passion that you've heard about from these panelists and from others about, and would we be creating lawyers who would leverage their abilities to improve the world, improve the environment, improve the condition of labor? And Karl consistently helped me and others when we talked to him about it, about what do we do, what's happening at this law school, how to think about it in the context and in the moment it was in. And I think to the extent that we continue to be a law school that promotes social justice, a law school that celebrates as opposed to simply tolerates diversity. I can say from my experiences and my conversations with Karl that we recognize and own a huge debt of gratitude because he helped us to shape the arguments and to make the decisions and to decide when to push and when to wait. And the wheel is still in spin, obviously, but he's helped to guide it. I think he's helped to guide the law school to stay in a good direction.
Hi, I'm Sarah Heidemann, class of 2016. And I came to law school here because of the labor law program. Emily called me, and I don't know if Emily's still in the room. Emily's there. And one of the things she sold me on was Karl, although I knew Karl about you before, long before that call. And the story that I want to relay, so right after law school, I took a job at a labor law firm, and one of the first questions that I got asked at that firm was, would I be willing to defend a union, even if I thought they were wrong, or even if, I thought the individual worker was right. And then about a year later, I started working at a national legal civil rights organization where I still work. And one of the first questions upon wanting to work with unions at that civil rights organization I got asked was around, would I be willing to back an individual worker within a union context, if they were going against their union, if we were to co-counsel something together. And so I pretty quickly realized that there was this gulf that, I hadn't had to experience in my learning about labor and then employment law, that a lot of practitioners saw as a tension between kind of the individual and collective power. And so, I very quickly realized that what I needed to do was fly Karl down to DC to give a presentation in front of my entire office for all of my colleagues about Labor Law 101, so they could see that collective power was something that we could also use in our civil rights work in the context of union work, but more specifically that we needed to really erase the gap between the ways that workers were using the law to gain power in a broader sense. And I have to say that talk has had a lasting effect on my colleagues and has opened up new pathways for us to be able to engage with the labor movement in a more robust way over the past almost 5 years now that I've been at the organization. And I never saw the individual and the collective as so in tension because of the way that I learned the law here, both Lucy, your classes as well. So thank you for that, Karl, and thank you for helping the civil rights movement of DC, the civil rights legal organizations in DC understand why working with unions is absolutely essential and important. Rachel, your admin class has also been very useful.
Anyone else?
Yes. So I'm actually not a former student, I'm a current student. I'm a 3L here. And I'm in one of Karl's classes right now, and I also took Labor 1 in the fall. And there are about a million things I could say about his teaching, but I think the story I want to tell is one of the first days of Labor 1, because my dad actually also went to Northeastern Law. I should remember the year he graduated, but I don't. Sometime in the early 80s, and actually had Karl for contracts. And, naturally Karl didn't remember him. Of course, I didn't expect him to because it was a big class a long time ago. But I just came up to him after class one day, and one of the very first interactions I'd ever had with him, and said, hey, just a fun fact. My dad came here and he had you for contracts. And the next day, Karl came and he had gone through and found his old class roster and printed off my dad's photo to show to me. And I think the reason that sticks with me so much, it just made my day, the day it happened, but the reason that sticks with me so much is I've heard so much about Karl before, but that's really what confirms for me that the unique relationship he cultivates with students. That small interaction just really showed for me that he listens to his students, he talks to his students, he wants to be friends with his students. And that was something that was really, it has stuck with me since it happened. So Karl, I count myself among the lucky many that have learned from you. So I just wanted to tell that small story from Labor One last fall.
So I want to follow up on Ted. I want to ask you a question. So because I think one recurring theme is people coming to Northeastern partly because Karl's here or knowing he's a legend, as Sufti said, right? Can't wait to get into American legal thought. But so you got him on his very first year here, but am I correct that you actually did know of him before you got here? Would you tell that story?
Know him is too strong a term. When I was a freshman at Trinity College in 1968, I was working with the anti-war people there, and I was drawing posters for an anti-war demonstration. And one of the featured speakers was Karl Klare, Yale SDS, I think. And I spelled Karl wrong, C. Who could imagine it would be KK? And I still have that poster somewhere. But I never met him then. A few years later, when I was working in Washington, I met his brother, Michael, who at that time was a well-known, well-regarded writer and researcher on US policy and imperialism in Latin America. But I had no idea that I would later meet Karl and that he would teach me the fundamentals of labor law.
Thank you. So Karl, your reputation always precedes you. So we have about 15 minutes left. Do you want to get in?
Yeah, I want to say one thing. Many of you know that Karl and I are very dear friends, and that we hang out together a lot. I'm sitting here and I'm seeing his head just get bigger and bigger right now. So I want to deflate for just a moment. I hang out in his office a fair amount, and Karl complains sometimes. And one of the things he complains about sometimes is how much work he has to do, how overwhelmed he is about how much work he has. And so every now and then, because I'm a very good friend of his, I try to say, Karl, don't do this. You don't have to do this. You don't have to do this. Now, those of you who have been his students know he is a master of making charts. He makes so many charts for his courses. And I frequently will say, Karl, you don't have to make another chart on this topic. Please, because he's complaining to me. And he will say to me, Lucy, I have standards. That is what he says to me over and over. I have standards for my teaching. So I just wanted to let you know, he cares so much about his teaching that I get his complaints, but you get his wonderful teaching and his wonderful charts.
So,
And I should have added along those lines that when I was a law clerk at Siegel Reutemann, I worked in the library directly across the hall from Karl. So I would frequently see him in the morning making a list of all the cases that he had to do, and he would put a circle and a number in the left margin, and then write the name of the case and what he had to do, and then number 2 and number 3. And he would get up to like number 42 in his list, which impressed the hell out of me that he could keep track of all those things. And I can see why he decided he wanted to be a teacher instead of juggling all of those cases. And I felt the same way when I was a young labor lawyer. But to this day, when I'm trying to remember what to do in my day, I make a numbered list with a circle and then the number in it in the margin, and I owe it all to Karl.
Oh,
yeah, sorry, I just wanted to say I'm Megan, I'm a 3L, and I must be living under a rock because I didn't know about Karl when I decided to come. But I knew him 1L year because he was Lucy's friend, and I was lucky enough to talk to Lucy her civil procedure. And due to the pandemic, I only was able to have Karl virtually, but last year during my 2L year, I took 3 fully virtual classes with Karl, and they were all amazing, highly recommend, obviously. But one of the first memories that I have is during labor law I took in the fall. He added extra work to his plate a few times, but one of them was like after the first class, our discussion of a case was going on, and he offered to write a memo for the class. He was like, please let me write you guys a memo, or I'll send an email clarifying. And I thought we were gonna get like a paragraph, like, hey, here's the answer to this. It was a multi-page memo with so many details and every explanation that you could ever want. And it was just such a testament to who you are as a professor and just how much you care about us, to Lucy's point. I'm so sorry, Lucy, you have to listen to him complain about this, but I can promise you, I truly like my entire year with you, and between the two of you, like the best law school professors and mentors that we could all ask for. So thank you so much.
And I will say, just on the subject of online classes, so Karl is many things, but I'm not sure that a technical whiz is one of them. And my office is right down the hall, and not that I'm really a technical whiz, but I seem to be the on-call tech support sometimes, like his phone or whatever, both Karl and Lucy, I'm right between them, and I get them both with all their. And I remember when we first went online very abruptly, right? Nobody knew what the hell they were doing. We didn't have Zoom even. We were on like Blackboard, I don't know what. And I remember kind of holding Karl's hand for his first class, getting him online and sort of making sure it all worked. He had no idea. And then I kind of tuned in 6 months later. He invited me to a movie night that he was doing for his students, where he was showing labor films. And I tuned in on Zoom, and there he is, and he's like sagging back and forth with the video, and it's all working fine, and he's using the chat, and he really did get very good at it. So he had a growth mindset about it. So yes.
I didn't graduate from Northeastern Law School. I went to Hofstra, but Karl was my teacher in political science classes at Adelphi University in 1969. And he was a new teacher. And I was basically a wet sort of person coming to learn about left politics. And Karl was my mentor. And he was a wonderful, wonderful mentor. He just sort of took me under his wing. And I've been friends with Karl for many, many years, through today. And we've been through a lot together. But mostly the thing that Karl is his passion and his love of teaching. And he's just such an extraordinary person. And I really love him beyond belief, because he's always there. He's a stalwart. If you have a problem, you can go to him. He doesn't always have the answer, but you can go to him. And one of the things that brings me to raise my voice here is the fact that Karl basically taught me the basic reader of Marxism. And I was wondering whether the comments today by, I'm sorry, whether that was revisionist history on his part. But one little anecdote that I have is that Karl was always there, but when he felt a little insecure, once in a while, he would look to his friends for help and assistance. And in 1970, at the height of the Vietnam War, we were in a small little school together at Adelphi University. And we needed to do something. We needed to do something stark and powerful. We get into the paper, and this group of us lefties at school decided we would stop the traffic on the Long Island Expressway with banners and rush hour at 8 o'clock in the morning. And Karl was worried about losing his job at Adelphi. We were all excited about it. And he egged us on. He was scared to death about going out there himself. So we let him sit in the car, but he had to drive. And so that was one of my initiations into the politics that I have now and that Karl continues to have. And I'm just so lucky to be here listening to all of you.
After hearing a comment from the relatively new attorney at Siegel-Reutemann about the phenomenon of duty of fair representation cases for union lawyers, I had to reflect, or have reflected, one of the great benefits of being in Karl's labor law class, because I had him for torts and then labor law, was the exploration of this dynamic between the collective and the individual. I had staked out personal positions. I had been a public non-registrant for the draft and was very active in the Philadelphia anti-draft and anti-war movement. So I sort of had embodied that individualist, you take a stand. To me, the Holocaust meant we had to make choices and we had to stand out. We couldn't just be silent. But then as I worked with the labor movement as a student and becoming a lawyer, the fact that we explored fully, in my mind, beyond points I would have, I think, thought about, the tension that can emerge between an individual and his or her expectations of what will happen with regard to their rights in the workplace, and that union and the authority it has. I've had the opportunity to go to the Supreme Court with a case on behalf of a labor union contending with a very contentious member. It's a profound challenge and I've also seen some very difficult situations where the membership got to vote about a grievance. So you didn't have this insular level of officers who you typically could educate how responsibility meant. And I was comfortable telling people, you have to seriously look at this, whatever it is. You have to think about it and make concrete decisions and then be prepared to back. But later in my career, I got very involved in representing individuals in employment discrimination matters. So I got involved with the employment lawyers community in DC. And they were like ships passing the night. Most of the lawyers that were representing, they couldn't fathom why I would represent a union. For them, like for too many people in the progressive left, unions became sort of bad figures. They weren't fully embracing something that they thought should have been embraced. And it became very difficult. I was often looked to sort of give small tutorials to fellow attorneys over what the union's position would or why it might be that. And particularly around the issue of whether an individual should be allowed to have their attorney involved in a union proceeding. And how difficult it was. And I think it reflects on how people aren't pushed to think hard about those things before they're in the midst of them. And again, I think it was coming earlier, Emily might have mentioned, most law schools abandoned labor law decades ago. It was like it was no longer necessary because the dominant forces decided they weren't going to have anything to do with it. Well, we know they have to deal with it, and we can celebrate it's still happening. But I was so grateful when I confronted some of those that Karl had pushed us to think hard about.
Well, so I just want to bring this to a close here. This has been so wonderful to hear everybody's experiences, and I'm just reflecting a little on my own sort of what have I learned from Karl, and it's a long list. I couldn't go through all of it, but there's two things that I'm thinking about a lot today, partly because of all the things that have been said today that I've learned from Karl, and I think one of them is how to be a teacher, right, and how important it is to bring respect and care and humility into the classroom. It's been a kind of recurring theme today. And the other that I'm really struck by sort of how important it is to forge these networks. It's kind of extraordinary to think about the networks of people, Karl, both his own networks and the networks he's fostered among other people. And I really think those are actually sort of two things, but it's really sort of the same thing, right? It's just being in community with people is really one of the things that you model for us very well. So thank you for that. And thank you to everybody. And we'll have a great break.
Well, Karl, Lisa and I'm Peter Dable. This is Lisa Jakes. Lisa and I are so glad to be here to honor you on this celebratory occasion for being the wonderful human being that you are, and a great friend for many, many years, more than 40 years since we first got together trying to build the critical legal studies movement. And I have nothing but wonderful memories of being roommates with you at critical legal studies camp, strategizing with you about how to promote our line, and always have felt a tremendous admiration for the moral presence that you carry within you, the commitment to an egalitarian society, to a more humane and just world that motivates everything you do and everything you say. And that quality in you brings that out in all of us as well, all of us who know you. It strengthens our own conviction that such a world is possible. And it's a wonderful feeling to have that kind of affirmation and solidarity. And I guess I would say one more thing in this very short video, which is to honor the incredible contribution of your early work in getting critical legal studies off the ground, because judicial de-radicalization of the Wagner Act and the origin of modern legal consciousness was a huge contribution to showing both that law in connection with a social movement can be a ground for advancing human ideals. In the case of the labor movement, in particular, the ideal of workplace democracy, solidarity, equality, true equality. And you also brilliantly showed how the federal courts, in the case of the Wagner Act, were able to absorb the energy of the movement, expand rights, and yet restrict their scope and application in such a way as to capture the movement's energy and form an ideology that ended up, to a large extent, justifying the status quo rather than fostering social transformation. So your work on how that process happens, how a concept of industrial peace can be constructed as important in a way that subordinates workplace democracy and other more significant social change. Your way of showing how that happened through a detailed analysis of cases had a tremendous impact on the critical legal studies worldview, its development of the idea of law as ideology and as a way of legitimizing an unjust status quo. So that double dimension of your work has been incredibly important to me and to the ability of our movement to get off the ground. So I just want to honor you for that early moment. I know you've done many, many things since then that are going to be discussed at this event, but you really made a tremendous difference in critical legal studies, becoming a movement that had wide appeal to people because of the hope that it offered for a better world. Lisa.
Yes, in addition to being Peter's partner, I am with the Hospitality Workers Union, And when I met Karl 30 some years ago, we were in a fight to organize the union at a non-union hotel where we had already launched a boycott. And the American Association of Law Schools was scheduled to use that hotel and violate our boycott. And Karl took the lead, along with a number of you in this conference today, or this event today. But Karl took the lead in helping us try to get the ALS to move out of that hotel. And although we weren't able to get ALS to move, a huge number of you, thanks in significant part to Karl, did move and did picket outside that hotel during that event, and did a number of other wonderfully agitational things during the event that helped lead us to victory soon thereafter in 1993 at that property. And then again, we were boycotting a Hilton in San Francisco years later, and Karl again helped us try to move the ALS. Once again, we weren't able to move the whole organization, but a huge number of you stayed out of that property and picketed, and Karl led a speech and chants, I suspect, from a pickup truck outside that hotel. And I don't think a lot of professors do that sort of thing. So I just want to thank you, Karl, for being my friend and my comrade and for helping my union. Have a wonderful day.
We love you, Karl.
We love you.
Okay, Vivian, Jean, can I invite you guys back up?
And Liz, I'll hand this to you. Thank you.
So I'm Liz Schneider, and I just have to say what an amazing day this has been to hear from so many people and to really see the breadth and the range of Karl's work in so many ways. I'm just thrilled to be invited to be part of this. I have known Karl since the mid-1970s and worked with him in a variety of different contexts, some of which I want to talk about, and talk about what I think are some of the dimensions that today's discussion and panels have really shown about him, that just make him such an amazing and unique person and someone that I really love very much. So I think my first meeting, Karl and I were talking about it last night. I think my first meeting with Karl was on the stage at some event that lefty Harvard Law School students organized. And I don't know whether Karl was still a student then or he had started to teach here. I was working at that time at the Center for Constitutional Rights in New York. And I think it was a panel of sort of both activists and theorists. And Karl talked about critical legal studies, and I talked about my work at CCR with Arthur Kenoy and Rhonda Copeland and William Kunstler. And, you know, through schmoozing afterwards, I think we realized we both had been in SDS, and I heard him speak and I thought, this is it. This is the world I want to be part of. You know, it's like what Dan Danielson said at the introduction to Duncan's talk. It was like, this person is so so clear about loving theory and loving activism and loving social movements. And at that point, I was on the verge of thinking about whether or not to move into legal academia. And it just had a huge impact on me. It really made me feel like if I moved into legal academia, I was already teaching as an adjunct with Rhonda Copeland at Brooklyn Law School, teaching women in the law. But the question was I going to really move? Was I going to leave CCR? Was I going to really move into legal academia? And I was engaged with legal, with CLS. I wrote a piece called The Dialectic of Rights and Politics that was very much tied in with sort of some perspectives about critical legal studies, and also engaged with a lot of other feminist work. And really, it was based on the work that I had been doing at CCR, which was in a range of different fields, but specifically on feminist legal work. And that's what that article really focused on. And it was around that time that there was a burgeoning of basically what developed as the femme crits. And some of the people that some of you may know, some of you may have been taught by them, Mary Jo Frug, who I also want to honor today with her passing in early April. Every early April, it's like another terrible wound. Mary Jo Frug, Martha Minow, Pat Williams, Zipporah Wiseman, Claire Dalton. And that was really a burgeoning group of people who did feel very strongly allied with the left critique in CLS, but also did not feel that critique had really developed a feminist perspective. During those years, I was a lot in Boston. I taught as a visitor at Harvard Law School from 1989 to 2003, teaching women in the law and battered women in the law. And so femme crits was something that was very much an ongoing part of my life. And I would always see Karl when I was in Boston. So Karl at that point, something that I think has not been mentioned, it's hard to imagine that there's anything about Karl's life that has not yet been mentioned today. But one of the things, Karl says, yeah, there are. But one of the things that Karl did at that point was he began to think about international connections. And so he organized a trip to Poland. And it was an amazing trip. Fred Block, who's here, was on that trip, and Duncan Kennedy was on that trip, and Mary Jo Frug was on that trip, and Pat Williams. And Karl was it was a trip to talk with colleagues, basically, lefty legal academics in Poland who had Poland had just, what can I say, become liberated, or that's what we thought. That's what we thought. And Anyway, but the problem was that when we arrived at the meeting place where we were going to meet up first with our Polish colleagues, the first person I believe who walked out of the bus was Pat Williams. And Mary Jo Frug and I were sitting together. It just happened to be, I believe, Pat Williams. And she walks into the law firm of the Polish folks that we are meeting with, and suddenly sees huge posters of Playboy nudes and other pornographic images. Pat comes back into the bus.
That's a damn Saturday Night Live skit.
It is. And Pat comes into the bus and says, "Oh my God, we're in trouble." Well, I won't tell you the rest of the story, but I will say that it worked out actually to be quite an interesting trip with a lot of international dialogue, as was his usual. Karl was an amazing ambassador. And then I was thrilled and lucky enough when Karl and Dennis Davis got together to be then part of the delegations that were 2 delegations to South Africa to work on the constitutional transformation, which were amazing trips with Karl and Frank Michaelman and many, many others that absolutely gave me, I mean, were so moving and so powerful. We learned so much from those experiences. They were totally, when I think back on all my work as a lawyer and as a legal academic, I mean, those 2 experiences were really among the highlights, and not so much, I mean, I think we had amazing conversations, but Karl's thoughtfulness about all of the different groups that were involved. I mean, think about what you are navigating. We are meeting with South African lawyers and activists, some of whom had been in hiding, some of whose, families had been killed. I mean, what did we know really to be able to talk about? And it was the process of it, the opportunity to share at a moment of such intense transformation was just an extraordinary moment. And I want to say Claire, Karl, and Frank Michaelman, and Dennis Davis, who you heard from this morning, and so many of the other people who were involved made that really one of the most important, really, moments of my legal life. So back to FemCrits. One of the things that really was enormously important was that Karl had the ability to really understand that one way in which the FemCrits, and I can't really speak for everyone, but we had some shared views, that FemCrits really, because of our work on feminism, that we were really starting from the experiences of women. And we were moving to the theory which we were developing and wanted to develop in conjunction with CLS, as a product, as a result of those experiences. Karl was amazing because of his experience as an activist and as someone who thought deeply about both activism and social movements and practice. He absolutely wanted to engage all of us and make us a part and have a feeling of solidarity and community within CLS for the burgeoning feminists who were developing, and to try, I mean, obviously he couldn't do this alone. I mean, there were many others who were very supportive, but he really wanted to keep us together as a community. And to me, this community was really for me, and I think for many of the other FemCrits, it was really their and our sense of community that we wanted to be part of. And I want to say that, although many of those people, have done different things now, or sadly, like Mary Jo, have passed away, there is still, I think, a lot of the resonance of FemCrit work that still exists. Many of you here, and believe me, thousands of law students around the country have been taught by people who were affiliated not only with CLS, but with FemCrits. And that the projects that have developed, which might not seem to be directly linked to CLS, for example, a project, Libby and I were talking about it at lunch, a project called the Feminist Judgments Project, which has taken the idea of having feminist law professors around the country in many different fields write new opinions for cases that were horribly decided. And that is an example of saying a different world is possible. And let us write that. And, that has been used in many classrooms. It's an example of a kind of legacy, third generational legacy, in a sense of FemCrits. Now, we're still asking, obviously, God knows today, with everything that's going on, we've not answered any of the fundamental questions about, how law matters, how it ties in with social movements. This is ongoing discussion. It will be ongoing discussion, I believe, for all of our lives. But I want to emphasize two things that I think have been overlooked as possible examples of where both CLS and FemCrits have made a difference. And it's very practical and may sound very boring and reformist to everyone here. But really sit down and think, whatever you may think of what has happened in the Biden administration, think about judicial appointments. Some of these folks, the first public defender on the Supreme Court, the first Black woman, so many legal services lawyers that have now been appointed to federal judiciary. Think about that, because they are people who very well, they didn't all have Karl, obviously, as their professor, but they may have had others because of the work that Karl, that we've been hearing about all day, the work that Karl has done, the networking, the organizing, the dimensions of so many people who have been affected. Some of those people, I know some of those people who have been appointed for federal judges, and some of them were exposed to CLS or to FemCrit teaching. And, you know, when, you know, you just have to think of that as an incredible piece of what's going on now that really carries on the legacy. And the other thing I would say, also may sound boring, reformist, etc., judicial education. Now, I'm somebody I've worked with the National Association of Women Judges, some of the most radical organizing I have ever done. Federal judges, women judges, state judges. When you do judicial training, you really can make a huge difference. I've taught domestic violence because that's one of the fields that I have worked in so many times to organizations of state judges and federal judges, women judges, about domestic violence. And there is not a single one of these programs that I have ever done in which one or two or three of those judges did not come up to me afterwards and say, I just want to talk to you privately for a few minutes, if you don't mind. This is a problem very close to my heart, and I've experienced this, and I don't really know who else to talk to. So I say that just because I think, honestly, given what's been going on with January 6th and Ukraine and all of the other things, that it's very easy for us to think, what can I do? And I think there are things to do. But I want to go back to Karl and close with talking about him. One of the most amazing reasons why, and a number of people have said it, Dan and Vina in the earlier panel this morning, one of the reasons why Karl is the brilliant teacher, human being, organizer, is because he really, really values relationships. And he really is in touch. He knows what solidarity looks like. And it's not some abstract, as we've said before. It's very concrete. It's feeling comfortable in a space, a safe space, where you can talk about the things that are really on your mind. And he has really practiced that. He has really built huge networks. Think about all the networks we've heard about today, just today. And there are some I know we don't even know about. The international legal labor lawyers, the transformative constitutional, I mean, my God, the desire to build community, to build connection is just unstoppable. It's fantastic. And it is really what organizing means. And it is really what solidarity and community mean. So this really is a labor of love. It's a labor of love for all of us. A love of his ideas, of his humanity, of his connections, of his ability to want to reach out to others, to build organizations. I mean, CLS was a start. Look at these other connections that we're talking about today. So I'm just so thrilled to be here and to really be able to imagine through the many stories that we've heard today about really reinvigorating a sense of what might be possible. Thank you.
You were next. All right, I'll be next. I'll be next. I can say that Karl had a big influence on my trajectory and my work in law from when I started law school to now, which has been quite a while. It was 73 was when I was hired to be dean for the clinical program at Harvard Law School, so a long time ago. But in terms of critical legal studies, I was with others, much better read in political and educated in political philosophy, all kinds of things. But I was very excited to be part of the group that I think founded critical legal studies and at Harvard Law School. I think that we get some credit for that. And it was helpful to me in a personal way because when I got to law school and had my first year classes, I was completely unprepared for the teaching methodology, for everything about it. No one in my family had been a lawyer. I didn't know anyone who'd gone to law school. And I could not figure out what the hell was going on in the class. The state the case stuff. Like, I would listen to what they did, but I didn't really quite know what it meant to state the case, then distinguish the case. What else could it mean? I was more at home then. I was pretty good in English, lit, things like that. But I really couldn't make much sense of it. Eventually, it looked to me like the practice in rationalizing judgments where there's appellate precedent, and maybe you want the outcome to be different than the precedent. It seemed to be a revered thing in law, a kind of cathected item. To me, it just seemed a demonstration that language is very elastic, that a statement can mean more than one thing. So I kind of got that, but how would you use that? What different? And it looked like, you use that and that's the way you get what your client wants to go in a different direction. And I was disappointed because I thought that law school was going to be about the larger social picture. What was government doing? What should they be doing? What laws would help? I was a 67 graduate at University of Michigan, started law school in 67. So we're right in the middle of that period in the 60s where more progressive legislation was signed than at any other single period in the history of the country. So I thought law was going to be all about that. And then I run into this state the case in class after class. And I was pretty disappointed and thought I might have made a wrong decision. And what the hell was I going to do now? I did have a scholarship at the law school in those days. Tuition at Harvard was $7,000 when I went, and I had a full scholarship. Just think about that. So I knew I wouldn't quit, but I didn't really at that time know anything about what being a lawyer might be or what this intellectual program was. And so, time went by. I just thought I would have to swallow my disappointment and chug along, and then I'd figure out what to do afterwards. Initially thinking I'd probably go to a firm like everybody did, although that changed quickly, thanks to OEO, the Legal Services Program, and a program at Harvard Law School that after my first year, there were about 5 or 6 faculty who petitioned the Office of Economic Opportunity to start a poverty law program, and the demonstration project was, could law students make a contribution to getting legal services to people? So there were 4 or 5 faculty. I remember many of the names, but this was an OEO type program. It was not on campus. An office was opened in an apartment that had been empty down in the poorest neighborhood of Cambridge. And all of the criteria of the first OEO programs, maximum participation of the poor. So get in touch. There were tenant organizations. There was a lot of organizing at the time. So the clients were there, they were organized. And I started doing legal aid work. There were experienced lawyers who the grant had hired to supervise us. And so that resolved a lot about, I figured at least if I stuck with this, I would know something about practicing law. I'd learn some law, I'd know what it was, and I could probably get a job. And then it was after that, and I don't, Duncan probably knows the date, Karl does. I don't know where the meeting stopped, but this issue about critical legal studies came up. What if we did, if we made an intellectual exploration of the nature of law? I read it as nature of law and society. I was all for that. Sociology of law, the social sciences, where I thought what law would be about, anyway. And somewhere along the way, Duncan, there may be more people in the room. A thing came up about learning more about Marx's writing and thinking, and other faculty. I wasn't involved in the persuasion, but I signed up right away. Persuaded Karl to develop a learning program, a tutorial on a reading group. I think it was a reading group, and then we would have a discussion group, and we would have a discussion of the readings. And that went on for quite a while, a couple of years. And for me, it was, and I think for everyone in the group, but given what I didn't know about law practice, it solved a lot of things for me, because this is what I thought we'd be talking about. What's the role of law in society? It isn't, we're not talking physics, we're not talking chemistry. We're talking, how do we organize ourselves? How do we deal with different kinds of problems? Who benefits, who doesn't, all those things. And so political philosophy, sociology, all these things bear on that. And the Karl's organization of, I think we called it a Marxist study group, right? Yeah, Marxist study group. We weren't backing off anything. Ted Cruz, I hope he's not listening because he'll use this. And it was formative, I think, for all of us who started it or who participated, and it went on for several years. And more people around the law school, at the law school, joined, and so then you had more women. We had the issue of race came up, so there was both a fem crit and a race crit dimension to the project. And it was one of the most exciting learning experiences that I ever had. There was a lot to think about afterwards. In some ways, nothing was really solved, but the idea that you could explore these issues, discuss them, debate them in a setting where we're just trying to figure things out. And then I think it influenced everybody who participated in different ways. But it was like having a second shot at an educational experience. So that piece was central to everything that the opportunities that I had afterwards and that I did. By the time I was a 3L, I had so many cases at this legal aid office in the poorest neighborhood in Cambridge that they hired me as a supervisor. And then I started representing, Ed Brooke was the public housing programs around the country were New Deal programs, which means it had existed in the 30s and 40s, and they were running down, they needed repairs. And the rent formula was beginning to not fit. The New Deal program on public housing was that the government would do all the building, but the rent had to cover the operating costs. Well, in the 30s and 40s and maybe 50s, that was a pretty good formula, but it wasn't a good formula by the time you got to the 60s. There wasn't enough money. The rents had to go up and the buildings weren't in great shape. So there were a couple of organizers who came looking for me at the Clio, that was the name of the program, the Clio office. And it said, we hear you do housing work. And I said, yes, I do. And they said, okay, we've got a job. We want you to do this. And here's what we're going to do. Ed Brooke, who had just been elected senator, was on his way to being elected senator. Duncan reminded me today, a Black Republican senator from Massachusetts said he had a formula and he would get a bill passed that set rent at at no higher than a third of the tenant's income. So if you lived on AFDC and had almost no money, your rent, you could still afford public housing. And then they were going to get another bill that would send a lot of money to modernize, became the modernization program. And it all happened. It all happened. So legal aid lawyers are beating their heads against the wall now, but the experience at that time was I learned about a problem. There was a political support for the problem. The laws got passed. And then the issue was to simply make sure that the cities and towns who were using public housing, who built public housing and had public housing, administered the program correctly. That's no simple thing in a place like Boston, because there was a lot of corruption. There were the political machine. There were categories of working on the city. You could get a job in an elevator at the port, turning the handle. These were old-fashioned elevators that would get you up to the floors, and you would just sit there all day. And if you didn't show up, someone would come in. There were no-show jobs. So part of the deal was if you had these resources that were supposed to benefit the poor, you had to see that they got there, and that the minimum amount had been doled out to the politicians who'd probably been promised something to vote for the bill. It was also the case that you could get a lot. You could get a lot through the housing system if you could get the housing authority to skip the waiting list. There was a waiting list for public housing. And if you could get your grandmother in to jump the list, then you could get one of these good jobs. And that was just Boston politics. So I had at the same time this theory and really kind of rigorous education in the critical legal services studies project And I'm getting a street-wide how politics works in Boston. And at one point, I'd heard about someone who had done this. And I said, look, the biggest city that I'm around is Chicago. And in Chicago, if you did a favor like this, you'd get 3 times what you got here. So don't think that, you know, Boston is so special. But that climate was and probably still is part of this work. So in the critical legal studies piece, I don't think without it that I would have ended up doing the legal services work and then staying and doing the legal services work. And because I did that, I was invited to interview for the job of assistant dean, the first dean for clinical programs. I did get the job, and let me just tell you this. I ran across a copy of the Harvard Law School record that had the announcement that I had been hired as this dean. So on the left column is my name, hired as first woman dean. And the column on the other side was Sachs denies gender discrimination. So there I am on the front of the record, an example of how there's less gender discrimination. Now, what the school wanted was women in tenure track positions, but this was an administrative position. Part of this is simply, I think I would have stayed in law school because I'd started, and but if it hadn't been for the critical legal studies and the fact, the coincidence of that happening around the time that the legal services program in the country was beginning. This was the first government-funded legal services program that we had in the United States. So it's a little simple, but the takeaways for me over many years are a way of thinking in which you don't have to accept the way everything's structured as you find it. It really can be changed. It's not easy to change things, but they can be changed. Everybody knows in the United States that we don't have enough legal aid for everybody, and that we're different than every peer nation. Every peer nation has a guarantee of legal assistance for every low-income person who can't afford it, and some moderate income people with a small co-payment. So we're an outlier. We're an outlier in that area, and so the whole the role of the ideas about legal aid in the United States have been shaped by that difference, and in many places, people just don't know that peer nations, Canada, the UK, all the Scandinavian countries have what they call a Judicare program. It's like Medicare. You're guaranteed legal aid, and the private bar provides it. Private bar can participate in the legal aid program. They have to accept the fees that the government sets, but there are plenty of reasons why solo small firm attorneys might take some legal aid cases now and then, just like in Medicare and Medicaid. The story, there are pieces of the story that I'm going to try to get down and put in an article before I leave the law school or this world. But we're stuck in the United States. The thing that we want is what the OEO Legal Services Program had. Staffed programs devoted only to legal aid work. And we can't seem to, we're not going to get that, I don't think, not in the near future. And so the problem is that we need to think about other ways of doing things. And it brings me back to there must be a way to channel some of this stuff to take a different approach. I think we should have a Judicare program, but the Judicare program reminds people of not getting the LSC program. So I don't know that's going to go very far. But there, some of the other possible. There are. I'm sorry, I lost a little. I should have made more notes. Anyway, there are ways that we can work at. We can work on doing some other approaches, and we're at another point where we're stuck on a model and can't move off of it. Is the point? And there's will to get the job done, but we need some more imagination and some more experiments to go to get any further with it. So the story is really a simple one. I got to law school. I didn't know what I was doing there, except that I got in, and I'd taken classes. I'd taken calculus and first year chemistry and gotten good grades because I thought about going to med school. And then I told my counselor that I fainted when I saw blood, and they advised me away from medicine, although I think if I'd been a man, they wouldn't have. And that's how I ended up in law school, found my way, and probably would not have stayed but for the people in this room who did critical legal studies and were mentors and partners and helped me along the way. So that's a story.
This is when I planned what I was going to do, I didn't realize I'd go just a half an hour before the end of a long day. So we've been talking about how wonderful Karl is for 7.5 hours. But we're going to do it some more now. Why not for another half hour, right? One thing I want to start off by saying is that I had this fear. I was thrilled when Libby wrote to me and said that this event was going to happen. Absolutely thrilled. And then I had this fear that people were going to talk about Karl as though he was over or dead or something, right? And I was thinking I wanted to give a talk that would be, I wanted to give a talk about him as an alive presence. And I'm going to talk about one of his early articles in a second. But I realized that the fear that I had was completely ridiculous, right? And totally absurd. Since this morning at 9:30, we've been hearing about how the Karl Klare project is an ongoing project all over the fucking world. There are people who are engaged in the Karl Klare project, including Karl himself, right? And they're on the screen and they're here and there and they're coming out of the woodwork. And what was I thinking even, right? That I had to do the counter eulogy, right? And what an alive and dynamic project the Karl, that would be a good name for a band, the Karl Klare Project. But it's really continuing here. So I should really just stop there, but I'm not going to. So what I thought I would do was to talk about the piece of Karl Klare's scholarship that most influenced me. As Libby kindly said, I'm the first generation. You said I'm the first generation of the Titans. Yeah, okay. First generation of students after the sort of the second tier. So when I went to law school, I thought this is a ridiculous low-class intellectual thing. And I was really looking star for intellectuality. I'd been a philosophy major in college, And I went to see Duncan, and I walk out of Duncan's office, like many people did in those days, with a stack of articles. You couldn't see my head anymore because the articles were stacked so high. And Duncan used to do that in the old days. So one of the articles that influenced me the most was Karl's article, Lawmaking as Praxis. And I haven't heard it mentioned all day long. And if you haven't read this article, it really is, you should do it tonight. It's a brilliant, really just a brilliant piece of writing. And it was, for me, it was directly related to what I've been doing as a philosophy student. I've been spending thousands of hours reading Marx and Hegel in the Frankfurt School. And I read Karl's article and I thought, oh my God, here I am in this intellectual wasteland of law school, and I had no critical legal studies people in my first semester. We don't have to go into that, but and I thought, oh my God, this is just the next step, okay? And I wanted to talk about it for a minute. The thing I want to say about this article, I'm gonna give an ad for the article. It's a classic. It's short, which is really great. It's short and it's a classic. And what I mean by a classic is it's something worth reading and rereading and rereading and rereading, and it takes on new meaning over the years every time you read it. That's what makes something a classic. So when the sort of thoughts triggered by some of the things that Frank was saying on that panel this morning, that our current situation is not between a stuck formalism legitimating the status quo versus a little pragmatism versus left-wing revolutionaryism. The right wing is not legitimating the status quo. They're on the march. You talk about transformative constitutionalism. They're not status quoizing. They're on the march. They're the revolution. The right wing revolution is underway. We had it's really underway, and it's not going to stop yet. Maybe Justice Jackson will with Sonia Sotomayor, maybe the two of them together. But it's on the march. So we're in a different situation, say, than it was when Karl wrote this article. It's a very, very different situation. And when I reread the article, I've now reread it 3 times in the last few weeks, it has a completely different feel to it than when I read it. I must have read it in 1982, right? But here's the thing about it, and here's more ad for the article. It's fresh. It's fresh. You read it and you feel like this is something that somebody wrote last week. It's fresh. And the reason it's fresh is because the ideas are alive, but it's also the content of the ideas, the particular ideas. So there have been some big allusions, sinister allusions to Karl as a Marxist that Duncan talked about. And now Gene raised the specter and we're going to shut down the recording so nobody knows. Right. But this article is just amazing. What Karl does in this article, if you haven't read it, it's his absolutely brilliant taking of a few of the lessons of the early Marx, the young Marx, the Marx of 1844, 1845, that period, and adapting them, understanding them, adapting them, modifying them, and infusing his understanding of law with them. It's just an astonishing thing. And actually, I know I'm only supposed to speak for 10 minutes. And I know you're supposed to leave at 5:30, but we're now going to have a 2-hour seminar. I'll just stop for 10 minutes because I don't want to hog the time, but I'll just stop abruptly and brutally after 10 minutes. Okay, so just brilliant. And I want to start off with our panel is called Why Does Karl Start with a K? So I want to start with a quote from Karl. This is a quote from Karl. The coinciding of the changing of material conditions, on the one hand, and of human activity, distinctively human activity, in other words, self-transformation, on the other hand, can be conceived and rationally understood only as revolutionary praxis. That's from Karl Marx. It's the third thesis on Feuerbach, and Karl Klare's article, Lawmaking as Praxis, is a reading of the third thesis on Feuerbach in the context of law. The other thing from Marx is from the 1844 manuscripts, which Karl directly kicks in here, where Marx says, the alienation of the worker and his product means not only that his labor becomes an object, an external existence, but that it exists outside him independently as something alien to him. So this is the famous distinction, famous in certain restraint circles, between objectification and alienation. So Marx's thing is, to be human is to do stuff. Now, I've never done any stuff. I'm just an ivory tower academic theorist, but I happen to be sitting next to some people who've really done stuff, right? And so being a human is to do stuff, to do stuff in the world with objects, with material stuff, right? And what happens under conditions of social inequality and oppression, and especially capitalism, is the things that you do then work against you. They become alien to you and they work against you. The worker in the factory produces a product, and the product then is used to oppress him, and so forth. So although it's the product of the worker's free human activity, it then is alien and it works against him. Okay, and so those two theses, right, that changing of material conditions and self-transformation coincide, and that they only coincide well when it's revolutionary praxis, right? And that distinction between objectification and alienation, those are the key ideas from Marx that Karl Klare takes and applies to law. And it's not just an application. It's a brilliant insight, something that German guy, Marx, he never would have thought of this. Maybe he would have, right? But the reason why does this article feel fresh? Here's why the article feels fresh. First of all, it's brilliant, but also because the idea is fresh. The idea is you're constantly transforming yourself. That's the idea. It's an idea that people usually associate with existentialism, but it's really Marx was there long before. It's the idea that in working in the world, you're transforming yourself, and that can either be done in conditions of freedom, in which case you're transforming yourself in an emancipatory way, or into conditions of oppression, in which case you're constantly reinforcing your own oppression through your activity in the world. And so what Karl says, so this is the thing about law. That lawmaking, and this must be after the death struggle between Duncan and Karl over Marx. This must be post that, right? Because Karl says lawmaking is good. And he cites a lot of E.P. Thompson here, right? That lawmaking is part of the way we run society, we run our human relationships. But under conditions of capitalism, it becomes alienated from us, and then those rules come back to oppress us. And it's that paradox. It's something that should be good, and yet it's alienated. So Karl says, E.P. Thompson is famous for saying the rule of law is an unequivocal human good, which was always a source of much merriment when I was a law student. And Karl says he's right and wrong. He's right, it's a good thing, but he's wrong because not now. Not now. And the thing is to transform it in a way that our activity as lawyers, as judges, legal theorists, and so forth is no longer alienated from us, and then we can do it in freedom. It's just so brilliant. Jeez. And I have all kinds of quotes here. I'm not going to read all of them. So the judicial de-radicalization of the Wagner Act, which many of you have heard of, actually, it preceded this article. So this article that I'm talking about is really the theory of that article. Although the theory is also in that article. The judicial de-radicalization is the example of the way in which objectification turns into alienation. The Wagner Act is, at least in part, the objectification, the turning into a out there in the world thing by workers' struggles. And yet, because of living in an alienated capitalist society, it then gets flipped around from being good objectification into bad alienation, something that then comes back and flips around to oppress the workers. Now, So I just want to do this end quickly here. I want to quote this from the article. I want to quote two things from this article. One is this: the fact that we must live and work within alien institutions that we do not control, which do not permit us collectively to guide our own destiny, ought not prevent us from conceiving of our own participation in the legal process to the extent possible as an experiment in the possibility of our freedom. It's a brilliant thing, isn't it? Right? So it's now starting from the condition of alienation. The fact that we live in conditions of alienation shouldn't prevent us from imagining what it would be like if we were doing all this damn legal work, but doing it under conditions of freedom. So it's, again, treating the creative activity, the truly human activity, which is creation in the world, now looking at as the law person, and the person who's out there creating the worker who is producing things, and yet their product is being taken away from them, and they're alienated, using to oppress them, and the worker is imagining what it would be like if I could produce for myself under conditions of freedom. And I want, I got to read one more thing and then I'll stop. Here's, I just love this. From page 127. And it doesn't sound like something Karl would write today. The conception of freedom as the material and institutional arrangements permitting human self-actualization and self-expression. It's not just some Politico. Human self-actualization and self-expression, and of human right as the right to community. Okay, we all recognize that. And communal control of the destiny of the species to work as a mode of self-expression. And then here's, I love this. Indeed, the right to the emancipation of the senses. He might be quoting Perry Anderson there. The emancipation of the senses. So there is, in this conception, Karl, who's deeply involved with fighting social injustice, right? There's an unbelievable utopian, even messianic message here, looking towards the emancipation of the senses. I mean, in a way, that's a very 60s thing, but it's under conditions of freedom will be new people. And now I will read my last thing, which is that you read this article and it's an open-ended project, just like the Karl Klare project today. And this is the last thing I'll read and then I'll stop. This is the last lines of this article. Karl says, I plead guilty. Oh, very Karl-like, I plead guilty. No, but listen to this. He says this, I plead guilty to the charge of raising issues today while providing little guidance towards their resolution. That's the humility, right? Meanwhile, he's provided all kinds of ideas, right? But I'm deeply committed to the necessity of the inquiry. It's the open-endedness of it. That's why this article, written 40-something years ago, feels like it was written yesterday by somebody who's 22, because of its open-endedness. And this is, I think, the Karl Klare project today has that same feeling, open, what's the next thing? And then he quotes Lukács. As Lukács once wrote, we must, quote, we must be able to comprehend the present as becoming. Only he who is willing and whose mission it is to create the future can see the present in its concrete truth. Keep on envisioning the future, Karl. You're wonderful.
Thank you so much. Thank you for that, Nathaniel. I'll just start by saying that I feel especially lucky to be on this panel. I know that there are numerous people at the Legal Academy, a list too long, they go far beyond the people in this room and on video, that would have had the opportunity to celebrate would have loved to have the opportunity to celebrate Karl's work, his legacy, and his kindness. And I know this because long before I came to appreciate the influence that Karl's work would have on my own understanding of the law was my experience of joining Karl Klare's faculty. When I joined Northeastern in 2010, there was not a single conference that I went to, this is not an exaggeration at all, in which someone did not say to me, "Oh, you're new to Northeastern? Do you know Karl Klare?" And from those numerous people, I would hear things like, "He saved my career. He wrote me the tenure letter that changed my academic fate. The university didn't like radicals. He supported me with my struggle at the university." And I continue to hear these comments, even from my colleague at Irvine, who, when he saw the schedule for this event, said, "You were so lucky to be able to work with Karl Klare. I once turned down a job that would have led me to Northeastern, and I always regretted losing the opportunity to learn directly for him." And it's true, I do feel very lucky. I'm not going to look at Karl or I'll get teary. So I have so much to say, but for my time, I'd like to focus in on a strand of Karl's work that I've latched onto because it resonates with me, and it's kind of similar, I think, actually, to what Nathaniel was saying now. But I'm referring to Karl's call, not so much with a specific outline or proposal for reform, but rather Karl's feeling in his work, one that emerges repeatedly for a world that can be different and better. I first picked up on this theme in Karl's work when I read his article, Transformative Constitutionalism, with apologies for repetition from this morning. And as I understood it, transformative constitutionalism is doing the work of adjudication in political and historical context, and with a vision towards achieving a country's political and social goals of a democratic, participatory, and in an egalitarian direction. Karl makes explicit that for him, transformative constitutionalism is not a neutral concept, but one that is intended to connote a social good based on the assumption that egalitarian and social transformation is desirable. Though transformative constitutionalism was written in 1998, Karl's desire to write for a better world prevailed. The theme comes through as well in a 2015 article in the Stellenbosch Law Review, Self-Realization, Human Rights, and Separation of Powers, a democracy-seeking approach, in which Karl critiques the formalistic application of separation of powers discourse that he says is based on archaic spatial and territorial references that obscure the policy choices that judges make. Karl makes a call to see the idea of separation of powers moving towards a contribution to achieving fundamental values enshrined, in his case in the South African Constitution, to forward the project of nurturing human beings. And in 2020, in a recent blog post on the Law and Political Economy page, reproducing comments he made at the Jurisprudence of Distribution conference, that as an organizer, I was told repeatedly blew everyone away, Karl makes his call more explicit. In writing about socialism and critical legal theory, Karl notes that Marx, despite his recognition that economics was constructed, was a legal formalist. Then Karl breaks from Marx's legal formalism, as critical legal scholars often do, to engage the law as indeterminate. To understand the transformative possibilities of law, we should understand the interrogation and contestation over legal rules and practices. And Karl offers what we can take from interrogating ideas of socialism, coupled with the indeterminacy critique. He says, our goal should be more caring and solidaristic forms of social coordination that will enable us to treat other humans as moral agents entitled to respect self-determination rather than just as means to satisfy our ends. This entails providing people with the socioeconomic conditions necessary to authentically experience self-realization. This is not simply a question of ameliorating material inequality, maldistribution, and absolute deprivation, but of confronting and undoing the power relations that generate and entrench them. When one engages with a scholar's work, as I have with Karl's, you meet it where you are at the time. When I first read Transformative Constitutionalism 12 years ago, I was in a moment of life transition. I was new to the legal academy and transitioning out of my career in international law and development. When I began working in the world of development with international NGOs in the UN, I entered thinking that there was something to believe in about rule of law style projects. How could I not? I learned my entire life, often in very explicit terms related to legal reform, that my family's own economic stability took generations and legal reforms to achieve, from being, this is our community history, we don't have that much personal family history, but from being untouchables and low caste Hindus generations ago, to our conversion to Islam, becoming migrants within India, moving with the masses of the urban Muslim poor, and immigrants in the United States. It was a success story of law and development. My father's elementary school education had been paid for by a development organization. None of his other siblings were educated. His home required sharing an outhouse with some other 30 or 40 people. Yeah, I've actually been there. It was donated by our religious community. An internal modernization project specific to our Shia sect that, coupled with transformations in legal entitlements and around gender in India, led to girls being educated, and an intra-community edict not to veil, controversially, and immigration reforms in the United States that drew South Asian medical professionals in droves. Something you could call law and development, legal reform or legal transformation, was all over this: colonial governance, title transfers, sewage regulations, laws on conversion in India, gender transformations, US immigration reform, weren't we living proof that legal reform could work? But even as I entered international development, working and consulting with the UN and NGOs on issues of gender with the goal of continuing these legal reforms, so much of what I did bothered me. Even aside from feeling at times the absence of any sustained discussion on politics, context, and contingency uncomfortable, I couldn't sustain in myself the as-if way of being necessary to exist as an international development practitioner. How did so many people seem to believe that abstracted 10-point plans, let's say on enhancing capabilities through basic provisions coupled with formal legal reforms, without any real sustained understanding of context, would produce any predictable results? In the midst of my turnings, Karl's scholarship provided me a way forward. Given his characteristic humility, Karl did not propose to have an answer or a step-by-step approach to addressing the world's problems. Instead, as I read it, Karl's work makes room for the possibility of transformation while holding on to the idea that context and legal culture matters. He writes as a critique of the perception that old institutions can be replaced with new ones to bring social change. And this is Karl. Institutions, practices, and ways of life cannot simply be replaced. They must be reconstructed through countless, always provisional, local contestations. My first readings of Karl's work in 2010 stopped me in my tracks. Had I found it, a better way to hold on to something like hope and another world is possible while also believing in contingency and context? I wanted more. I read more Karl Klare. I sent it to my friends. Vina didn't mention that I sent her the Judicial Right Radicalization article in 2010. Our ladies' nights are super fun. Followed by citations. I followed Karl's citations. I read more critical legal studies in general. And finally, I started to understand theory, which felt inscrutable to me. And I realized that I had a new way forward and a new way to understand our world. And I thank Karl for that. Outside of the specific context that Karl writes in, his work remains for me integral to understanding our current moment. One could mobilize Karl's idea in a million ways, but in my world of scholarship, which deals with gender and law and health, Karl's trenchant critique of the ideas of separation of powers provides one example. Many of us, of course, are watching the Supreme Court as they're about to overturn Roe, and then perhaps with it in the coming years, the entire line of cases in the context of substantive due process. Even as gains were made on abortion access with key cases like Whole Women's Health and June Medical, where the court deployed a separation of powers analysis, taking back the ability to decide on questions of whether certain abortion restrictions were necessary, that they painted as medical uncertainty from the legislature. And they said, yes, we can actually review these questions. And side note, finally acknowledging that poverty matters, that it can't be dismissed as it had in earlier jurisprudence. It's all being undone again. Chief Justice Roberts expertly deploys separation of power analysis to disable the perception that courts shouldn't have a role in helping people access healthcare, whether in the context of reproductive health or COVID. The stakes are high. While many scholars will theorize and debate these decisions, from my perspective, there is no plausible reading of these cases and their deployment of separation of powers, except for Karl's understanding that separation of powers disguises policy choices. And here he argues separation of powers is not a unitary or coherent doctrine or a set of values that may be brought to bear on legal problems. Separation of powers is a cluster of disparate and sometimes conflicting values that reflect the distinct and not always harmonious theories of democracy. As my students hold their heads in their hands as they struggle to find the right balance between their own faith and legal rules and politics, I find myself reciting Karl's ideas to them. Can we look beyond what is presented to us as unitary, coherent doctrine? Look beyond seeing rules as distinct from their context and legal cultures? Can we begin to imagine a different type of society that emerges from transformations in our own political and legal culture while we hold on to the idea of contingency? Can we hold on to the idea of a better future? I'm so grateful to Karl for his ideas, his tools, his kindness, his generosity, for letting people as I did fail in my attempts to understand and explain them again over and over. But most of all, I'm grateful to Karl for modeling for me and so many others how to be good in this world.
Thank you to these wonderful panelists for bringing us home here. I want to wrap us up for the day. We're going to give Karl an opportunity to talk, so that's why I'm not going to do this, even though you're instructing me to. But I want to first just give a few thank yous. The organizers wanted to thank Jacob Bouvier and Brad Whitmarsh for all the tech support. We want to thank Miel Siobhan Fanning and Jennifer Giassi for all of the help planning and executing the whole plan here. For that. Thanks to all the wonderful panelists who zoomed in or traveled here, or did whatever you had to do to participate in the day. And let me say one more thing before I invite Karl up here. A few people have asked Jeremy and Lucy and me over the course of planning this, how we got Karl to agree to do this. And the answer is that we knew he wouldn't, so we did not give him the choice. You know, I assume the question comes from people being mindful of his sort of humble and self-effacing nature, and we were well aware of that. And so we went to his office and simply informed him that this was going to happen and that we would just contend with whatever confusing mix of gratitude and anger he felt toward us after that. So with that conclusion, I want to thank everyone again and invite Karl to come up here and cry in front of all of his friends and colleagues.
Well, I really am going to cry. So, it's overwhelming, your thoughts and feelings. And I'll do the best I can to get to through the next few minutes so that we can get to the drinks. I mostly want to give thanks and gratitude. I want to thank my colleagues, Libby, Jeremy, and Lucy for conceiving this day and organizing it so beautifully. They had the wisdom to scheme behind my back because I certainly would have put a stop to it, but I didn't know until it was too late. And even this traitor did not tell me. Again, a big shout out, please, everybody, for the people without whose hard work this never would have happened. So E.L. Marquis and Jennifer Giassi in Development and Alumni Affairs, Deborah Feldman, Siobhan Fanning in our Communications Department, and our intrepid tech geniuses, Brad Whitmarsh and Jacob Bouvier. Thanks to Thanks to Dean Hackney for his support, generosity, and leadership, and to all of the panelists for your energy and wonderful contributions. I should also say for somebody in my job, there is no greater honor than the recognition of the firms whose attorneys, including many NUSL graduates, daily fight on the front lines to protect and advance the rights of working people. And I'm humbled by the sponsorship of the 5 distinguished union side law firms that they provided for this event. Along my journey, I've had extraordinary mentors without whom I would never have become the educator or person I am, and I want to thank them. Duncan Kennedy, the intellectual giant and spiritual guru of the critical legal studies movement, devoted much of his life to modeling great mentorship. More than anyone else, he shaped me as a scholar and a teacher. In countless ways, Duncan also set an example of how to be an activist law professor, including his support for the Clerical and Technical Workers Union, for pay equity between professors and janitors, for rent control, for student protests, just to name a few. Duncan exemplified politicizing the classroom while delivering outstanding pedagogy. He has been a loyal friend, a go-to buddy through thick and thin. I give thanks for the great run that we've had causing good trouble together. Fred, where's Fred? Fred Block is my oldest friend and comrade, back to our days as Columbia undergraduates and members of SDS. We taught each other critical theory over a lifetime. Okay, we were nerds. Big excitement for us was when the latest issue of New Left Review showed up in the bookstore. But we kept up a vibrant and challenging conversation going on 60 years now about everything from the current political conjuncture to fundamental questions of method to intimate personal stuff. It is a fact, and I will say that undoubtedly Fred taught me more than I have. Through Fred, I met his partner and future wife, Karl Klare, a brilliant champion of reproductive rights, who has also become a lifelong intellectual companion and teacher. Two important mentors arrived later. Dennis Davis had no clue how he would change the course of my life and of my career by inviting me out to South Africa during the democratic transition in order to give a boring speech on American labor law. Dennis bravely defended democracy and racial justice during the dark days of apartheid. He was detained by the security police. And he went on to serve the New South Africa as a distinguished jurist and mentor to young lawyers and judges working to transform their country. He's been a wonderful teacher to me who has precipitated some of the most important and significant learning experiences I've ever had. I would never have written my South Africa articles without his guidance, encouragement, and partnership. And I've had the great fortune in life to cause good trouble with Dennis on several continents. I had taught at Northeastern for nearly 20 years before Lucy Williams joined our faculty. It's hard to imagine this place without her. Lucy's dad, a Baptist minister, braved death threats by preaching racial justice in East Texas in the 1950s. Lucy became a brilliant lawyer for poor people and victims of domestic violence, and later a gifted and beloved educator. She soon became another mentor and teacher to me and has been my steadfast partner in almost all of my projects in recent years, particularly Intel and ISERP that you heard discussed this morning. She's been a pal and an indispensable co-conspirator at Northeastern. She and her partner Faith were beloved friends to my partner Hallie. Legal education when I was a student at Harvard in the 1970s was repressive and dispiriting. I certainly would have quit had I not found and gravitated toward an extraordinary group of outsider professors. Besides Duncan, there was Gary Bello, whose name I want to mention today, Gene Charn, Morty Horowitz, Roberto Unger, and my beloved labor law professor, Bernard Dunow, who passed away during my 3L year. Under their spell, I germinated the wild and crazy idea that I could make a contribution to social justice by developing new forms of legal education aimed at training and empowering students to embark on careers as progressive and radical lawyers. I loved my years in labor practice, but in the end, I was unable to resist the call of academia. My most important expression of thanks today is for one of the great gifts of my life, Northeastern Law students. I am so happy to see so many of you here today. Other law schools count on their faculty to attract students. It is a well-known fact about Northeastern that the faculty come and they stay here because of our students. You challenge us, you let us know when we need to do better. You want to learn to become social justice lawyers. Then you go out into the world and you do amazing things with lasting impacts and reverberations on the lives of so many people. Look around this room and everywhere you will see people who work every day, rolling the stone up the hill to make the world a better place. If I can let myself think that I played even a tiny part indirectly in your achievements and impacts, I can go to my grave satisfied. So two concluding thoughts, please. Today, I thank you for enabling me to honor the memory of my parents, Mildred and Charlie Klare. I'm grateful to them for teaching my brother, sister, and me about social justice and for setting us on the right path. My parents had a special gift which allowed them to show me the way while at the same time trusting me to find it for myself. It is not as though we agreed on everything. Normal adolescent rebellions occurred over such momentous questions as the validity of Trotsky's French turn in 1934 and whether Bob Dylan betrayed folk music in 1965 by going electric at Newport. My parents believed that people, these were their fundamentals. This is what I got from them, that people must have the courage of their convictions, that silence in the face of injustice is complicity, and then decent people stand up to injustice, solidarize with the victims, and find ways to resist. To the best of my ability, I've tried to live my life faithful to those teachings. And finally, today, I remember Hallie Carmen, my partner of nearly 35 years. I loved her for the wonderful, beautiful, brave person she was. And as relevant to today's proceedings, I loved her. And I'm grateful for this opportunity to thank her for trying her best to keep me true to our shared principles. Thank you for everything today. And now I want to invite everybody to the reception. It's downstairs where we had lunch. And come, let's have a glass.